ಏನ್ ಫೈಲ್ ಇಡು ನೀವು ಫೈಲ್ ಇಟ್ಟಿರಿ ಇಲ್ಲ ಫೈಲೇ ಇಲ್ಲ ಅಂದ್ ನೋ ಪೇಪರ್ ಅಂತ ಹಾಕ್ಬಿಟ್ರ ಹಂಗೆ ಹೇಳಕತ್ತೀನಿ ನೀವು ತೆಗ್ಯದ ಅಲ್ಲ ನೋ ಪೇಪರ್ ಇಲ್ಲಿ ತಾನ ಫೈಲ್ ಕೊಟ್ರ ಮನೆಗೆ ಇವೆಲ್ಲ ಇಲ್ಲೇ ಇದಾವ ಈಗ ಇವೆಲ್ಲ ಬಿ ಗ್ರೂಪ್ ಮ್ಯಾಟ್ರ್ ಅದಾವ ಈಗ ನಾ ಅಂಕುಸ್ತಾಡ್ಬೇಕು
ಸರ್
ಒಂದೊಂದ್ಸರಿ ಬಾಳ ಹೈರಾಣ ಕೂತೀವಿ ಸಬ್ಜೆಕ್ಟ್ ಮಾಡಿದ್ರು ಅದ 1 2 ನೋಡ್ಬೇಕು
ಬರ್ತಾರೆ ಹೇಳ್ಬೇಕಾ
ಅದು ರೆಡಿ ಮಾಡಿ ತಂದು ತೋರಿಸ್ತೀನಿ ರೆಡಿ ಮಾಡ್ಯಾರ ಅಂತ ಒಂದ್ಸಲ ನೋಡ್ರಿ ಹೆಂಗಿತ್ತು ಹಂಗೆ ಹೌದು
ಎಲ್ದಿದಾರ ಮತ್ತೆ ಮುಂದಿನ ಮಂಗಳವಾರನೇ ಎಲ್ಲ ಆರಾಮ
ಮೆನ್ಷನ್ ಮಾಡ್ತೀನಿ ಬಿಡಿ
ಸರ್
ಹೇಳಿ ಮೇಡಮ್
ಫೈನಲ್ ಇದೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಿ
ನೀವೇ ಮಾಡ್ರಿ
ಅಲ್ಲಂದ್ರೆ
ತಗೊಳ್ರಿ
ನೀವು ತೋರಿಸಿ
ಹೇಳ್ರಿ ಮೇಡಮ್ ಈ ಕಡೆ ಬಿಜಿ ಇದೀನಿ
ಇಲ್ಲೊಂದಲ್ಲ ADLR ರಿಪೋರ್ಟ್ ಸರ್
ಇಲ್ಲ ಅವ್ರು ಬಂದಿಲ್ಲ ಇವತ್ತು
ಸರ್ ಇಲ್ಲೊಂದದ
ಪ್ಲೀಸ್ ಮೇಡಮ್
ಸರ್
ಒಂದ್ ಹೆಲ್ಪ್ ಮಾಡ್ರದು
ಹಾಗಾಗಿ ಇವೆಲ್ಲ
ಇಲ್ಲೊಂದದ ADLR ರಿಪೋರ್ಟ್
ಆಯ್ತು ನಾನು ಮ್ಯಾನೇಜ್ ಮಾಡ್ತೀನಿ
ನಮಗ್ ಕೊಟ್ರ ಬೇರೆ ಕೊಟ್ರ ಏನ್ ಇದೆ ಅದ
ನಮ್ಮನ್ನ ನಿಮ್ಗೆ ಹೇಳಿ ಕೇಸ್ ಇದೆ
ಇದೆಯೇನ್ರಿ
Fresh matter, my lord, tomorrow.
One service matter, your lordships. It is a B group category.
Kumar, can it not wait till the assigned day?
Again, it is on next Tuesday, my lord.
We have assigned some dates. If it can come on the assigned date, let it come. Unless you want it, it's very, 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 very urgent that it cannot wait till the assigned date. ಯಾವತ್ತು ಬರುತ್ತೋ ಅದು ಕೊಡಿ.
Service matter is assigned tomorrow, your lordships. The urgency is that your lordships salaries has been
tomorrow it will come on the assigned
tomorrow, your
dates.
lordships. And your lordships, one matter for urgency is that your lordships recovery notice has been issued. The matter is still pending consideration. A notice of recovery has been issued. I have filed application seeking stay of that taken up tomorrow.
One memo for withdrawal.
Serial number
10, man.
memo is filed by the land council for the petitioner to withdraw the writ petition. The memo is taken on record and the petition is dismissed as withdrawn.
Please.
Serial number
5 and 11.
5
5 and 11.
Learned counsel for the petitioner has filed a memo to withdraw the petition. The memo is taken the same order. 5 and 11.
Yes, my lord.
11 also same order.
Fresh street petitions, my lord.
Put it, it will come on the assigned days. Correct.
Serial number 43, my lords. I appear for respondent. Lords, the 2 weeks time may be granted, my lords. Settlement ಆಗ್ತಿದೆ.
ಆಗ್ತಿದ್ಯಾ?
ನಾನು ಅವ್ರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀನಿ ಸಿದ್ದಾಪುರ ಕಸ್ಟ್.
Learned counsel for the respondent. No? Learned counsel for proposed respondent.
Respondent.
Next time on the ground that the parties are working out a settlement. Hence list on.
It's after 2 weeks I need. Please.
Sir.
44,
Ah.
which time will be granted from documents to be produced.
ಯಾಕೆ ಶಿವಶಂಕರ್?
ಅದರಲ್ಲಿ ವರ್ಕ್ ಮ್ಯಾಟ್ರ್ ಇದೆ ಮಿಲಾಡ್, ಕೆಲವೊಂದು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅದರಲ್ಲಿಲ್ಲ.
KLR matter ಇದೆ ಇದು.
ಪ್ಲೀಸ್
It appears to be a KLR matter.
ವರ್ಕ್ ಮ್ಯಾಟ್ರ್ ಮಿಲಾಡ್ ಮರ್ಜ್
ಏನು ವಕ್ಫ್ ಅಂತ ತೋರಿಸಿದ್ರ ಕಾಲಮ್ 11 ಅಲ್ಲಿ?
ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ ಮಿಲಾಡ್, 86 ಅಲ್ಲಿ ರಿಜಿಸ್ಟರ್ ಇದೆ. ಪೊಸೆಷನ್ ಇಸ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಮುಂತಾವಲಿ
Yes,
ಇದ್ದಾರೆ.
it is shown.
ಅರ್ಲಿಯರ್ ಒಂದು ಮತ್ತೊಂದು ಅವ್ರದ್ದು ನಮ್ದು ಎಕ್ವೈರ್ ಆಗಿದೆ ಅಂತ ಕ್ಲೇಮ್, ಕೌಂಟರ್ ಕ್ಲೇಮ್ ಇದೆ ಸರ್ ಮಿಲಾಡ್. ಆಕ್ಚುಲಿ ಇಟ್ ಮ್ಯಾಟರ್ ಟು ಬಿ ಸೆಟಲ್ಡ್ ಅಟ್ ಬಿಫೋರ್ ಟ್ರಿಬ್ಯುನಲ್, ಬಟ್ ಇಲ್ಲಿ ರೆವೆನ್ಯೂ ಎಂಟ್ರಿ ಆಗಿದೆ ಮಿಲಾಡ್.
Learned counsel for the petition seeks time. ಯಾವತ್ತು ಬೇಕು? These are old matters. Please finish it.
Today, maybe afternoon today, I'm.
ಆಯ್ತು 2:30 ಮಾಡ್ತೀರಿ?
The one matter ಮುಗಿಸ್ಬೇಕು.
ಆಯ್ತು ಮುಗಿಸ್ಕೊಂಡ್ ಬನ್ನಿ ಅಂತ ಅಂದ್ರು.
Maybe after. Please.
Serial number 48, my lord. I am for petitioner, my lord.
ಹಾ
My lord, respondent herein filed objections, my lord. For that, I have to make some joinder of parties application, my lord. That's why 2 weeks time may be granted.
it's not joinder of parties, it is rejoinder.
Region, yes, sir.
Oh, not joinder of parties.
Sorry, my lord.
Learned counsel for the petition seeks time to file a rejoinder to the reply filed by the respondents. List on.
2 weeks may continue.
Hmm.
Much
Serial
obliged.
serial number 47, my lord. I am for the
Hmm.
petition. You take
ಯಾವಾಗ
next
ಈ ಹಳೆ ಕೇಸ್ಗಳಲ್ಲಿ ಯಾವ ಮುಗಿಸ್ಕೋತೀರಪ್ಪ ನೀವು?
one date. my lord.
Why you people? Learned counsel for the petition seeks time. List on.
Flash, my lord.
Serial number 64, my lord.
Hmm.
And for the petitioner, I seek one.
Learned counsel for the petition seeks time. List on so and so. Correct.
Serial number 71.
ಹಾ
2 weeks time.
ವೈ
ಬೆಂಗಳೂರಿನಿಂದ ಬರ್ಬೇಕು, ಅವ್ರ ಮಗನ್ ಮ್ಯಾರೇಜ್ ಇದೆ ಅಂತೇಳಿ.
ಯಾರು?
ಮಂಜುನಾಥ್ ಅಂತೇಳಿ. ಎಲ್ ಮಂಜುನಾಥ್.
Learned counsel for the petition seeks time. List on.
Please.
Tokmul.
Well, so page number 17, that is a sketch map I have produced, that is cut, that may be overall.
Office objection at serial number.
More. Page number 17, along with my salaried.
17, office objection. That page number 17 is
Okay.
not legible. You're not relying upon this document.
Yes, yes. Sketch.
Overruled by accepting the submission of the learned counsel for the petitioner. That he would not rely on this document.
Connected one more, man. Connected one more matter, 201117,
List this petition along with WP number.
201117.
Notice issue ಮಾಡ್ಬೋದಲ್ಲ?
Yes, kindly.
The AG is directed to accept notice for respondents. List this petition along with WP number sounds. Sachin Mahajan, 1 week time.
Yes. The petitioner, my lord, was not a party before the assistant commissioner, his mother was. In
Office
fact, the
objection.
death of the mother was reported before the assistant commissioner, yet, my lord, no steps were taken to.
Office objection is number 23. He is overruled by accepting the submission of the learned counsel for the petitioner. ಏನ್ case
On
ಏನ್-
matters, on merits, my lord, I must begin by submitting that Ashok versus Pandurang ILR 2012, my lord, where order passed by the assistant commissioner is required to be necessarily challenged in revision before the deputy commissioner.
Hmm.
The only exception, my lord, that is tried to be drawn by the petitioner herein,
You challenge the
that-
order passed by the assistant commissioner.
it is an order passed by the assistant.
Then go before the deputy.
I make only one submission, that exception that is, my lord, sought to be carved out. Is, my lord, there was already a writ petition, my lord, in which this honorable court, my lord, passed an order that your revenue entries will be subject to the result of, my lord, the civil suit. Suit is decreed, my lord, for partition and separate possession. Nevertheless, my lord, there is no final decree, my lord, proceedings have taken place. There is no carving of share by meets and bounds. In the meanwhile, the lady who had filed that writ petition, who took that order, my lord, that there shall not be any change in entries, she, my lord, executes 2 sale deeds. Mutations are effect, my lord. In that proceedings, my lord, the matter went before the revenue, my lord, authorities in the, that becomes a ground again, my lord, for revision. My lord, ಸುತ್ತಿ ಬಳದು ಅಲ್ಲೇ ಬರುತ್ತೆ ತಿರ್ಗ. Record me, submission may kindly be recorded, my lord.
AG is directed to accept. AG is directed to accept notice for the respondents 1 to 5. Notice to the other respondents is dispensed as the petition is taken up for disposal. Next para. The petitioner has filed this writ petition challenging an order dated so and so, bearing number so and so, passed by the respondent number 2, by which the revenue entries were,
My lord,
by which the revenue entries were changed.
by which, my lord, revenue entries are changed. In the name of, my lord, the purchasers. Page
By
number
which the
74,
revenue-
my lord.
By which the revenue entries in respect of land bearing survey number
157 bar star bar
B
2. 157 bar star bar 3, 180 bar star bar 1, 180 bar star bar 7.
of Hirediddin village, Manvi Taluka, Raichur district were transferred to the purchasers. Full stop. Next para. The petitioner contends that a suit in OS number 54/2007 was filed for partition and separate possession by respondent number 16 and 17 against Srimati Ayyamma and others concerning survey number 157 bar B, 180 bar B of Hirediddin village. Full stop. An additional relief was also sought for to declare a gift deed bearing number 3068/2005-2006 as null and void. Full stop. The said suit after contest was decreed on 27/8/2012. And final decree proceedings is yet to begin. Full stop. When things stood thus, comma, one of the defendants in OS number 54 of 2007 filed WP number 204641/2014 against Dodda Yellappa and others, challenging an order dated 23/8/2013 passed by the respondent number 2, by the Deputy Commissioner Raichur in revision petition 23 of 2009 on the ground that the said order was passed without considering the decree passed in OS 54 of 2007. Full stop. This court, in terms of the order dated 3/4/2017, allowed the writ petition and held that the revenue courts are bound by the decree passed in OS number 54/2007. Nonetheless, comma, the respondent number, nonetheless, the said defendant executed 2 sale deeds dated 27/4/2015 Two sale deeds, both dated 27/4/2015. Encumbering survey number 157/2 in two portions. Full stop. The respondent number 18 herein filed RRT appeal 6/2023 before the respondent number 2 under section 136/2 of the Karnataka Land Revenue Act, challenging the mutation brought about in respect of the aforesaid survey numbers. Full stop. It was brought to the notice of the respondent number 2 that by virtue of this decree in OS number 57 of 2007, and the order passed by this court in WP number 204641 of 2014, the revenue courts are bound by the decree, and any mutation in favor of respondent number 12, 14 and 15 herein are illegal. Full stop. The assistant commission, the respondent number 2 passed the impugned order setting aside the mutation and directed the name of respondent number 18 to be entered in the revenue records in respect of her share. Full stop. The petitioner contends that this has caused serious prejudice to him as his rights are impaired. Full stop. The petitioner is therefore before this court challenging the order passed by the respondent number 2. The learned counsel for the petitioner reiterated the above contentions and contended that once the civil court had passed a preliminary decree of partition, there is no question of any of the defendants in the suit encumbering the property, and therefore the entries made by the respondent number 2 in the name of the respondent number 18 is improper and deserves to be interfered with. Per contra, the learned AGA submits that the petitioner is not a party to the proceedings before the respondent number 2 and has filed this petition challenging the said order. He submits that by virtue of the judgment of the full bench of this court in
Ashok versus Panduranga, my lord.
Ashok versus Panduranga as well as Murugarajendra Math, the petitioner is bound to challenge the order of the assistant commissioner before the deputy commissioner in a revision petition under section 136(3) of the Karnataka Land Revenue Act. Full stop. Next paragraph. Consider submissions of the learned counsel for the petitioner and the learned AGA. Next paragraph. The petitioner is admittedly not a party to the proceedings before the respondent number 2. Full stop. However, he has challenged the order of the respondent number 2 in view of a mutation which is ordered to be accepted to enter the name of the respondent number 18 herein in the revenue records. Full stop. No doubt, the respondent number 2 must have directed that the entries in the revenue records shall be made following final decree proceedings that may be initiated pursuant to the preliminary decree passed in OS number so and so. However, the respondent number 2, instead of doing so, has directed the revenue records to be entered in the name of the respondent number 18 herein. Full stop. In view of the judgment of the division bench of this court as well as the full bench judgment of this court, in the judgments referred supra, the appropriate remedy for the petitioner is to file a revision petition under section 136(3) of the Karnataka Land Revenue Act. Therefore, this petition is disposed of, reserving liberty to the petitioner to challenge the order passed by the respondent number 2 in a appropriate revision petition filed under section 136(3) of the Karnataka Land Revenue Act before the Deputy Commissioner. Yes, next. ಜಯಮ್ಮ ಅಲ್ರಿ ಅದ್ ಯಾವ್ದು ಹೇಳ್ತೀರಿ ಹೇಳಿ ಪಾಂಡುರಂಗ ಮತ್ತೆ ಯಾವ್ದು ಕೊಡ್ತಿದ್ರಿ ಫುಲ್ ಬೆಂಚ್ ಅಂದ್ರೆ ಇದ್ರದ್ದು ಮುರುಘರಾಜೇಂದ್ರ ಅಂತ ಇದೆ ನೋಡಿ.
Ashok versus Pandurang is also my lord full bench.
My lord, a week's time may be granted for compliance. My lord.
1 week.
1 week.
1 week time is granted to do the needful. Mr. B.A. Ramakrishna. 1 week time is granted to do the needful. 5 withdraw. 1 week, huh?
Yes.
1 week. 6 1 week. 7 1 week. 8 1 week. 9 1 week. 10 1 week, failing which petition shall stand dismissed without reference to bench.
ಇಲ್ಲ 10, 11 withdrawn.
ಎಲ್ಲ withdraw ಆಗಿದೆಯಾ? 10 11
10,
12
11 withdrawn.
12 1 week, failing which the petition shall stand dismissed without reference to bench.
A week's
Count
time,
17.
a week's time, Lord, counterpart is looking after this matter. Lord,
ಅಲ್ಲ but 2017 the pending ಇದೆಯಾ?
17 matter, my Lord, correct address of the respondent 10 and 11, who are, my Lord, subsequently added to the writ petition. So, my Lord, I have to ascertain
They are purchasers.
purchasers.
Why?
Yes,
Why were they necessary parties?
Lord, it is a matter, my Lord, before pending before the land tribunal, Vijaypur
With the Form 7.
House.
Form
Excess
7 ಯಾಕ್
land.
ಬೇಕಿತ್ತು?
ಅಲ್ಲ ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಎಕ್ಸೆಸ್ ಲ್ಯಾಂಡ್ ಐ ಆಮ್ ಸಾರಿ
Excess land.
Excess land.
ಎಕ್ಸೆಸ್
10 and 11 are purchasers.
10 and 11.
1 week time is granted to do the needful. As a last chance, 1 week time is granted
Obliged.
to do the needful. Failing which the petition against 1 week Saka,
1 week.
failing which the petition against respondent number 10 and 11 shall stand dismissed without
Much,
dismissed.
please.
There are many objections. I'll comply, my lord, a week's time. Apart from taking steps,
ಏನು substituted service ಏನು?
substitute service in respect of 4A and B, my lord. Anyhow,
There's some order on 39
Yes, yes.
to reissue.
yes, ma'am,
ಯಾಕ್ ಮಾಡಿಲ್ಲ ನೀವು?
39 to the, yes.
There's an order on 39
I'll,
2024.
for a moment, I'll not press substituted service.
Learned
I'll
counsel
take.
for the petitioner does not press IA 6 of 2024. Hence the same is rejected. What about non-amendment of cost title?
I'll carry out during.
Learned counsel for the petitioner has amended the cost title to include the LRs for
R5D.
purchased R5D and R6A.
60.
Non-filing of death certificate.
Death certificate.
Number code. The office objections regarding non-filing of death certificate in support of IA 1 of 24 to 3 of 24 and 4 of 24 to 5 of 24 is overruled. Issue notice on IA 1 of 24 to 3 of 24 and IA 4 of 24 to 5 of 24. ಇದು ನೋಟಿಸ್ ಆಗಿದೆಯಲ್ಲ?
Notice ಆಗಿದೆ.
On LR's application, notice is already issued. I have to take steps.
ಇದು office objection is overruled regarding death certificate. Issue notice ಬೇಡ. 1 week time is granted to pay the process to issue notice to the unserved respondents. Failing which, the petition against them shall stand dismissed. Yes.
Please.
Parasaka?
Yes, yes,
No about ಮಾಡಿ ಅದು.
please.
Non-compliance of office objection raised on memo dated as master applicable condition. Yes.
Respondent has filed the memo.
Huh?
Respondent has filed the memo.
Filed a memo that, R2 died and these are the LRs on.
No, but.
Respondent has filed the memo. Respondent has filed the memo.
But.
Respondent has filed the memo.
But What memo have you filed?
Reporting the LRs of respondent, deceased respondent number 2, my lord.
The memo million the objection. With Berkeley office objections raised on the memo dated 14/6/2024 is overruled. Counsel for the petitioner is directed to take necessary steps to bring the legal heirs of deceased respondent number
2.
within how many days? She is given the LRs also.
Lordship, these are not the LRs. How they, once they have said that, Lordship, LRs are already on record.
ಏನ ಇವಾಗ ಮೆಮೊ ಹಾಕಿದಾರಲ್ಲ ಫೈಲ್ ನೆಸೆಸರಿ ಅಪ್ಲಿಕೇಶನ್ ಮೆಮೊ ಹಾಕಿದಾರಲ್ವಾ?
I'll verify, Lordship, because how they are related.
The learned counsel for the petitioner is directed to verify whether the parties mentioned in the memo filed by the respondents are to be brought on record as LRs of R2. Yes. If yes, to take necessary steps to bring them on record.
Please.
For petitioner, my lord. Kindly week's time may be granted. I will take
Pay the
steps.
process today, madam.
Much.
ಇವತ್ತೇ ಕಟ್ಬಿಡಿ
Yes, ma'am.
ಪಾಸ್ವರ್ಡ್
Much.
ಕಟ್ತೀರಾ ಅಥವಾ ಬರ್ಕೊಂಬಿಡ್ಲಾ ಕಟ್ತೀರಾ ಅಂತ?
ಕಟ್ತೀವಿ ಅಂತ ಬರ್ಕೊಂಡು.
Learned counsel for the petitioner undertakes to pay the process during the course of the day. The process is paid, office is directed to issue notice to R6.
Much.
17, same order.
Please,
Pay the process today.
please, today only I will pay them.
18,
Same, my lord, maybe.
ಇದೇಂತ ತಿರ್ಗಾ ಡಿಸ್ಮಿಸ್ ಆಗುತ್ತೆ ಅಂತ ಲಾಸ್ಟ್ ಟೈಮೇ ಮಾಡಿತ್ತು 2004 ಅಲ್ಲಿ ಅಲ್ಲ 2000 ಜುಲೈ 2024 ಅಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಫಾರ್ ನಾನ್ ಪ್ರಾಸೆಸ್. ಪಾಸ್ ಓವರ್.
Please,
ಪೇ ದ ಪ್ರೋಸೆಸ್,
please, madam.
ಎನ್ಶೋರ್ ದಟ್ ಇಟ್ ಇಸ್ ಇನ್ ಆರ್ಡರ್.
Please, madam, I will,
ಆಮೇಲೆ ಪ್ರೋಸೆಸ್ ರಿಟರ್ನ್ ಆದ್ರೆ ಐ ವಿಲ್ ಡಿಸ್ಮಿಸ್ ದ ಪಿಟಿಷನ್.
I will, today only.
Yes.
During the course of the day, we'll furnish. the-
Learned counsel for the petitioner seeks time to undertakes to attend to the office objections during the course of the day.
Please, madam.
If office objections are not complied, the petition shall stand dismissed without reference to bench.
Same, madam.
Pass over.
Please, madam.
Inamdar. Dismissal. of-
Comply the all office objections, Your Honor.
Huh?
Comply ಆಗಿದೆ sir. Dismiss for non prosecution ಆಗಿತ್ತು, restore ಆಗಿದೆ.
When did you comply, madam? When did you come? ಯಾವ ಕಂಪ್ಲೈ ಯಾವಾಗ ಮಾಡಿದ್ರಿ? Pass over, note.
Yes.
Notice to respondent, notice issued to the respondent number 6 and 23 is refused. Hence, notice to the said respondents is held sufficient. 1 week time is granted to pay process to issue notice to the unserved respondents.
Yes. Obliged.
ಕಟ್ಬಿಡ್ರಿ process.
Please.
Correct time.
Address correct ಆಗಿಲ್ಲ ಅಂತ reach ಆಗ್ತಿಲ್ಲ, my lord.
ಏನ್ ಮಾಡ್ತೀರಾ? 1 week.
I will pay process, my lord. If not, sir, I will take
But
public
correct,
notification.
give the correct address also.
Please, ma'am.
1 week,
Please, ma'am.
failing which the petition shall stand dismissed. Huh?
Please,
1 week ಸಾಕಾ?
1 week, sir.
Next.
Only 2 days time will be granted, madam.
Pay the process today, Mr.
More.
Huh?
More process ಅಲ್ಲಿ ಕೊಡ್ತಾ ಇದ್ದೀವಿ. 2 days kindly to.
1 week
Please.
time is granted to do
Obliged,
the
madam.
needful.
No. 1 week time.
1 week time is granted to do the needful.
For petitioner, my lord.
Hmm.
The petitioner are before the honorable court seeking the relief of mandamus in respect of land utilized for the purpose of National Highway and Service Road.
My lord, additional ADLR report file
Report.
ಮಾಡ್ಬೇಕಾಗಿತ್ತು.
Yes, sir. That is pending. ನಿಮಗೆ
The ADLR report, government advocate.
Your Lordship, that report is not yet received. Short date may be given.
How many times we should give the?
Yes, Your Lordship, but I already communicated 2 times, but still I am not.
No, how many dates should we give, madam?
Last chance maybe.
Two thousand twenty-two is the order.
Yes, your lordship.
We are in 2025.
So many times communicated, your lordship. Last chance may be given.
Then we'll issue a warrant.
No, one more chance. I will.
Yavatu,
First or second.
list on 1st February. ಯಾವತ್ತು ಬರುತ್ತೆ ಲಿಸ್ಟ್ ಆನ್ ಶನಿವಾರ ಅಲ್ವಾ ಫಸ್ಟ್
First.
Publish.
learned HCGP seeks time list on first as a last.
Please.
26.
26, my lord. During the pendency of this writ petition, petitioner is passed away, leaving behind 2 sons. Application is ready, my lord. By tomorrow I will file it.
Learned counsel for the petitioner seeks time to file an application to bring the legal heirs of deceased petitioner. List after the same is done.
Lord, there is interim order.
Interim order granted early is extended till the
Great.
list on date could.
Please.
Interim order granted early is extended to the next date.
Great.
Filing objection. I appear for the petitioner in this case, Your Lordship. Respondent number 5 took time to file objections, Your Lordship.
Yes.
Objection 5.
ಕಾಪಿ ಕೊಟ್ಟಿದ್ರಿ ಅವ್ರಿಗೆ
ಅವರಿಗೆ ಥ್ರೂ ವಾಟ್ಸ್ಆಪ್ ಸರ್ವ್ ಮಾಡಿದೀವಿ ಇಲ್ಲಿ
ವಾಟ್ಸ್ಆಪ್ ಅಲ್ಲಿ ಸರ್ವ್
ಇವರಿಗೆ ಫಿಸಿಕಲಿ ಸರ್ವ್ ಮಾಡಿದೀವಿ ಸರ್.
ನಮಗ್
ಎಲ್ಲ ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ ವಾಟ್ಸ್ಆಪ್ ಅಲ್ಲಿ. ಅವ್ರ ಕಡೆಯಿಂದ ಯಾರು ನಮಗೆ ನಂಬರ್ ಕೊಟ್ಟಿದ್ರು ಅವರಿಗೆ ಕ್ಲರ್ಕ್ ಅಂತ ನಂಬರ್
ನವೀನ್ ನಂಬರ್ ಇಸ್ಕೊಂಡು ಕಳಿಸ್ರಿ
ಪ್ಲೀಸ್.
ಟೇಕ್
ದಯಾನಂದ್ ಅಂತ ಅವ್ರ ನಂಬರ್ ಕೊಟ್ಟಿದ್ರು ಅವ್ರಿಗೆ ಕೊಟ್ಟು.
ನವೀನ್ you just pass on your number to Gaurish.
ಪ್ಲೀಸ್ ಐ ವಿಲ್
ನಂಬರ್ ಹೇಳಿ
9900
9900
177
177
656.
656.
Okay.
9900 177 656.
Please. 9900 177 656. Correct.
Next week, kindly one date.
Pardon?
I am appearing for respondent number 4.
You are for
Yeah,
respond number
4.
4.
Did-
What do you
did it-
want?
Senior counsel work. Next week, one particular date.
Learned counsel for the respond number 4. The learned counsel for the respond number 5 has filed the statement of objections. However, the learned counsel for the petitioner submits that he has not received a copy. Hence, the learned counsel for the respond number 5 is directed to serve a copy of the statement of objections to the learned counsel for the petitioner. Next para. The learned counsel for the respond number 4 seeks time. Hence, list on Yavat.
Date. 4. Please.
So interim order to be continued.
Interim order granted early is extended till the next date of hearing.
Please.
Kindly pass over my lord.
Yar, who is the answering respondent?
Respondent number 9 to 12 I am appearing, my lord.
Who is the answering respondent?
R6.
Kumar Mali
Patil, Housing Board.
Shivkumar Malipatil.
Yes, R6.
ಬಂದಿದಾರಾ?
Last time ತಗೊಂಡಿದ್ದಾರೆ.
ಅಲ್ಲ ಇವತ್ತು ಬಂದಿದಾರಾ ಅಂದೆ? Has he come? Mr. Shivkumar Mali Patil.
I have also to be filed objection, my lord.
ನೀವ್ ಯಾರಿಗೆ?
My respondent number 9 to 12, my lord. I have the purchaser of the land in question, the sites in question, my lord. They have sought for interim order against me.
The learned counsel for the respondents 9 to 12. You are the answering. You are also answering respondent.
Not the, my lord, the responsible actually, my lord. They are unnecessary made as a party and also sought for interim order against our plots, my lord.
Housing Board not at site to this.
2014, 10 I am.
What is challenged in the petition?
This petition, they sought for compensation, my lord. Encroachment is done by the Housing Board. They sought for compensation, my lord.
No,
And
this
also
is
they
regarding
want
that area which they have encroached. KHP had encroached that particular area. Is that the same case?
their case,
With
my lord.
regard to 6 quotas, there is an encroachment.
ಮತ್ತೆ?
Here, my lord, it is another, my lord, petitioner is, my lord, claiming his survey number was totally blocked by the internal approaching road. A triangle shape ಅಲ್ಲಿ ಇರೋದು.
No, that man doesn't have an access to his property.
Yes, my lord. ಅದು ಪ್ಲಾನ್ ಮತ್ತೆ ಸರ್ವೆ ಮಾಡಿಸಿದೆ. ಕೋರ್ಟ್ ಆದೇಶದ ಮೇಲೆ ಸರ್ವೆ ಆಗಿದೆ. ಆ ಸರ್ವೆ ನಲ್ಲಿ ಇವ್ರ ಸರ್ವೆ ನಂಬರ್ ಬ್ಲಾಕ್ ಆಗಿದೆ ಅಂತ ಬಂದಿದೆ ರಿಪೋರ್ಟ್.
But report copy has not been submitted to me, my lord. My lord. Even twice I have asked to the my lord.
Non-counsel for the response 9 to 12 seeks time to file objections. Hence list on ಯಾವ
ಪಾಸ್ ಓವರ್ my lord.
Yes, my lord.
ಅವ್ರೇನು objection ಹಾಕ್ಬೇಕಂತಾರೆ ಶರಣ್ ಬಸಪ್ಪ.
ಇಲ್ಲ objection ಏನು ಕ್ಲಿಯರ್ ಇದೆ ಸ್ವಾಮಿ. ಅವ್ರು ಇವ್ರು they are the my lord, they are the allottees of two sides where.
ಏನಾಗ್ಬೇಕು? Will they be affected or not?
Yes, my
Whether
lord.
the respondents 9 to 12 will be affected by any order that is going to be passed in the petition. Suppose if you say, let the housing board set apart one site for access.
My lord, here there is a earlier bench, my lord, directed to see the alternative sites so for accommodating these persons to open this internal road.
No, why should the entire line of sites be removed? One site
ಅದೇ ಒಂದೇ ಅವ್ರು ಕೇಳ್ತಾ ಇರೋದು ಒಂದೇ ಸ್ವಾಮಿ.
one site ತೆಗೆದುಕೊಟ್ರೆ ನಿಮಗೆ ದಾರಿ ಸಿಗುತ್ತೆ.
ಅಷ್ಟಾಗತ್ತೆ ಅವ್ರಿಗೆ ಅಷ್ಟು ಜಾರಿ ಸಿಗುತ್ತೆ. ಅಷ್ಟು ಮಾಡ್ಬಿಟ್ರೆ ಮ್ಯಾಟ್ರಿ ಎಂಡ್ ಆಗುತ್ತೆ. ಅದು ಹೌಸಿಂಗ್ ಬೋರ್ಡ್ ಅವ್ರು ಹೇಳ್ಬೇಕು ಸ್ವಾಮಿ.
ಸೊ ಅದಕ್ಕೆ ಎಲ್ಲಿ
ಕುಮಾರ್ ಮಾಲಿ ಪಾಟೀಲ್ ಇದ್ದಾರೆ. ಲಾಸ್ಟ್ ಡೇಟಿಗೆ ಅದನ್ನೇ ಇದು ಮ್ಯಾಪ್ ಕೊಟ್ಟಿಲ್ಲ.
ಇವ್ರಿಗೆ ಪಿಟಿಷನರ್ ಇಲ್ಲಿಂದ ದಾರಿ ಇಲ್ವಾ?
ಎಲ್ಲಿ ಇಲ್ಲ.
ಬೇರೆ ಕಡೆ ದಾರಿ ಇದೆ.
ಬ್ಲಾಕ್.
ಬೇರೆ ಕಡೆ ದಾರಿ ಇದೆ. ಅವರು ಇವನ್ ಆರ್ಚ್ ಮಾಡಿದ್ದಾರೆ.
ಬೇರೆ ಕಡೆ ದಾರಿ ಇರೋದು ಬೇರೆ. ಇವ್ರ ಸರ್ವೆ ನಂಬರಿಗೆ ಕನೆಕ್ಟ್ ಇಲ್ಲ. ರಿಪೋರ್ಟ್ ಇದೆ. ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ ಈ ಸರ್ವೆ ನಂಬರಿಗೆ 26/1, 26/2 ಇದಕ್ಕೆ ಎಲ್ಲಿನೂ ಕನೆಕ್ಷನ್ ಇಲ್ಲ. ಇಲ್ಲಿ
ನೀವ್ಯಾರಿಗೆ?
I am for Kalaburagi Urban Development Authority. I am submitting the facts, my lord.
No, that is right, but how do you say that this land doesn't have any access?
Yes, but it is.
On what basis are you saying?
Report ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇದನ್ನೇ ಕಂಡು ಹಿಡಿಯಕ್ಕೆ
ಕೊಟ್ಟಿರೋದು.
ಕೋರ್ಟ್ ಕಾಪಿನೇ ನಮಗೆ ಕೊಟ್ಟಿಲ್ಲ. Twice I have asked for report, my lord.
A ರಸ್ತೆ ಮತ್ತು B ರಸ್ತೆ item number 5 and 6. Item number A.
Petitioner is the owner of 26/5 or 26/4.
My lord, 26/5.
Petitioner owner of 26/5.
Yes, my lord. 4 and 5 ಎರಡು ಇದೆ. ಎರಡರದು ಒರಿಜಿನಲ್ ಅವರೇ ಓನರ್ ಇದ್ದಾರೆ. 3 acres ಸಮ 8 ಗುಂಟೆನೇ ಇದೆ.
Petitioner seems to be the owner of 26/2, 3.
ಅವೆಲ್ಲ ಅಕ್ವೈರ್ ಆಗಿದೆ. 26/2, 3 ಅದು ಅಕ್ವೈರ್ ಆಗಿ ಉಳಿದಿರೋ ಪೋರ್ಷನ್ ಈ ಕಡೆದು ಸೌದರ್ನ್ ಪೋರ್ಷನ್ ಅಕ್ವೈರ್ ಮಾಡಿ ಮತ್ತೆ ಒಂದ್ ಸ್ವಲ್ಪ ಎಡ್ಜಿಗೆ ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಇದೆ. ಆ ರೆಡ್ ಕಲರ್ ಅಲ್ಲಿ ತೋರಿಸಿದ್ದು ಆಲ್ ಅಲಾಂಗ್ 6 ಗುಂಟಾಸ್.
Sir, map, my lord, it affects all the sites, my lord, not only to the, my lord, to the sites of the respond number 9 to 12.
No, it will not affect all the
ಇಲ್ಲ,
sites.
ಇಲ್ಲ, red color mark, you.
ಅದು ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ is separate.
Encroachment is
It
red
is
color
with,
mark, my lord.
it is with regard to the housing board. That red color encroachment insofar as it is concerned between the petitioner and the housing board. They have made the layout, they have handed over the sites to the allottees. Here, my lord, yellow color A road and B road, they are blocked. Site ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ. ಅದರಲ್ಲಿ ಯಾವ್ದಾದ್ರು ಒಂದು ಓಪನ್ ಬಿ ಓಪನ್.
But it site ಮಾಡದೇ ಇದ್ರೆ then you will get this excess land. What should happen to that excess land? Site ಮಾಡದೇ ಇದ್ರೆ.
ಇವ್ರಿಗೆ ಇದನ್ನು ರೆಸಿಡೆನ್ಸಿಯಲ್ ಅಂತೆ ರಿಸರ್ವ್ ಇದೆ ಏರಿಯಾ.
No, the area marked in red.
Yes, my lord.
That is the area which is encroached.
That is encroached of.
So the area marked in blue,
My lord.
is the area which belongs to the housing board.
Yes, my lord.
So a housing board has formed the sites, including a portion of survey number 26/3, 5, 4 and 5.
ಹೌದು.
So that red portion is about 6 guntas.
Only 6 ಗುಂಟ.
So therefore we can ask him to provide some road margin either in This
ಹಾ,
kind,
ಅದು ಕಂಪನ್ಸೇಟ್ ಮಾಡಿ 6 ಗುಂಟೆ ಕಂಪನ್ಸೇಟ್ ಮಾಡಿ ರೋಡ್ ಓಪನ್ ಬಿಟ್ರು ದಟ್ ಕ್ಯಾನ್ ಆಲ್ಸೋ ಬಿ ಮೆಲಾಡ್ ಸರ್ವ್ ದಿ ಪರ್ಪಸ್. ಒಂದ್ ಬಿ ಏನ್ ಪ್ರಾಜೆಕ್ಟ್ ಆಗುತ್ತೆ ಸ್ವಾಮಿ, ಅಲ್ಲಿ ಬಿಟ್ರೆ ಸಾಕು, 30 ಫೀಟ್ ರೋಡ್ ಬಿಟ್ರು ಸಾಕು ಅಂತಾರೆ. ಈ ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಆಗಿರೋದಕ್ಕೂ ಅದಕ್ಕೂ ಕಂಪ್ಯಾರಿಸನ್ ಮಾಡಿ ಹಿ ಇಸ್ ರೆಡಿ ಮೆಲಾಡ್.
ನೋಡಿ ಅಂತ ಇದೆಯಲ್ಲ ರೋಡು,
ಸ್ವಾಮಿ
ಆ ರೋಡ್ ಎದುರುಗಡೆ ಇರೋ ಸೈಟ್ ನಂಬರ್
186 ಅದ್ ಮನೆ ಕಟ್ಟಿಬಿಟ್ಟಿದ್ದಾರೆ,
186 ಮನೆ ಕಟ್ಬಿಡಿ.
ಮನೆ ಕಟ್ಟಿದ್ದಾರೆ, ಇಲ್ಲಿ ಕಟ್ಟಿಲ್ಲ.
So what about this 176 and 177?
176, 170, ಇಲ್ಲ 192, exact 191 some part and 192, 193 part, there this road B is projecting.
You 192, 193.
ಹೌದು ಸ್ವಾಮಿ, ಇದು ಇವರು Bob Shetty is appearing for them. Immediately after service of, immediately after service of notices of this writ petition, they have
Can file objections as to whether there is any access. Barcode. The Learned Counsel for the respond number 9 to 12 seeks time to file objections.
a date will fix it by.
Hence list on ಯಾವತ್ತು ಬೇಕು?
ಯಾವ್ದಾರ date
10 days ಮೇಲೆ after 10 days.
11/2.
Land acquisition matters ಯಾವತ್ತು ಬರುತ್ತೋ ಅವತ್ತೇ ಕೊಡ್ಬೇಕು. 11th ಆಗುತ್ತಾ? 11th.
I appear
29. Yes, PS Mali Patil.
I appear for the petition, my lord. I sought for, my lord, extension of, my lord, dispensation of annexure.
I thought A 1 of 25 is for
Annexure K.
dispensation of production of certified copy of annexure K. The reasons mentioned in the application are perused and the same is accepted. Hence, IA 1 of 25 is allowed. Yes, what is the issue?
My lord, annexure K, my lord, is the order, impugned order challenged, my lord, in the writ petition, wherein, my lord, the BDO, my lord, block education officer has asked my petitioner
Please
to, my lord,
increase
to
your
close the-
volume, Mr. Mali Patil.
Yes, my lord, I'm sorry.
I'm not able to hear you.
Yes, now it is, my lord.
ನಮ್ದು ವಾಲ್ಯೂಮ್ ಇನ್ಕ್ರೀಸ್ ಮಾಡ್ರಿ. Yes.
Yes, my lord. Annexure, under annexure K, my lord, the petitioner has been asked to, my lord, close the hostel, my lord, in the school, high school premises.
Please read.
My lord, kindly see, my lord, ಈ ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ 1ರ ದೂರಿನ ಅನ್ವಯ ನಿಮ್ಮ ಶಾಲೆಯಲ್ಲಿ ಅನಧಿಕೃತವಾಗಿ ವಸತಿ ನಡೆಸುತ್ತಿರುವ ವಸತಿ ನಿಲಯಗಳನ್ನು ನಡೆಸುತ್ತಿರುವ ದೂರಿನ ಕುರಿತು ಉಲ್ಲೇಖ 2ರನ್ವಯ ಮಾನ್ಯ ಸಹಾಯಕ ಆಯುಕ್ತರು ರಾಯಚೂರು ಇವರು ಸದರಿ ದೂರಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಕ್ರಮ ಕೈಗೊಳ್ಳುವಂತೆ ಆದೇಶಿಸಿರುತ್ತಾರೆ. ಪ್ರಯುಕ್ತ 3 ಮತ್ತು 4ರನ್ವಯ ನೀವು ಲಿಖಿತ ಹೇಳಿಕೆ ಮತ್ತು ದಾಖಲೆಗಳನ್ನು ಉಲ್ಲೇಖ 5ರನ್ವಯ ಮಾನ್ಯ ಉಪ ನಿರ್ದೇಶಕರು ಶಾಲೆ ರಾಯಚೂರು ಇವರಿಗೆ ಮಾರ್ಗದರ್ಶನಕ್ಕಾಗಿ ಪತ್ರ ಬರೆಯಲಾಗಿತ್ತು. ಪ್ರಸಕ್ತ ಉಲ್ಲೇಖ 6ರನ್ವಯ ಮಾನ್ಯ ಉಪನಿರ್ದೇಶಕರು ರಾಯಚೂರು ಇವರು ಸಾಕ್ಷಮ ಪ್ರಾಧಿಕಾರ ಅನುಮತಿ ಇಲ್ಲದೆ ನಡೆಸುತ್ತಿರುವ ವಸತಿ ನಿಲಯಗಳನ್ನು ಕೂಡಲೇ ಮುಚ್ಚಲು ಕ್ರಮ ವಹಿಸುವಂತೆ ಆದೇಶ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ನಿಮ್ಮ ಶಾಲೆಯಲ್ಲಿ ವಸತಿ ನಿಲಯವನ್ನು ಕೂಡಲೇ ಸ್ಥಗಿತಗೊಳಿಸುವಂತೆ ಸೂಚಿಸಿದೆ. ಒಂದು
where is the approved permission obtained by you?
Annexure K, annexure H, page 26.
No, that is only a registration of a society.
Annexure H, page 26, my lord.
Page 26.
Notice was issued, my lord, by which, my lord, I have answered. It was issued, my lord, in respect of 4 schools in Manvi.
No, I'm asking you a simple question.
Yes, my lord.
What is there to show that you are permitted to run a hostel?
Yes, my lord.
Illide.
I have been, my lord, given permission, my lord, by the TMC Manvi.
Illide.
Yes, my lord, I will just show it. Fiction is the.
You say it's a PG center.
Annexure F, my lord, annexure F.
No, this is not a, how can it be a trade license? How can this?
And thereafter, my lord, food safety annexure G, my lord, is a food safety, my lord, the standard authority has issued.
No, we are not on that.
Certificate.
We are not on that.
Now, my lord, what they say that, my lord, we have to close it, my lord. We have filed the reply to the annexure H as per annexure J.
No, please tell us, is it a PG center or?
It is not a PG center, not. It is only, my lord, a residence provided to the school students.
So
Hostel.
therefore,
Hostel.
if you are providing hostel services,
Hostel services, my lord.
is there any requirement in law that it should be registered before any authority?
It is not, my lord, school is to be registered, my lord. Now it is a society.
Under the Education Act, sir. Under the Education Act, and registration is compulsory. Why don't you look at it?
I will, my lord, I will.
Under the Registration Act, you have to register the hostel because there are certain safety standards which you have to adopt.
But it may be called tomorrow, my lord. I will satisfy your lordship. With reference to, my lord, provision.
Under the Education Act, I remember
ma'am.
there's some
Yes.
provision regarding.
Yes, my lord, I will do it. My lord, similar notice was issued in respect of other 3 schools, my lord, in Manvi. And one of them, my lord, has approached this honorable court and at annexure L, the honorable court has issued notice and, my lord,
The interim order is granted.
interim order is granted, my lord, till next date of annexure L, my lord, I have produced page 30.
No, the section 82 nodi answer the Education Act.
Yes. Yes, my lord, I will.
Please go through and please let us know.
Yes, my lord. I will.
List tomorrow, yavatu?
Tomorrow, my lord. Yeah.
List tomorrow.
Yes.
I am for the petition. Let's, petitioner is the absolute owner of measuring 15 square feet, 15,000 square feet in survey number 36/1. And this, he has purchased the land from original owner as per annexure A shall deed I have produced. In pursuance of this registration shall deed, his name is transferred in, entered in the Kata as Kalaburagi municipality.
Yes.
And he has paid the tax also. That land acquisition officer acquired the land. It is 36/1 is measuring total 5 acres. Out of that, I have purchased only 15,000 square feet.
So what is the total extent of 36/1?
5 acres plus.
5 acres?
Yes, plus.
What, how much is acquired?
That's total 5 acres is acquired.
The entire extent of 5 acres
Please,
is acquired?
please.
Plus,
at the time of acquisition, my notice was not issued to the petitioners and is not a party to the proceedings also. After acquisition, 36/1 transferred to the agriculture university for the purpose of agriculture development. But by mistake, that was transferred 36/2 as per Annexure C, my lords. Annexure C, page number 26, my lords. This, by mistake that was transferred 36/2, therefore the university filed an appeal before the Assistant Commissioner under section 136 of the Karnataka Land Revenue Act.
Yes.
That appeal was allowed and ordered to transfer 36 acre, 2 acre 18 gunta. Sorry, my lords, by correction, 2 acre 18 gunta was acquired, my lords, total. In this also, my lords, I am not a party. Petitioner is not a party. Therefore, petitioner filed a revision before the Deputy Commissioner. The Deputy Commissioner, who had order dated, my lords, 19/2/2022, dismissed my revision petition, holding that the OS 597 of 2011 filed by the petitioner and RA was dismissed. Therefore, he has no right. But in fact, this OA order and RSA order is challenged before this honorable court in RSA, my lords. That was allowed and remanded when matter is pending, but this order is not correct. RSA is allowed and remanded the matter. No matter is pending.
I think you succeed in the suit, you'll get back your revenue.
No, my lords, they have taken entire compensation or, my lords, without paying any compensation. If my land is utilized, my lords,
Now, you do not know whether your land is also acquired.
that,
Whether your land measuring 15,000 square feet, whether it is acquired or not.
as per the, my lords, they are said that acquired, they are trying to take possession, my lords.
So therefore, who has received the compensation?
That land acquisition officer is passed the award in the benefit of Agriculture University.
Correct.
Right.
Who has received the compensation?
Till today, they are not received. I am not, petitioner is not received, whether the other side received or not, I am not aware. But that must, but the order is, now my name is entered in the record, I have produced the sale deed, everything, my lords. Even though, but only, my lords, I have filed a suit for 597 of 2000 per injunction, bare injunction suit, my lords. And that was dismissed. And again, that RA is also RA. Against that, my lords, I filed RSA. RSA is remanded, allowed and remanded.
See, do you admit that your land is acquired or not? If you admit that your land is acquired,
Please.
then you cannot challenge the order passed by the Assistant Commissioner. If you admit
Yes.
the land is acquired, then
Please.
you cannot challenge the order passed by the Assistant Commissioner. Your claim is only for compensation.
Yes.
If you do not admit, then you can challenge the order of the Assistant Commissioner.
Please. Yes, please. Then, my lords, your lordship, kindly, whether I'll produce the acquisition, I'll get the acquisition proceedings and produce before your lordship, whether it is acquired or not, I'll get. But so far as that order rejection is, my lords, illegal. Because matter is pending.
Rejection ಸರಿ, but ನಾನು ಕೇಳ್ತಿರೋದು,
Yes, yes, sir.
ಇವಾಗ ನಿಮ್ಮ ಜಮೀನ್ acquire ಆಗಿದ್ರೆ,
Settle. Yes.
if your property is acquired,
Please.
then you cannot challenge the order passed by the Assistant Commissioner.
Only I am entitled for.
You are entitled for compensation.
Yes.
If it is not acquired, only then you can challenge it.
Yes. I'll
Town
produce.
Council for the petitioner seeks time to secure instructions whether the property of the petitioner is acquired or not.
Please, I'll produce. Next day,
List down on date.
please.
Mutation in record. Mantesh Patil.
Lords, one Hanumakka, a resident of Husky Hall village, my lords, was the owner of the property. And it was standing in her name from the lords 1955 to up to 2017. I have produced the revenue records at Annexure A series, my lords. And your lordships would find that till the date 2006-7 at page number 45, her name was shown as, my lords, as a owner and possessor column in the possession column. And, my lords, she executed the registered will dated 27/4/1966, my lords, in favor of the temple called Dodda Anjaneya Temple of Husky Hall village. It's a registered will, Annexure B at page number 46, my lords. And the typed copy is at page number 51, Annexure B, my lord. Thereafter, my lords, in the year 2006, one Narayanappa, my lords, has alleged to be filed an application at annexure C, my lords, page number 57, K. Narayana, son of Ramappa, claiming that he is the successor of Hanumakant. That application for mutation was came to be rejected by order dated 31/5/2008, my lords, page number 57. Then, my lords, again one more application was filed by his Narayanappa, same person, in the year 2018, my lords. Again, 29/1/2018 at page number 59, my lords. The application was rejected on the ground that the since earlier application was rejected on 31/5/2006 and directed the petition, the Narayanappa to approach the civil court, my lords. Thereafter, since he has failed, my lords, to get mutation of the property, between the family members, the suit for partition was filed, and that was compromised, my lords, within a 1 day. And the compromise, as per the compromise petition, now by in the year 2007-8, my lords, dated 26/2/2008, the mutation was effected at page number 68, my lords.
But anyway, you are claiming under the will.
But the temple is claiming under the will. All the proceedings which were not started, and when the Tahsildar was initiated the proceedings and 2 times it was rejected. Then they files a petition, compromise suit.
I understood.
Ultimately,
No, you are representing the temple.
Yes, my lords.
And you are claiming that this Hanumakka had executed a will somewhere in 1966.
In favor of the temple.
Alva. Whether the name of the temple was included in the revenue record based on the will.
Agila. 19 up to 2007-8 vargu kuda Hanumakka ne hesaru ittu. Hanumakka died in the year, my lords, approximately 2017. The subsequent proceedings, the temple, they will not, no one.
But based on a will, can the revenue authorities decide?
No, I am not, my lord, saying that based on the will, my name has to be entered. What is there on the date of filing of subsequent suits and initiating proceedings, my lords, that ought to have been maintained.
Yes.
Other than that, my lords, because Hanumakka, all are disputed entries, and apparently, my lords, prima facie, it shows that.
Have you filed any suit?
Suit, my lord, the page number annexure.
Declaration for declaration.
Yes,
on the will, based on the will.
Based on the will, and also for setting aside the compromise entered by them.
Where is the plaint filed?
Page number 73 is the operative portion.
Page number
73, my lords.
What is the relief sought? Both.
The Honorable Court may be pleased to pass a decree declaring that the decree passed in OS number 228/2007 dated 15/12/2007 on the file of Principal Civil Judge Junior Division is null and void and ineffective and to be cancelled. Decree be passed that in view of the will deed, the suit property bearing number so and so of Askiyad Raichur belongs to the Dodda Anjaneya temple of Askiyad village so and so. And for granting permanent injunction and so and so.
Yes, government advocate. AG has directed to accept notice for response 1 to 4. Issue emergent notice to respond number 5 and 6. The revenue records of the land bearing survey number?
Not survey number 141 star and star 13 acre 22 guntas of Askiyad.
141 bar star of which village?
Askihal.
Huh?
Askihal village, Raichur.
Askihal village?
Raichur Taluk.
Raichur Taluk. The revenue records? Shall not be altered and status quo shall be maintained as on date.
Status quo by virtue of the Deputy Commissioner order, they have changed it. And one more aspect I want to bring to your Lordship's notice is, now it was thereafter during pendency of the suits, it was transferred to someone else in order to alter the he was filed a permanent injunction suit. In that, 39(1) and 2 was filed. And that was dismissed and ME in the MA also that is confirmed.
Correct. Shall be maintained. Contemporary, in addition, the respondent number 3 and 4 are directed to make appropriate entries in column number 11 of the RTC. about the pendency of this writ petition. And the order passed today. Yes, blessed.
Lordship, all these petitioners are landless backward class people without having any such individual agricultural land to cultivate and get some income. And it is further submitted that land survey number 3110 of Kurdi village is a government land.
Well, let the government advocate get instructions.
Yes.
Protocol AG is
Yes.
directed to accept notice for the respondents 1 to
1 to 4.
4.
1 to 4, madam.
List on Yavat, when can you get instructions?
11,
2 weeks.
2 weeks.
List on date.
Yes.
Ravi B. Patil, Nenne matter.
Yes, my lord.
Yes, what happened?
My lord, I am producing proceeding on 18, 24 and 27.
Now, whether this man was there on 18/1.
Yes, my lord.
He was seen
Yes, they are signed. Order sheet, my lord. Kindly see 18-1.
Yes, madam, you have signed some order sheet.
Yes, your lordship, on 18, lordship, he has taken here the party sign at the evening time, lordship. Thereafter 24 was given and time, lordship.
Madam,
At
yesterday
that-
you said,
Yes, your lordship.
yesterday you said that this officer, joint director of societies, was not sitting in the office. Now you say that he has taken your signature,
On 24, lordship.
same order. Whatever order that
submission,
was passed.
submission, my lord. On behalf of the respondent number 2, I will undertake, my lord.
Yaru?
Respondent number 2, my lord.
Competent election authority.
You are
Yes,
Mr.
ma'am.
Solomon.
Yes, my lords.
You're not to be seen. I've been asking all lawyers, where is Solomon Alfred?
So, my lord, while I am coming from Srirangapatna, I met an accident, some knee pain is there, my lord. That is the reason, my lord.
ಅದು ನಿನ್ನೆ ಜಡ್ಜ್ ಆರ್ಡರ್ ಮಾಡಿದೆ, ಸೇಮ್ ಆರ್ಡರ್, ಲೆಟ್ ಇಟ್ ಬಿ ಮೇಂಟೈನ್. Mr. Alfred Solomon is permitted to file a memo of appearance for the respondent number 2.
Lordship, and wine submission, lordship.
Huh?
At least 2 weeks time may be granted.
No, madam.
Your lordship.
Because of you, we posted the matter
Elections.
today.
The elections were not held, lordship.
Next. No, when you're making a statement before the court, you should
Yes,
be very,
your
very cautious, doubly cautious. Just because your client says something, you need not be carried away. I asked the government
submission-
advocate whether this man was in office on that day or not. Government advocate said he was. You said no, he was not there.
On
You
24
waited till
was
evening,
not.
he did not turn up ಅಂತ ಏನೋ ಹೇಳಿದ್ರಿ. Next,
Your lordship.
Krupa Sagar Patil.
Yes, the petitioner being agreed by order at annexure D, wherein an additional award is passed by the SLO after the LAC judgment, LAC award is passed. My lord, additional award is on the basis of that he has claimed that possession is taken prior to 401 notification. My lord, here the facts are, my lord, that regarding the same LAC, the LAC which is based upon the LAC which an order is passed at annexure D is challenged before this honorable court and it is pending for consideration, my lord. And moreover, in the Lok Adalat, the petitioner himself has settled, the respondent number 2 himself has settled the matter for 127 rupees per square feet. Now he claims at annexure D, he claims at 150 rupees per square feet, my lord, for as additional compensation.
Take out notice.
My lord, in this case, my lord, for R1 government, R2 already,
AGA for R1.
R2 Mantesh Patil has filed another writ petition challenging the very same order.
Mantesh Patil is directed to accept notice for R2.
Plus R2, my lord. I'll give you the connected numbers, my lord.
List this petition along with WP number sounds.
Serial number 36 also same, my lord.
36 same order. List this petition. Ella, what is correct, Madi?
36, sir.
35.
The lordships, in this matter, the petitioner herein has filed a suit for partition, wherein he has sought for a temporary injunction against defendant number 4. The temporary injunction was granted.
Is it an ex parte order or after contest?
No contest.
Ex Ex parte order.
It is an
If it's an ex parte order, how can it be entered?
ex parte order.
Then after contest, you file. Workhold. AG has directed to accept notice for response 1 and 2. Is order sheet next para. The petitioner has sought for a writ in the nature of mandamus directing the respondent number 2 to consider his representation dated 29/11/2024. Next para. The petitioner contends that he filed a suit for partition and separate possession of his share in survey number 768/* of Vasadant Nagar, Vijaypur district, measuring 16 acres 31 guntas. He contends that in the suit filed, an application was filed for injunction to restrain the defendant number 4 from alienating or mortgaging or encumbering or transferring the suit property, and that the court, in terms of the order dated 28/11/2024, granted an ex parte order of injunction. Full stop. After the order of injunction was passed, the petitioner submitted a representation before the respondent number 2 to enter the order of injunction in column number 11 of the RTC. Petitioner contends that the said representation is not considered, and therefore the petition is before this court for a suitable direction to the respondent number 2 to consider the representation. Next, the learned counsel for the petitioner reiterated the above contentions and contended that the order of the injunction passed by the court should be entered in column number 11 so as to ensure that the respondent number, so as to ensure that the defendant number 4 in the suit does not violate the order of injunction. Per contra, the learned AGA submitted that the respondent number 4 is not arrayed as, the defendant number 4 in the suit is not arrayed as a party in this writ petition. Besides this, he submits that the order of injunction granted by the trial court is an ex parte order without hearing the defendants in the suit, and therefore no direction can be issued to the respondent number 2 to enter the order of injunction in column number 12, column number 11 of the RTC. He, however, contends that if the court considers the objections, if any, of the defendant number 4 in the suit and then passes any order, then steps would be taken to enter it in column number 11. Next para. As rightly contended by learned AGA, the order of injunction granted in the suit is without hearing the defendants in the suit, and therefore, the no direction can be issued to the respondent number 2 to enter the ex parte order of injunction in column number 11 of the RTC, as that would impair and affect the rights of the defendants in the suit. Full stop. Therefore, no directions can be issued to the respondent number 2 to consider the request of the petitioner. However, after the court considers the application for interim injunction, after hearing the defendants in the suit, the petitioners are at liberty to file necessary representation before the respondent number 2 to enter the text of the order in column number 11 of the RTC. Full stop. If such a representation is filed, the respondent number 2 shall consider the same in accordance with law. Yes.
Obliged.
The writ petition stands disposed of, subject to the above observation.
Obliged.
Challenging the endorsement issued by on H2, page 28.
This is syllabus 37.
Yes, easy is directed to accept notice for response, 1, 2, 3. Get instructions. Please serve copies.
My lord, I will.
2 weeks.
List on date code. Sachin Mahajan.
Would appear for the petitioner in this case, my lord. Now, the petitioner, my lord, is presently working, my lord, in KSRTC, KKRTC, my lord, as assistant engineer, class 2 civil. My lord, he is junior engineer, my lord, and he is, my lord, eligible for promotion as assistant engineer. My lord, ACR is called for as per annexure A at page number 13. My lord, my name, my lord, is shown against that post, my lord. I am the only person eligible, my lord. Muhammad Hanif, Kiriya Abhintaru, Kamagari, Mikulu the Srini, my lord, residual, my lord, Mikulu the Vranda, Muhammad Hanif. My lord, when I was in the active zone of consideration, my lord, a charge sheet is issued, my lord, as per annexure B, page number 15. Your lordship, my lord, will peruse or 3-4 lines, my lord, after the Apadane Patra. ಎಂ ರಾಜ್ಯಪ್ಪ ವ್ಯವಸ್ಥಾಪಕ ನಿರ್ದೇಶಕರು ಹಾಗೂ ಶಿಸ್ತು ಪಾಲನಾಧಿಕಾರಿಗೂ ಕರ್ನಾಟಕ.
Are they not bound to follow the sealed cover procedure?
What they are required to do, my lord, they cannot first, my lord, my first contention, my lord, is the charge sheet cannot be initiated on the basis of, my lord, a preliminary inquiry report. What they say, my lord, ಜಂಟಿ ಮಧ್ಯಂತರ ತನಿಖಾ ವರದಿ ಅನುಸಾರ ಹಾಗೂ ನನ್ನ ಮುಂದೆ ಇದು ಹಾಜರುಪಡಿಸಿದ ದಾಖಲೆಗಳ ಅನುಸಾರ. My lord, there is particular provision, my lord. I have produced that document, my lord. Karnataka State Road Transport Corporation Servants Conduct and Discipline Regulations of 1971, Annexure C, my lord. In that, your lordship will find, my lord, relevant page number 27, procedure for imposing major penalties. Adaralli 23 clause 3, my lord. After conclusion of the inquiry, a report shall be prepared and it shall contain the following particulars. So it is only after, my lord, the conclusion of the report, my lord, such a charge sheet can be initiated. And there are 2 more circulars, my lord, taking into consideration, my lord, such situations where, my lord, employees are put to harassment right at the crucial stage, my lord, of their promotion. My lord, such charge sheets are issued. Therefore, my lord, to discourage, my lord, such tendencies, annexure D, my lord, there is a circular dated 12/5/2017. Specifically stated, my lord, we are in the active zone of consideration, such steps should not be taken. And now, my lord, charge sheet is, my lord, issued with respect to
a notice, issue emergency notice.
Today they are, my lord, today and tomorrow they will be finishing, my lord, the DPC proceedings. My lord, if it is concluded, my lord.
Is it a selection, promotion by selection or what?
No, this is promotion, my lord, on the basis of, my lord, my past service. They have issued work order for that very work, my lord. Tender is now, notifications are issued.
Is there any criteria for selection or promotion?
My lord, criteria for promotion, my lord, as such, my lord.
Yeah, criteria. Is there any interview or something like that?
No, there is no interview, my lord. It is already, my lord, my name is gone. I am the only person, my lord, for that particular post. My lord, in all probabilities, my lord, since I am the only person, my lord, I am bound to be promoted.
Notice, yaar KKRTC yaar idhar hai?
My lord, Subhash Mallapur, Mr. Deepak Barad is there, my lord, and
Mr. Deepak Barad is there to accept notice for response 1 and 2. You are the only person who they cannot fill it up with any other person. Mohammed Dhani.
Once they, my lord, conclude, again, my lord, some notification will be issued, it will be given to somebody else, my lord. Because now my name will be put in seal cover, my lord, it will be suspended. Take instructions.
Pending disposal of this writ petition, comma, if the petitioner is entitled for promotion, comma, the respondent shall adopt the sealed cover procedure and declare the promotion of the petitioner after conclusion of the inquiry. Yes.
For the petitioners seeking direction to remove the name of the 6th respondent in column number 11. annexure B1.
ಸಾಲ ತೀರಿದ್ಯಾ?
ಸಾಲ ಬ್ಯಾಂಕಿನಲ್ಲಿದೆ ನೋಡಿ. Subsequently in annexure A, ಸಾಲ ಬ್ಯಾಂಕಿನಲ್ಲಿ ಸಾಲ ಇದೆ.
ಸಾಲ ಇದೆ.
ಇದೆ.
Have you cleared the loan?
No, my lord.
Then
But WAF name is forthcoming in the same.
ಎಲ್ಲಿದೆ ಕಾಲಮ್ ನಂಬರ್ 11 ಅಲ್ಲಿ?
11 in annexure B1 and B2.
Page number 15 and 16.
12,
16,
16.
Waf Mandali, Bangalore.
It is page number
16 on 6.
12 and 16. From the year 2017 and 18, it is forthcoming, my lords, without any reasons.
Yes, work here, Naresh Kulkarni. AJ's director to accept notice for response 1, 2, 3, 4, 5. Naresh Kulkarni for R6. You know, we can close it. Huh? Work. The petitioner claims to be the owner of a land bearing survey number 24/* of Vaganagera village, Shorapur Taluk, Yadgir district, measuring 10 acres, 5 guntas. Full stop. He contends that the respondents four and 5 unilaterally entered the name of the respondent number 6 in column number 11 of the RTC. Full stop. The petitioner is therefore before this court for a direction to the respondents 3 and 4 to remove the entries, to remove the name of the respondent number 6 from column number 11 of the RTC. It is contended that this court in similar circumstances had allowed WP number 202965 of 2022. Stop. Next, the learned AGA submits that there are no, the learned AGA submits that entries are made in column number 11 only to establish, only to show the claim of the respondent number 6. And therefore, it does not affect the title, if any, of the petitioner. The learned counsel for the respondent number 6 reiterated the contention of the learned counsel, learned AGA. Next para. Column number 11 of the RTC relates to other rights and liabilities. Full stop. Admittedly, the name of the respondent number 6 was not entered in the revenue records relating to the above survey numbers till the year
17 and 18.
Till the year 2017-18. Full stop. If any entry had to be made in column number 9, comma, the petitioner being the occupant and owner of the land ought to have been notified. Full stop. The respondents 3 and 4 would not have unilaterally entered the name of the respondent number 6 in the revenue records. To that extent, comma, the submission of the learned counsel for the petitioner merits acceptance. As rightly contended by the learned counsel for the petitioner, a coordinate bench of this court in WP number 202965 of 2022 and 201590 of 22 has held has directed the deletion of the waqf in the column number work from the revenue records. In that view of the matter, this petition also deserves to be allowed. And the respondents 3 and 4 are liable to be directed. 4 and 5 are liable to be directed to forthwith delete the name of waqf from column number 11 of the RTC. full stop. If the respondent number 6 has any claim in respect of the property, the respondent number 6 may make appropriate representation before the respondent number 4 and 5, who shall, after hearing the petitioner, take necessary steps.
My lord,
AG is permitted to file memo.
record of rights up to 1617. Of name is not there, it is up to 1718 ಅಂತ ಆಗಿದೆ 1718 of name is
16, 17.
up to 1617.
17, 18, 16, 17.
But the direction has to be issued to the Tahsildar to initiate proceedings.
You give a representation as to how it is work property, why it has to be included. Give a representation, then they will consider. I have given that liberty to you. Deepak Bharat.
Before my lord arguing, there is wrong. Phone number 6 has been wrongly typed, my lord. I am permitted to change the page. I will change the page.
But what is the name of respondent 6?
That's what I will change it. I'm permitted to change.
No, but we do not know the cause list.
No, that.
ಅಲ್ಲ ಏನಂತ ಆರ್ಡರ್ ಶೀಟ್ ಏನಂತ ಟೈಪ್ ಆಗಿದೆ ಕೊಡ್ರಿ ಇಲ್ಲಿ. ಇಫ್ ಇಟ್ ಇಸ್ ಅದು ಏನಾಗುತ್ತೆ ಸಿಸ್ಟಮ್ ಅಲ್ಲಿ ಹಂಗೆ ಬಂದ್ಬಿಡುತ್ತೆ. The learned counsel for the petition file at least a memo or something like that.
I will.
The learned counsel for the petitioner. What they will do is they will copy the same thing in the at the time of filing.
By oversight it has happened.
Counsel
I'm
for the
permitted to
petitioner.
replace the page.
The learned counsel for the no, ನೀವು ರೀಪ್ಲೇಸ್ ಮಾಡ್ತೀರಿ ಸರಿ. ನೀವು ಫೈಲಿಂಗ್ ಕೌಂಟರ್ ಅಲ್ಲಿ 6th respondent ಇಂದಾನೆ ಟೈಪ್ ಆಗಿರುತ್ತೆ. So for you to correct it, then you have to file a memo or an application or something like that.
I will file memo.
The memo is filed by the learned counsel for the petitioner to correct the particulars of 6th respondent in the writ petition. In view of the memo, the learned counsel for the petitioner is permitted to show the name of the respondent number 6 correctly. Full stop. The registry is directed to make appropriate entries in the website to show the name of the respondent number 6. Yes, what is the issue?
I'm seeking direction to be issued to the third respondent to consider Annexure H, my lord.
What is Annexure H?
My lord, Annexure H, I have filed an objection, my lord, for a survey of survey and HUD-bus of survey number 470, my lord. My lords, what has happened? The 6th respondent earlier, my lord, has filed a suit against the petitioner.
6th respondent has filed a suit against the petitioner.
Petitioner here in.
Just a moment. 6th respondent.
Has filed a suit against the petitioner in OS 11 of 2023 before the Civil Judge Junior Division, Unnavarna, seeking, my lord, injunction against the petitioner. My lord, on the ground that, my lord, he is in owner and possessor of land survey number 470, measuring 1 acre 19 guntas. My lord, the injunction was filed, a temporary injunction. The application came to be rejected by the civil court, my lord. Since the petitioner filed objection and temporary injunction application was rejected. Thereafter, my lord, miscellaneous appeal is filed. It is pending consideration. My lord, meanwhile, my lord, the 6th respondent approached this court in WP number page 56, my lord.
Yes, take a purport. Issue AG has directed to accept notice for response 1 to 5. Issue emergent notice to respondent number 6. Have you sought for an interim?
Yes,
interim stay of survey and demarcation of land in survey number 470 and 467 of Humnabad till the next date of hearing. List on. Please file a memo.
I will.
Submission with my lord's kindly. Serial number 38, my lord, I will file a memo for hand delivery. They will complete it today.
Yes.
Please.
41.
41 records they have traced, my lord. Next week I will produce land tribunal records. Misplace ಆಗಿದ್ದು ಸಿಕ್ಕಿದಾವಂತ. Land tribunal records, honorable court directed to secure, my lord. ಅವು ಮಿಸ್ಪ್ಲೇಸ್ ಆಗಿದ್ದು ಸಿಕ್ಕಿದಾವಂತ ನಿನ್ನ ರಾತ್ರಿ ಫೋನ್ ಮಾಡ್ಯಾರ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇಟ್ ಮೇ ಬಿ ಪೋಸ್ಟೆಡ್.
Records ಬಂದಿಲ್ಲ.
ಸಿಕ್ಕಿದ್ರೆ ಮತ್ತೆ ತಂದ್ಕೊಡ್ಬೇಕಲ್ಲ ಅವರು.
ಇಲ್ಲ ತಂದು ಕೊಡ್ತೀನಿ ಅಂತ ಅಂದಾರ್ರಿ. ಮತ್ತೆ ಅದ್ರ ಸಲುವಾಗಿ ಮತ್ತೆ ಇವತ್ತು ಮ್ಯಾಟ್ರ್ ಇದೆ ಅಂತ ಹೇಳಿ.
ಈಗ ತಾಂಬರಕ್ಕೆ ಹೇಳ್ರಿ ಇವತ್ತು. Ask him to bring it.
ಶಾಪೂರ್ ಮೇಲೆ.
ಶಾಪುರ್ ಎಷ್ಟು ದೂರ ಇದೆ? ತರಕ್ ಹೇಳಿ. ಮಧ್ಯಾಹ್ನ ತರಕ್ ಹೇಳ್ರಿ.
With your lordships, this is the third time adjournment is being sought for summoning the records.
ಏನ್ ಮಾಡ್ತೀರಿ? Pass over. Ask him to bring the records. Mr. Ayyar, Biradar. Yes. Yes, Nadagoda.
I am the respondent corporation.
Ah.
Lord, the petitioner.
The petitioner objection file ಮಾಡಿಲ್ಲ. Its petitioners appointed on as a waterman, water supply and road lighting as a peon in the chief officer to municipal Sindigi in the year 1978. And my lord, his service was
When was he appointed?
not in the year 1978. 12/1/1978. The resolution copy produced as annexure A minutes. Appointment order. And equal pay for equal work is also granted to the petitioners and others in the year 1983 by annexure B minutes. But in the year 1984, he is removed from service without any order. Then he approached the DC, Vijaypur, and DC wide annexure C page typed copy page number 21.
Yes, government. Who has to?
Government will regularize service.
My lord,
Government. You are the one who has to regularize.
Yes, sir.
He has been working from 1978.
For my lord, the fact means that there is no relationship as such after the retirement of the petitioner, my lord. There is no relation whatsoever.
He is the municipality. He is recommended my case for regularization.
The government which has to
Yes.
ultimately approve is.
True, my lord. The apex court has several times held, in the absence of any specific scheme regarding the support of the temporary employees, a relief of even direction to the government cannot be issued.
Why?
There
He's
is no
been working on daily wages from 1978.
Stay length of service idru kuda.
Correct. From 1978 he's worked. He's entered for regularization. Who are you to come in the way of he is seeking regularization? Has he not made a request for regularization before he retired?
He would have hesitated this, he should have hesitated this matter before the retirement, madam. After retirement.
He has done it. You did not do anything. Supreme Court has directed that all persons who are in daily wages, on daily wages, and who have completed 10 years are entitled to be regularized. Have you taken any steps for regularization?
No, man.
Then you have to be held responsible. Why did you keep this man guessing? From 1978, this man doesn't have the benefits of pension. What is this absolute lethargy by the employer?
The statement of objection है. Statement of objection है.
You're not filed. Huh?
Akil my lord.
Why you not filed from the last 7 years?
Direction.
7 years you kept quiet, Mr. How do? With great difficulty, these people come to the court, and this is the way you deal with these ex-employees.
Sorry, sir. Extremely sorry.
No. This government, who is the answering response? Director of Municipal Administration, ಏನ್ ಮಾಡಿದ annexure ಹೆಚ್ಚಲ್ಲಿ?
Yes, let's see. This petitioner is approached in the year 2002 itself before this honorable court, my lords, in page number 42. For seeking regularization. This honorable court allowed my writ petition and issued the direction to consider the regularization. What they have said that I have not approached the court. This man is approached in the year 2002 itself. my lords. Now, my lords, the endorsement issued by the DC, Powdad, the administrator of my lords, respondent number 2, my lords. Annexure H, page number 45, my lords.
But what were you doing from 2005 till 2017, Mr.?
My lord, he retired.
He retired.
On
Well, see,
31st
earlier,
May
my lords, he
1999,
approached
my lord.
for this court, my lords, in 2002 itself. And thereafter, they are not considered till the retirement.
This annexure H is in 2005.
Yes, my lords.
What were you doing from 2005?
Then, my lord, he filed a representation before the authorities, my lords, again.
He retired in the year 31/5/1999, my lord.
And similarly, persons have already regularized. One of the copy I have produced, annexure E, my lords. No, sorry. Let's notification, must annexure E may kindly be seen.
Barkol.
He retired in the year 1990.
It doesn't matter. The petitioner has sought for a writ in the nature of certiorari to quash the order dated 28/12/2005, passed by the respondent number 2, bearing number so and so on the dated 28/12 passed by the respondent number 2, and the endorsement dated 17/5/2016, bearing number so and so. The petitioner has also sought for a writ in the nature of or order of direction to direct the response 1 to 4 to regularize the services of the petitioner and grant pensionary benefits with effect from the date of he retiring from service. Next paragraph. The petitioner contends that he was employed as a water supply and road light peon by the then Panchayat of Basavana Bagewadi on daily wages on 12/1/1978. The Panchayat was later
Upgraded Patan Panchayat.
the Panchayat was later upgraded town Panchayat, Patana
Patana Panchayat.
upgraded to a town Panchayat.
Yes.
And and he continued to work at the town panchayat. A resolution dated 29/12/1981 was passed by the town panchayat, fixing the salary of the petitioner at a sum of ₹5 per day. Salary, but fixing the wages at a sum of ₹5 per day. Later, it was enhanced to a sum of ₹8 per day with effect from 26/1/1983. However, the petitioner was terminated on 30/5/1984. Full stop. The respondent number 3, on being satisfied that the termination was not in accordance with law, and in view of the judgment of the apex court, not in accordance with law, reinstated the petitioner into service with all consequential benefits in terms of the order dated 25/11/1991. Petitioner contends that he worked in the town panchayat from then on till 31/12/1997, when he was granted the time scale of pay. He was granted the time scale of pay by the panchayat. Full stop. Later, the petition was transferred from Basavana Bhagyawadi Town Panchayat to Sindagi Town Municipality on 17/6/1998. Full stop. The respondent number 5, taking into consideration the length of service of the petitioner, recommended to regularize his services. Consequently, the respondent number 5 addressed a communication to the respondent number 3. Full stop. The respondent number 3 then forwarded it to the respondent number 2. Full stop. The petitioner contends that he retired from service on 31/5/1999. Full stop. He submits that he contends that being agreed with the inaction on the part of the respondents in not regularizing his services and granting all consequential benefits, he approached this court in WP number 1685/1997. This court in terms of the order dated 3/3/1999.
Annexure G, not annexure.
Huh?
WP number 18221. Annexure G.
1821.
Please.
1821 of 2002.
Yes.
This court in terms of the order dated 23/10/2002. Directed the state government and the directed the response 1 and 2 herein to consider the case of the petition for regularization and also to pay the pensionary benefits. Full stop. Following this order, the respondent number 2 passed an order, issued an endorsement dated 28/12/2005, refusing to regularize the services of the petitioner and extending the pensionary benefits to him on the ground that he was relieved from service on 30/5/1984 and was appointed on 28/11/1991. and that he retired on 31/5/1999. And therefore he had not completed 10 years of continuous service. Full stop. Later, the petitioner brought to the notice of the respondent number 4 that a person named Mr. Murtuza Saab Hassan Sahab Kuntoji, a waterman working at Talikote municipality, was given benefit of 3 years of service and he was regularized and was granted pensionary benefits. The petitioner therefore sought for similar treatment. Full stop. The respondent number 4 forwarded the same to the respondent number 5 on 11/5/2016. Full stop. The respondent number 5, in terms of a communication dated 17/5/2016, comma, refusing to grant the benefit of the grant of benefit of pension to the petitioner. The petitioner is therefore before this court challenging the order passed by the respondent number 2 as well as the respondent number 5. The learned counsel for the petitioner submits that the state government has issued an order which reads, order dated 26 September 1998, which reads as follows. Third, in partial modification of the orders issued in the government order dated 6/8/1990, read above, government are pleased to substitute para 14 thereof by the following paragraph. Third, para 14. In the case of daily wage employee, ಇದನ್ನು annexure L ಅಲ್ಲಿ page 52 ನಲ್ಲಿ ಇದು red pencil mark. It therefore contends that the petitioner should be granted the benefit and his services should be regularized. Full stop. Per contra, the learned counsel for the learned AGA submits that since the services of the petitioner had not completed 10 years of service, comma, he is not entitled for regularization. Full stop. The learned counsel for the respondent number 4 also reiterates the contentions of the learned AGA.
Only one sentence.
Huh?
Mine is only one sentence. Mine is only one submit argument. In the absence of any specific scheme, even the government has no powers to regularize.
You're batting for the government or for yourself?
I'm representing R4, my lord.
So then you please argue for your point. Why are you arguing for the government?
In the absence of any specific scheme, no authority can.
He contends that there is no scheme permitting regularization of employees such as the petitioner, and therefore the petitioner is not entitled to any benefit. Next para. The respondent number 4 has not filed any statement of objections till date, denying the fact that the petitioner was appointed on daily wages on 12/1/1978. Full stop. The petitioner has admitted that he was terminated by the town panchayat Basavana Bagewadi on 30/5/1984. But he was later taken back into service on 25/11/1991. Full stop. Assuming that the petitioner entered service on daily wages on 25/11/1991 and he retired on 31/5/1999, by taking into consideration the government order referred above, the petitioner was entitled for the benefit of an additional 3 years of service. Full stop. If the same was provided, the petitioner would have completed 10 years of service and therefore was entitled to be regularized.
As per Annexure J, my lords, respondent number 4 has recommended my case. Now he is arguing.
Full stop. Even otherwise, this court in WP number 1821 of 2002 had issued a positive direction to the respondents 1 and 2 to consider the case of the petitioner for regularization and for payment of pensionary benefits. Since the same is not done, a positive direction deserves to be issued to the respondents 1 and 2 herein to forthwith regularize the services of the petitioner and grant him all consequential benefits including pension and other benefits. Regularize the services of the petitioner and petitioner. However, the petition shall not be entitled to any arrears of salary, but shall be entitled to pension benefits. And for this purpose, the respondents 1 and 2 shall take all necessary benefits, steps to fix the pension after regularizing the services of the petitioner. Yes, this shall be done within a period of 3 months from the date of receipt of a copy of this order.
Annexure H and so may be cost.
ಮೇಲ್ಗಡೆ ಅದು as a result ಅಂತ ಮಾಡಿದ್ರ as a result, ಅದು ಹೊಡೆದಾಕಿ as a result, the writ petition is allowed. The impugned endorsement issued by the respondent number 2 bearing number so and so dated so and so bracket annexure H is quashed. Consequently, the impugned communication dated so and so issued by the respondent number 5 to the respondent number 4 is also quashed. The respondents 1 and 2 are directed to forthwith regularize the services of the petitioner and grant him all notional benefits and fix the pension payable to the petitioner with effect from the date of his retirement. Full stop. This shall be notionally better. Grant all regularize the services of the petitioner and grant all consequential benefits, including pension. This shall be complied within a period of 3 months from the date of receipt of a copy of this order. Yes.
Much of it.
Yes, sir. 40?
44 will not.
Shivshankar Manur,
Subject matter is, my lord, in respect of the work property. Annexure A, my lord. Annexure A is the gazette notification dated 2006, my lord.
Annexure A.
Annexure A, my lord. Survey number 911 A, my lord. Measuring 6 acre 25 guntas. But respond number 1 government political college disputes these measurements, my lord. Therefore, I filed application before the Tahsildar for measurement of the site, my lord. So annexure B is the order of the Tahsildar. PT sheet is prepared by the Tahsildar, my lord. And with consent of both the parties, joint measurement is made. So Tahsildar said, my lord, as per the checkbandi prakara, I am in possession of 3 acres 16 guntas only, my lord. As per annexure B, my lord. So earlier it was a 6 acre 25 gunta, my lord. But this was disputed by the political college, my lord, government political college.
You are held to be in possession of 3 acres 16 gunta.
ಅವರು ಇರೋದು ನಾವಿರೋದು 3 acre 16 ಗುಂಟ ಮಾತ್ರ, ರಿಮೈನಿಂಗ್ 3 acre 10 ನಾವಿದೇವೆ ಅಂತ ಹೇಳ್ತಾರೆ ಪಾಲಿಟೆಕ್ನಿಕಲ್ ಕಾಲೇಜ್ ಔಟ್ ಆಫ್ 6 acre 25 ಗುಂಟ. So this is the situation, my lord. So next question arises again, my lord. Annexure D prakara, the government political college filed an appeal, my lord, before the AC, assistant commissioner. So assistant commissioner dismissed the appeal, my lord. Thereafter, they filed as per the thereafter they approved before the DC, my lord. DC remanded the matter, my lord. Adu I'm searching, my lord. Annexure D.
Annexure K.
No, adu subsequent after remand ide, my lord. DC remanded the matter to the assistant commissioner, my lord, as per annexure.
Annexure H.
Yes, sir, H, my lord. As per annexure, matter was remanded to the assistant commissioner, my lord. And as per annexure J, my lord, assistant commissioner passed the order. And assistant commissioner said, my lord, the order of the Tahsildar is set aside. And this is the property of the government political college anta ಅವರು ಹೇಳಿದ್ರು. ಇದು work property ಬರಲ್ಲ ಅಂತ ಅವರು ಹೇಳಿದ್ರು.
So that was challenged by you.
That was challenged by before the DC, my lord. As per annexure K, my lord. DC also dismissed my appeal, my lord. So
On what basis this assistant commissioner say it is not work property?
So assistant commissioner said, my lord, this 3 acre 10 gunta was acquired by the government in the year 1979. Therefore, subsequent to whatever the
Why don't you read the order passed by the assistant commissioner?
Yes, my lord. Page 53, my lord.
Yes.
Sadri Badita Astyu, re-survey number 637A/1A, Kshetra, 3 acre 29 gunta. Square yard. ಮೇಲ್ಮನವಿದಾರರ ಹಕ್ಕು ಬಾಧ್ಯಸ್ಥಿಕೆ ಕೋರಿರುವ ಕ್ಷೇತ್ರ ಈ ಪ್ರಾಧಿಕಾರದ ಭೂ ಸ್ವಾಧೀನ ವಿಭಾಗದಿಂದ LAQ SR 740A ವಿಜಯಪುರ ದಿನಾಂಕ 27/2/1979 ರನ್ವಯ 1/10/2073 27/2/1979 ಭೂ ಸ್ವಾಧೀನತೆಯ ಎಲ್ಲಾ ಕ್ರಮಗಳನ್ನು ಜರುಗಿಸಿ ಸದರಿ ಬಯಲು ಜಾಗೆ ಅಂಡ್ ವಿಸ್ತರಿಸಿದ ಕಾಲಂಗಳಿಗೆ ಪ್ಲೇಗ್ರೌಂಡ್ ಅಂಡ್ ಶೇಲ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಪಾಲಿಟೆಕ್ನಿಕ್ ಬಿಲ್ಡಿಂಗ್ ಐತೀರ್ಪು ರಚಿಸಿ 31/10/1998 ಕಬ್ಜಾ ಪಡೆದುಕೊಳ್ಳಲಾಗಿದೆ. ಅದರಂತೆ ವಹಿವಾಟು ಮಾಡುತ್ತಾ ಬರಲಾಗಿರುತ್ತದೆ. ನೆಕ್ಸ್ಟ್ ಮಿಲೋಡ್ ಅದರಂತೆ ಸದರಿ ಎದುರುದಾರರು ಪ್ರಸ್ತುತ ಭೂ ಸ್ವಾಧೀನತೆಯ ಕಲಮು 4161 ಅಧಿಸೂಚನೆ ಮತ್ತು ತೀರ್ಪುಗಳ ಕುರಿತು ಪ್ರಶ್ನಿಸಿ ಎಲ್ಲಿಯೂ ಯಾವುದೇ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರದಲ್ಲಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ ಮತ್ತು ಭೂ ಸ್ವಾಧೀನತೆಯ ಪ್ರಾಧಿಕಾರ ಹಂತ 4161 ಅಧಿಸೂಚನೆ ತಕರಾರು ಆಕ್ಷೇಪಣೆಗಳನ್ನು ಸಹ ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. ಸದರಿ ಮೇಲ್ಮನವಿದಾರರ ಮುಖ್ಯಸ್ಥರಾದ ನಿರ್ದೇಶಕರು ತಾಂತ್ರಿಕ ಶಿಕ್ಷಣ ಮಂಡಳಿ ಕರ್ನಾಟಕ ಸರ್ಕಾರ ಬೆಂಗಳೂರು ಸದರಿ ಸ್ಥಳವನ್ನು ಗುರುತಿಸಿ ಭೂ ಸ್ವಾಧೀನತೆ ಪಡಿಸಿಕೊಂಡು ಸಲ್ಲಿಸಿದ ಪ್ರಸ್ತಾವನೆ ದಿನಾಂಕ 30/12/1970 ಪೂರ್ವದಲ್ಲಿ ದರ್ಗಾ ಹಜರತ್ ಗೈಬೂಬ್ ಸಾಬ್ ದರ್ಗಾ ಇವರ ಅಥವಾ ಇವರ ಪರವಾಗಿ ಮುತಾವಲ್ಲಿ ಸ್ವಾಧೀನದಲ್ಲಿ ಹೆಸರಿಗೆ ಇತ್ತು ಎನ್ನುವ ಬಗ್ಗೆ ಯಾವುದೇ ಸಮರ್ಥನೀಯ ದಾಖಲೆಗಳನ್ನು ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. ಸದರ್ ಎದುರುದಾರರು ಪ್ರಸ್ತುತ ಆಸ್ತಿ ಭೂ ಸ್ವಾಧೀನತೆಯ ಅತೀರ್ಪು ದಿನಾಂಕ 27/2/1979 ಅಥವಾ ತಾಂತ್ರಿಕ ಶಿಕ್ಷಣ ಮಂಡಳಿ ಸ್ಥಳ ಗುರುತಿಸಿ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸಿದ ದಿನಾಂಕ 30/12/1970 ಪೂರ್ವದಲ್ಲಿ ವಫ್ ಆಸ್ತಿ ಎಂದು ಸ್ಥಳ ಮೋಜಣಿಯ ಬಗ್ಗೆ ಗಡಿ ಗುರುತಿಸಿದಂತೆ ವಫ್ ಮಂಡಳಿಯಿಂದ ಹಾಗೂ ರಾಜ್ಯ ಸರ್ಕಾರದ ವಫ್ ಇಲಾಖೆಯಿಂದ ಅನುಮೋದನೆ ಪಡೆದುಕೊಂಡ ರಾಜ್ಯ ಪತ್ರದಲ್ಲಿ ಪ್ರಕಟಿಸಿರುವ ಪ್ರಸ್ತಾವ ದಾಖಲೆಗಳನ್ನು ಕುರುಹುಗಳನ್ನು ಇರುವ ಬಗ್ಗೆ ಹಾಜರುಪಡಿಸಿರುವುದಿಲ್ಲ. ಅಲ್ಲದೆ ಸದರಿ ಎದುರುದಾರರು ವಿವಿಧ ನ್ಯಾಯಾಲಯಗಳಲ್ಲಿ ದಾಖಲಿಸಿರುವ ದಾವಾ, ರಿಟ್ ಪಿಟಿಷನ್, ಮೇಲ್ಮನವಿ, ಭೂ ಸ್ವಾಧೀನತೆ, ಕಬ್ಜಾ ವಹಿವಾಟು, ಬಾಧಿತ ಆಸ್ತಿ ಕಬ್ಜಾ ವಹಿವಾಟು ಅಂತ ಯಾವುದೇ ನ್ಯಾಯಾಲಯಗಳಲ್ಲಿ ಹಕ್ಕು ಬಾಧ್ಯತೆ ಆದೇಶವಾಗಿರುವ ಕಂಡು ಬರುವುದಿಲ್ಲ. ಮೇಲ್ಮನವಿದಾರರು ರಾಜ್ಯ ವಫ್ ಮಂಡಳಿ ಪ್ರಕಟಿಸಿದ ರಾಜ್ಯ ಪತ್ರ ಪ್ರಕಟಣೆ 11/8/1988 ಅಧಿಸೂಚನೆ ನಂಬರ್ KT so and so 1986-87 ಅನ್ವಯ ಕ್ಷೇತ್ರ 16 ಎಕರೆ 25 ಗುಂಟೆ ಅಧಿಸೂಚನೆ ರಾಜ್ಯ ಪತ್ರದಲ್ಲಿ ಪ್ರಕಟಣೆ ದಿನಾಂಕ 13/7/2006 ತಿದ್ದುಪಡಿ ಅಧಿಸೂಚನೆ ಕ್ಷೇತ್ರ 6 ಎಕರೆ 25 ಗುಂಟ ನೇದುಗಳಿಗೆ ಬಾಧಿತರಾಗಿ ಸಂಬಂಧಿಸಿದ ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರದಲ್ಲಿ ಪ್ರಶ್ನಿಸಿರುವುದಿಲ್ಲ. These are the findings now.
Correct. If the land is already acquired in 1979.
This, I agree, my lord. This document 1979 referred in the first time before the AC, my lord. In the earlier disputes before the Waqf tribunal and before the authorities, my lord, this document not came into force, my lord. Ellinu idar bagge refers madilla, my lord. And whether it is a same property or adjoining my property, this was not clarified. And extent of the total acre is 18 acres, my lord. 911A is the total 18 acres. Out of 18 acres, some lands were acquired and only remains, my lord.
Please read paragraph 50, page 55.
Page 55.
Page 55, beginning of page
Yes, my
55,
lord.
please read.
ಕಂದಾಯ ದಾಖಲಾತಿಯಲ್ಲಿ ವಫ್ ಆಸ್ತಿ ಅಂತ ದಾಖಲಾಗಿದ್ದರೂ ಕೂಡ ಕ್ಷೇತ್ರ ನಮೂದಿಸಿರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಅರ್ಜಿದಾರರ ಕ್ಷೇತ್ರ ನಮೂದಿಸಿಲ್ಲ. ಅರ್ಜಿ ಕೋರ್ಟ್ಗೆ
ಅರ್ಜಿ ಕೊಟ್ಟಾಗ ಎದುರುದಾರರಿಗೆ ನೋಟಿಸ್ ನೀಡಲಾಗಿ ಅವರು ತಕರಾರು ಮಾಡಿದ್ದರಿಂದ RTS CR ಅಂತ ಮಾನ್ಯ ತಹಸೀಲ್ದಾರ್ ವಿಜಯಪುರ ಇವರಲ್ಲಿ ಪ್ರಕರಣ ದಾಖಲಾಗಿದ್ದು ಇರುತ್ತದೆ.
ಎಸ್ ಸರ್,
ಓದಿ.
ಇರುತ್ತದೆ. ಸದರ್ ಪ್ರಕರಣವನ್ನು ವಿಚಾರಣೆ ಮಾಡಿ ಸರ್ವೆ ನಂಬರ್ 911 ಅದಕ್ಕೆ ಸಿಟಿ ಸರ್ವೆ ನಂಬರ್ 63/A ಅಂತ ಕೊಡಲಾಗಿದ್ದು, ನೇದಲ್ಲಿ ಹಜರತ್ ಪೀರ್ ಗೈಬೂಬ್ ಸಾಬ್ ದರ್ಗಾ ಅಲ್ಲದೆ ಸರ್ಕಾರಿ ಪಾಲಿಟೆಕ್ನಿಕಲ್ ಕಾಲೇಜ್ ವಿಜಯಪುರದವರ ಕಟ್ಟಡ ಇರುವುದನ್ನು ಗಮನಿಸಿದ್ದರು ಮತ್ತು ದಿನಾಂಕ 16/9/1986 ವಫ್ ಸರ್ಟಿಫಿಕೇಟ್ ನಲ್ಲಿ ಬರೆಯದೆ ಸಿಟಿ ಸರ್ವೆ ನಂಬರ್ 637A/1A ಕ್ಷೇತ್ರ 6 ಎಕರೆ 25 ಗುಂಟ ಅಂತ ತೋರಿಸಲಾಗಿದ್ದು, ಈ ಕಾರಣಕ್ಕಾಗಿಯೇ ದಿನಾಂಕ 4/2/2006 ಕೋರಿಜೆಂಡಂ ಪ್ರಕಟಿಸಿ ಸರ್ವೆ ನಂಬರ್ 911 ಅಂತ ತೋರಿಸಲಾಗಿದೆ ಮತ್ತು ಅರ್ಜಿದಾರರನ್ನು ವಫ್ ಮುತಾವಲಿ ಅಂತ ಪ್ರಕಟಿಸಲಾಗಿದೆ ಅಂತ ತಿಳಿಸಿದ್ದಾರೆ. ಸದರಿ ಸರ್ವೆ ನಂಬರ್ 911 ದಲ್ಲಿ ಮಾನ್ಯ ಡೆಪ್ಯೂಟಿ ಸೆಕ್ರೆಟರಿ ಕಂದಾಯ ಇಲಾಖೆಯವರು ಆದೇಶ ನಂಬರ್ RD so and so 2001 ರಂತೆ ಮಾನ್ಯ ಸ್ಪೆಷಲ್ ಆಫೀಸರರು ದಿನಾಂಕ 17/5/2005 ಮೋಜಣಿ ಮಾಡಿ PT ಶೀಟ್ ತಯಾರಿಸಿರುತ್ತಾರೆ. ಈ ಎಲ್ಲ ವಿಷಯಗಳನ್ನು ಮತ್ತು ದಾಖಲೆಗಳನ್ನು ಪರಿಗಣಿಸಿ ಮಾನ್ಯ ತಹಶೀಲ್ದಾರ್ ವಿಜಯಪುರ್ ಇವರು ದಿನಾಂಕ 1/3/2011 ಆದೇಶವನ್ನು ಮಾಡಿ ಸದರಿ ಜಮೀನು ಅಳತೆ ಮಾಡಿ ಮೋಜಣಿ ದರ್ಗಾ ಕ್ಷೇತ್ರ 3 ಎಕರೆ 16 ಗುಂಟೆ ಇದಕ್ಕೆ ಪಿಟಿ ಶೀಟ್ ತಯಾರಿಸಿರುವುದಾಗಿ ತಿಳಿಸಿದ್ದಾರೆ. ಆ ಪಿಟಿ ಶೀಟಿನ ಪ್ರಕಾರ ಮಾನ್ಯ ತಹಶೀಲ್ದಾರ್ ವಿಜಯಪುರ್ ಅವರ ಆದೇಶದ ಪ್ರಕಾರ ಸರ್ವೆ ನಂಬರ್ 911ರಲ್ಲಿ ಮೇಲೆ ಹೇಳಿದ ಚಕ್ಬಂದಿ ಮಧ್ಯದಲ್ಲಿಯೇ 3 ಎಕರೆ 16 ಗುಂಟೆ ಹಜರತ್ ಪೀರ್ ದರ್ಗಾ ವಫ್ ಅವರ ಹೆಸರು ದಾಖಲಿಸಲು ಆದೇಶ ಮಾಡಿದರ ಪ್ರಕಾರ ಪಿಟಿ ಶೀಟಿನಲ್ಲಿ ಸೋ ಅಂಡ್ ಸೋ ಅಕ್ಷರಗಳಲ್ಲಿ ತೋರಿಸಿದ ಬುಕ್ಗೆ ದಾಖಲಿಸಲು ಆದೇಶ ಮಾಡಿದ್ದರ ಪ್ರಕಾರ ಸೋ ನಂಬರ್ ದಿನಾಂಕ 2011ರಂತೆ ಕಂದಾಯ ಇಲಾಖೆಗಳಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಲಾಯಿತು. ತಹಶೀಲ್ದಾರ್ ವಿಜಯಪುರ್ RTF ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ರಲ್ಲಿ ಮಾಡಿದ ಆದೇಶದ ವಿರುದ್ಧ ಎದುರುದಾರರು ಉಪವಿಭಾಗಾಧಿಕಾರಿ ವಿಜಯಪುರ ಇವರಲ್ಲಿ ಮೇಲ್ಮನವಿ RTS ಸೋ ಅಂಡ್ ಸೋ 2014ರಂದು ಅಂಗೀಕರಿಸಿ ಆದೇಶಿರುತ್ತಾರೆ. ಸೋ ಅಂಡ್ ಸೋ ದರ್ಗಾ 3 ಎಕರೆ 16 ಗುಂಟೆ ಜಮೀನದಲ್ಲಿ ಕ್ಷೇತ್ರದಲ್ಲಿ ಮಾಡಿದ ಪ್ರಾರಂಭದಲ್ಲಿ ಮಾನ್ಯ ಹೆಚ್ಚುವರಿ ಸಿವಿಲ್ ಜಡ್ಜ್ ಮತ್ತು JMFC ವಿಜಯಪುರ ಅಸಲ್ ದಾವಾ ನಂಬರ್ 2014 ದಾಖಲೆ ಮಾಡಿದ್ದು ಅದರಂತೆ ಡಿಕ್ರಿ ನೀಡಿದ್ದು ಇರುತ್ತದೆ. ಅದೇ ರೀತಿ ಅರ್ಜಿದಾರರ 2006ರಲ್ಲಿ ಎದುರುದಾರರ ವಿರುದ್ಧ ದಾವಾ ಆಸ್ತಿ ಕೂಡ ನಿಶ್ಚಿತ ಆದೇಶ ಕೋರಿ ವಫ್ ಟ್ರಿಬ್ಯುನಲ್ ಬೆಲ್ಗಾಂದಲ್ಲಿ ದಾವಾ ನಂಬರ್ 2006 ನೇದನ್ನು ದಾಖಲಿಸಿದ್ದು ಅದು ದಿನಾಂಕ 30/9/2010ರಂದು ವಜಾಗೊಂಡಿರುತ್ತದೆ. ಸದರ್ ಹಕ್ಕುವಿನ ವಿರುದ್ಧ ಅರ್ಜಿದಾರರು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಕಲಬುರಗಿ ಪೀಠದಲ್ಲಿ ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ 83/824/2010 ನೇದನ್ನು ದಾಖಲಿಸಿದ್ದು ಅದು ಕೂಡ ರದ್ದಾಗಿರುತ್ತದೆ ಅಂತ ತಿಳಿಸಿದ್ದಾರೆ. ಈ ನಂತರ ಅರ್ಜಿದಾರರು ರಿಟ್ ಅಪೀಲ್ ನಂಬರ್ 2,135/2015 ವಫ್ ನೇದನ್ನು ಸದರ್ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ದಾಖಲಿಸಿದ್ದು ಅದು ಕೂಡ ವಜಾಗೊಂಡಿದ್ದು ಅದರಲ್ಲಿ ತಹಶೀಲ್ದಾರ್ ನೀಡಿದ ರಿಪೋರ್ಟ್ ಪ್ರಕಾರ ಅರ್ಜಿದಾರರು ಸರ್ವೆ ನಂಬರ್ 911 ನೇದರಲ್ಲಿ 3 ಎಕರೆ 16 ಗುಂಟೆ ಜಮೀನಕ್ಕೆ ಕಬ್ಜೆಯಲ್ಲಿದ್ದಾರೆ. ಆ ದಾಖಲಾತಿ ಮೇಲೆ ಅವಲಂಬಿಸಿ ಎದುರುದಾರರು ಅಥವಾ ಬೇರೆ ಯಾರಾದರೂ ವಫ್ ಬಗ್ಗೆ ಉಂಟು ಮಾಡಿದ್ದರೆ ಕ್ರಮ ಕೈಗೊಳ್ಳಬಹುದು ಅಂತ ಹೇಳಿದ್ದು ಇರುತ್ತದೆ. ಆ ಅವಧಿಯಲ್ಲಿ ಎದುರುದಾರರು ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ವಿಜಯಪುರ ಇವರಲ್ಲಿ RTS ರಿವಿಷನ್ 2014-15 ನೇದನ್ನು ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳ ಆದೇಶ ನಂಬರ್ 20 ವಿರುದ್ಧ ದಾಖಲಿಸಿದ್ದು ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಸದರ್ ರಿವಿಷನ್ ಪ್ರಕರಣವನ್ನು
You had filed a suit before the tribunal.
Yes,
What happened to that?
for injunction, my lord, against the political college. In that suit, my lord, that was not decided on merits, my lord. So
But
that
you
was
also,
dismissed, my lord. I have not made a work board as a party anta dismissed ಮಾಡಿದ್ದು, my lord. And I have not obtained a certificate from the WAF on the ground. Thereafter, I filed the writ petition before before this honorable court. And I also produced some documents, my lord. I have obtained the permission from the WAF board, my lord. So my writ petition dismissed before the division bench. I produced certain documents, my lord. Documents are accepted, my lord, and matter was disposed of. And already joint measurement was done, my lord. 3 acre 16 gunta, I am in possession, not in 6 acre 25 gunta, my lord. So I remained in 3 acre 16 guntas. Thereafter, appeal is filed back. So now dispute, the political, earlier they have not raised any dispute, my lord. They have not challenged the corrigendum, not challenged the notifications, my lord. Though as per the act, my lord, if it is a registered work, my lord, only it can be decided by the tribunal only, my lord. Making it, it's okay, my lord. But so far as a dispute raises, my lord, other declaration required, my lord. Earlier, I am not seeking declaration relief because there is no dispute, my lord. When they are entering my property, my lord, I sought for injunction suits. That was also not disposed of on merits, my lord. Now question raises, my lord, only when they filed appeal, my lord, before the AC. And regarding acquisition, my lord, first time they have produced the copy before the AC when matter is remanded second time. In the earlier suit, my lord, they have not produced any document, my lord. So now dispute regards the subject matter, my lord, between two parties. So this can be decided before only tribunal, my lord. And liberty may be granted to both the parties, my lord, under section 85 of the WAF Act, my lord. If such kind of disputes, even revenue authority also no
But
power.
please tell us, now this whole proceedings have taken so many shapes. Now, after the suit filed by you before the.
One is I filed against private persons, my
Please
lord.
wait. Let
That
me-
was decreed, my lord.
Please correct me if I'm wrong.
Yes,
You went to the you went to the tribunal for injunction respect of 6 acres, 25 guntas.
yes, my lord.
That was dismissed,
Dismissed.
confirmed by this court
Yes, my lord.
in a writ petition.
Dismissed not on merits, my lord.
Correct. It was confirmed by this court.
Thereafter approved before the.
Thereafter, there was a survey. Tahsildar says you are not in possession of 6 acres, 25 guntas. You are in possession of 3 acres, 16 guntas.
Yes.
So writ appeal was also dismissed recording that fact.
Disposed of regarding that facts.
Yeah, writ appeal was
Appeal
dismissed.
I have produced, my lord, copy. My additional document also allowed, my lord.
Correct. Writ appeal was dismissed
Yeah.
recording the above fact.
Page number
48.
44, sixth paragraph.
Subject to the aforesaid observations, writ appeal is dismissed as we find no infirmity in the order of the learned single judge vis-a-vis the fact that 6.25 acres of land not being in the possession of the appellants herein. So the division bench noted
Yes, my lord.
that the Tahsildar has given a report saying that you are in possession of 3 acres,
3 acres.
16 guntas. Correct?
Yes.
Now, they have filed an appeal before the deputy commissioner,
Yes, my lord.
assistant commissioner.
Assistant commissioner.
Assistant commissioner, he dismissed it.
Yes, my lord.
They went to the deputy commissioner.
Deputy
Deputy commissioner has found that there are some acquisition proceedings
Yes, my
and therefore he allowed it
lord. Yes, my lord.
and remitted the matter back to the assistant commissioner for reconsideration.
Yes,
Assistant commissioner has confirmed
confirm.
that there is an acquisition
Yes.
which you are challenged and you are lost. Please tell us, is there no acquisition of your property or not?
My lord, this is a CTS number, my lord, this is a 6, sorry,
Ishtalla admele, why should it again go back to some tribunal and
I will.
why should the litigation be kept pending?
I will clarify. There is a total 6 acre 25 guntas, my lord.
Total, what is the survey number?
Survey number, my lord, 911 A, my lord. Total
911.
18 acres, my lord.
911,
911 A of Mahal Bagait, Vijaipur. Total extent is 18 acres, my lord, as per Annexure B, my lord.
18 acres.
Thereafter, some acquisition postings happened, my lord, only remains 11 acres, 11 guntas, my lord. Now, after acquisition.
After acquisition.
Huh.
So what is acquired?
Ambale, thereafter, what happened, my lord? Out of that, my lord, thereafter, again, acquisition was in the year 1979. Our prakara 3 acre 10 gunta, 1959 order, AC order prakara, my lord.
3 acre 10 gunta.
10 gunta.
was
In
acquired.
now possession, I was in possession, my lord, 6 acre 25 gunta. Out of 11 acre, my lord. ಈಗ ಅವರು 3 acre 10 ಗುಂಟ ಹೋದ್ರೆ ಓನ್ಲಿ ರಿಮೇನ್ಸ್ 3 acre 15 ಗುಂಟ ಉಳಿಯುತ್ತೆ ಮೇಲೆ ಲ್ಯಾಂಡ್. ಈಗ ನಮ್ದು ಅಷ್ಟೇ ಇದೀವಿ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ, ಜಾಯಿಂಟ್ ಮೆಜರ್ಮೆಂಟ್ ಮಾಡಿದ್ರು, ಇದು ನಮ್ದು ಅಂತ ಹೇಳಿದ್ರು, ಇದು ನಮ್ದು ಅಂತ ಓಪನ್ ಇದೆ ಮೇಲೆ ಸೈಟ್. ಅವ್ರು ಆಲ್ರೆಡಿ ಅದು ಎಕ್ವೈರ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಲ್ಯಾಂಡ್. ಈಗ ನಾವು ಪಾಲಿಟೆಕ್ನಿಕಲ್ ಈಸ್ ಮೋರ್ ದೆನ್ 20 acre ಅವ್ರ ಪೊಸಿಷನ್ ದಲ್ಲಿ ಇದ್ದಾರೆ ಮಿಲಾಡ್.
That's okay.
ಈಗ ಡಿಸ್ಪ್ಯೂಟ್ ಮಿಲಾಡ್ ವೆದರ್ ದ ಒನ್ ರೇಜಸ್ ಮಿಲಾಡ್ 6 out of 6 acre 25, 3 acre 10 gunta was the political and remaining 3 acre 16 gunta was Dargah, or the property are one and the same anantadu not clarified, my lord.
Yes.
And this was the very dispute, my lord. And next question, my lord, regarding the total extent, my lord, AC did not mention total extent of the land.
No, please tell us. Out of these 18 acres, you said after acquisition 11 acres, 11 guntas remained.
Remains.
Acquisition.
Out of the 11 acre, again, my lord, some
acquisition agide yavaga?
79, my lord.
1979.
63 go acquisition agide, my lord, 2 acres land, my lord. Polytechnic acquired 2 acres in this survey number. ಅದಾದ ಕೂಡ 11 acre ಉಳಿತು, my lord. Then ಅವ್ರು ಏನ್ ಮಾಡಿದ್ರು, 3 acre 10 gunta was acquired in 1979, my lord. This document came into force now, my lord. ನಮ್ದು 6 acre 25 ಇತ್ತು, ಈಗ ಅವ್ರು ಬಂದ ತಕ್ಷಣ ನಮ್ದು 3 acre 16 gunta ಉಳಿತು ನಮ್ದು. ಸೊ ಈಗ ಏನಂತಾರೆ, ಇದು ಎಂಟೈರ್ ಲ್ಯಾಂಡ್ ನಮ್ದಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ, ಇದು ಉಳಿದಿದ್ದ ಲ್ಯಾಂಡ್ ನಮ್ದಂತ ನಾವ್ ಹೇಳ್ತಿದ್ದೆ. ಅವ್ರು ಆಲ್ರೆಡಿ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿದ್ದಾರೆ. 20 acres ದೇ ಆರ್ ಇನ್ ಪೊಸಿಷನ್. ಗೌರ್ಮೆಂಟ್ ಪೊಲಿಟಿಕಲ್ ಕಾಲೇಜ್ ನಾವು ಟೋಟಲ್ 20 acres ಇದ್ದಾರೆ.
ಹೆಂಗೆ ಸರ್ವೆ ನಂಬರ್
ಅವ್ರೆಲ್ಲ ಬೇರೆ ಬೇರೆ ಸರ್ವೆ ನಂಬರ್ ಎಕ್ವೈರ್ ಆಗಿದೆ ನೋಡಿ ಪಕ್ಕದಷ್ಟು. ಅವ್ರು ಇರೋದು ಟೋಟಲ್ 20 ಎಕರೆ ಇದ್ದಾರೆ. ಸೊ ಇದನ್ನು ಕೂಡ ಚೆಕ್ ಬಂದಿ ಪ್ರಕಾರ ನಮ್ದು ಓಪನ್ ಸೈಟ್ ಇದೆ. ಅವ್ರದ್ದು ಏನು ಓಪನ್ ಬಿಟ್ಟಿದ್ದಾರೆ ಎಕ್ವೈರ್ ಮಾಡ್ಬೇಕಾದ್ರೆ 1979 ಆರ್ಡರ್ ದಲ್ಲಿ ರಿಮೈನಿಂಗ್ ಪೋರ್ಷನ್ ಆಫ್ CTS ನಂಬರ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಎಷ್ಟಂತ ಹೇಳಿಕ್ ತಯಾರಿಲ್ಲ ಬಿಲೋಡ್ ಆ ಚೆಕ್ ಬಂದಿಯಲ್ಲಿ. ಬಟ್ ನಾವು ಇಟ್ಟು ನಮಗೆ ಉಳಿದಿದ್ದು ಇಷ್ಟೇ ಅಂತ ಮೆಜರ್ಮೆಂಟ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ದಾರೆ. ನಾವು ಕ್ವಶನ್ 6 acre 25 ಹೋಯ್ತು, 3 acre 16 ಗುಂಟ ಅಂತ ಹೇಳಿದ್ರು. ನಾವು ಇದನ್ನು ಕೂಡ ನಮ್ದೇ ಬರುತ್ತೆ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ. ಸೊ ದೇರ್ ಆರ್ ನೋ ಕ್ಲಿಯರ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಮಿಲಾಡ್. ಇದು ಫಸ್ಟ್ ಟೈಮ್ AC ಮುಂದೆ ತಂದಿದ್ದಾರೆ ಇದು ಡಾಕ್ಯುಮೆಂಟ್. ಅಂಡ್ ಅದರ್ ನೋ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಆರ್ ದೇರ್. ಅಂಡ್ ವಾಟ್ ಆರ್ ದ ಟೋಟಲ್ ಎಕ್ಸ್ಟೆಂಟ್ ಆಫ್ ಲ್ಯಾಂಡ್ ಅಂತ ಹೇಳಿಕ್ ತಯಾರಿಲ್ಲ. ಅವ್ರದ್ದು ಎಷ್ಟು ಹೋಯ್ತು, ರಿಮೈನಿಂಗ್ ಎಷ್ಟು ಉಳಿತು, ನಾಟ್ ಕ್ಲಾರಿಫೈಡ್ ಬೈ ದ AC. So under such situation, and section 85 prakara, if it's a dispute milord regarding the work property, it can be decided by only tribunal anta. So full-fledged trial is required milord for this issue. Only making mere entry is not sufficient for this dispute milord. They have to produce some our the document ide namde enide total.
Anyway, now the court has said that you are not in possession of 6 acres 25 guntas.
Only remains 3 acre. We even
No, let us
we got to
assume.
protect 3 acre 16.
Let us assume that somebody else is in possession of work property.
Some ಇಲ್ಲ milord ಅವರೇ
I
ಪೊಲಿಟಿಕಲ್
think
ಅದೇ
Polytechnic College is-
ಅವರು ಇದ್ದಾರೆ 3 acres ನ
You-
ಪೊಲಿಟಿಕಲ್
someone else is in possession of work property. The Polytechnic College,
ಅದು 3 ಅವರೇ ಈ ಪೊಲಿಟಿಕಲ್ ಕಾಲೇಜ್ ಇದೆ, ಬೇರೆ ಯಾರು ಇಲ್ಲ.
as per your annexure A,
ಹಾ ಸರ್,
the total extent which is notified is 6 acres 25 guntas.
25 gunters.
Now Tahsildar says it is, you are in possession of 3 acres 16
only
guntas.
ಅಂತ ಹೇಳಿ.
So Mikkid 3 acre 10 guntas is in possession of the government
Government
Polytechnic College. Now let us see what the Waqf board says as to how to recover property in possession of others.
ನಮ್ಗೆ ರಿಕವರಿ ಬೇಡ ಮಿಲಾಡ್, ನಮ್ದಾದ್ರೂ ಉಳಿಸ್ಕೋಬೇಕಂತ. 3 acre 16 ಆದ್ರೂ ಉಳಿಸ್ಕೋಬೇಕಲ್ಲ.
Yes.
They are claiming this property also. Open site ಇದೆ ಇದು ದರ್ಗಾ ಮುಂದೆ.
Government,
I'll secure restriction because as per survey, 3 acre 10 gunta we have acquired and we are utilized for Polytechnic College. Remaining with the Dargah only, man.
no, but remaining now the Tahsildar has prepared a map. And he says 3 acres 16 guntas can be registered in the name of the Waqf.
Yes,
So why you can't give effect to that?
it can be given.
Now, how can you challenge even this 3 acres 16 guntas also?
No, only 3 acre 10 gunta we can claim.
3 acre 10 guntas, they also don't have objection. They are saying, take the 3 acre 10 guntas. Tahsildar now says it is 3 acre 16 guntas in which they are in possession. ಅದನ್ನ ಮಾಡ್ಕೊಡಿ ಅಂತ ಅವ್ರು ಕೇಳ್ತಿರೋದು.
ಈಗ ಅವ್ರೇನ್ ಮಾಡಿದಾರೆ ಮೇಡಮ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಅದನ್ನು ತಗೊಂಡಿದ್ದಾರೆ. ಇದನ್ನು ಅಕ್ವಿಸಿಷನ್ ಆಗಿದ್ದೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ 1979. ಇದು ಡಬಲ್ ಎರಡೂ ನಮ್ದೇ ಅಂತಿದ್ದಾರೆ.
ಕೊಡಿ,
ಡಿಸ್ಪ್ಯೂಟ್ ಸ್ಟಾರ್ಟ್.
give the particulars of land which is acquired in the survey number.
Yes.
ಬರ್ಕೊಳ್ಳಿ. After hearing the counsel for the petitioner, comma, this court is of the opinion that the area acquired for the purpose of respondent number, sole respondent, huh?
One sole.
The area
One.
acquired for the purpose of respondent has to be ascertained.
Respondent one number one. I am two.
Respondent number one has to be ascertained. The learned AG is therefore directed to secure instructions as to the total extent of land in survey number 911/*A that was acquired for the respondent number 1. Hence list on yavat 11th February.
ಈಗ ಅವ್ರು ಏನಂತಿದ್ದಾರೆ ಮಿಲಾಡ್, ಈ ಓಪನ್ ಇದ್ದಿದ್ದೇ ಅದೇ ಅಂತ ಮತ್ತೆ ಬಂದಿದ್ದಾರೆ ಶಿವ್ಲಿ. ನಾವು ಮಿಲಾಡ್ ಇಫ್ ಡಿಸ್ಪ್ಯೂಟ್ ಸ್ಟಾರ್ಟ್ ಮಿಲಾಡ್ ಇಟ್ ಕ್ಯಾನ್ ಬಿ ಡಿಸೈಡ್ ಬಿಫೋರ್ ದ ಟ್ರಿಬ್ಯುನಲ್. Full
Let us
trial
see.
required milord.
So many levels of litigation has ensued. You've gone to civil court, you've gone to tribunal, you come to this court, division bench, then AC, then DC, then AC, then DC.
Bare injunctions in respect of 6 acre. 6 acre if it are not proved, 3 acres ಆದ್ರೂ ಉಳಿಸ್ಕೋಬೇಕಂತ.
Yes, we'll consider. Ms. R.S. Siddhapurkar,
Please.
Mr. Kadlur Satyanarayana Acharya, Gaurish Kashampur. Ready now?
I appear for my friends to Gaurish Kashampur.
ನೀವು ಇಲ್ಲಿ ಬರ್ಬೇಕು. You are for the respondent.
In one case, I am the petitioner.
Ha.
Another case filed by him, I am respondent.
Yes. Yes, please. Ready now? Both
Yes,
of you
yes.
ready?
Producing document, my lord.
Ready.
Application filed by the petitioner for grant of occupancy rights under the certain Norm Abolition Act. The extended period. The facts of this case are that, my lord,
You are not earlier, you are not filed the application.
already filed.
ಮತ್ತೆ ಇನ್ನೊಂದ್ಸತಿ ಯಾಕೆ ಮಾಡಿದ್ರಿ?
ಅಲ್ಲ, extended period ಅಲ್ಲಿ ಮೊದಲು ಹಾಕಿರ್ಲಿಲ್ಲ.
ಮೊದಲು ಹಾಕಿರ್ಲಿಲ್ಲ.
That was not filed.
Hmm.
These lands are the coming under the certain Inams Abolition Act, certain Inams of Madiga Inam. And one Lakshaya, the father of petitioner, was the Inamdar. The respondent number 4 to 7 were nothing to do with the family of the
Referring to which petition? First petition?
first petition 225871.
22587. You are referring to that petition?
Yes, ma'am.
The father of the petitioner?
Lakshaya,
Lakshman Rao.
Lakshya, son of Narsya, was the Inamdar.
ಇದು ಲಕ್ಷ್ಮಣ್ ರಾವ್ ಅಂತಿದೆ. Petitioner is Gauramma.
Gauramma.
Daughter of Lakshman Rao.
Lakshman Rao ಅಂತಾಗಿರೋದು. Lakshya, actually original name. And his name appears in the Khasra Pani in Inam Patrak. That being the fact, suddenly in the year 2004, respondent number 4 to 7 started interfering in the possession. Therefore, the petitioner and her mother filed a suit OS number 158 of 2004 that the trial court held that it is pertaining to Inam land that injunction cannot be granted. Therefore, during the proceedings of that suit, the petitioner and her mother came to know about the illegal transaction that have been entered into by some third person in the name of the respondent number 4 to 7. The person so named have nothing to do with the family of the properties, family of the petitioners. Therefore, the petitioner and her mother filed an application before the Assistant Commissioner challenging the alienation, stating that it is hit by a PTCL Act. That application was allowed by the Assistant Commissioner. That order was challenged by the respondent 4 to 7 before the
What did the Assistant Commissioner do?
Lordship.
What did the Assistant Commissioner do?
Commissioner allowed the application.
He allowed. Where is
And that application was, that order was challenged by the respondent 4 to 7 before the Deputy Commissioner. And the Deputy Commissioner allowed the appeal and also called for the report from the Tahsildar as to the nature of the lands and Inam. That order was challenged by both this petitioner and respondent number 4 to 7 in the writ petition, in writ petition number 19952 of 2007, and that which came to be allowed at which is an annexure E, my lord. Later on, in the side proceedings, it has observed that Lakshmaya was the only Inamdar and this purchaser, the vendor, so-called vendors of respondent number 4 to 7 have nothing to do with the family of the petitioner, and therefore it matter was remanded. What was held is that at that stage, Tahsildar gave a report, and that report was directly as against that report. Whole submission. Yes. Yes. Tahsildar submitted a report as per Annexure K, my lord. Observation that scheduled properties are Madiga Inam lands and there is no application pending seeking re-grant of the lands. And in the genealogy of the family of this petitioner, the so-called vendors of petitioner 4 to 7 do not find place. And that this honorable court in writ petition number 20362 of 2015 clubbed with another writ petition filed by us in 203175 2015 are pleased to dismiss the writ petition with the liberty to petitioner to challenge the report of the Tahsildar. And after the remand, that challenge, the till 2019, the respondent number 4 to 7 did not challenge that order. It appears in the respondent 4 to 7 appears to have challenged in 2019 without impleading the petitioners herein, and the order came to be passed. That order is now being challenged. In that proceedings, the Deputy Commissioner holds that this is not the Inam land coming under certain Inam Subvolution Act, but it is Jagir land, and there is a procedure that the Jagir Inam gets directly converted to a Batta land. Therefore, respondent number 4 to 7 are the purchasers. That order is now challenged. Our only contention is that when there was a specific order passed by this honorable court, that the Tahsil, both the parties are at liberty to challenge the Tahsildar order. The respondent number 4 to 7 challenged that order because that Tahsildar report was in our favor. That is at N.
Sir, K page 80.
Annexure K.
K, madam.
Page 80.
Please read that.
Page number 80. ಈ ಮೇಲ್ಕಂಡೆ ವೀಕ್ಷ ಸಂಬಂಧಿಸಿದಂತೆ ಕೋಲಾರಕ್ಕೆ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 95 ಹಳ್ಳಿದು ಸರ್ವೆ ನಂಬರ್ 230 239 ಈ ಜಮೀನುಗಳಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖಿತ ಆದೇಶ ನಂಬರ್ 1ರಂತೆ ವರದಿ ಸಲ್ಲಿಸುವಂತೆ ನಿರ್ದೇಶಿಸುತ್ತೀರಿ. ಪ್ರಯುಕ್ತ ಸದರಿ ವಿಷಯ ಕುರಿತು ಉಲ್ಲೇಖ 2ರಂತೆ ಕಂದಾಯ ನಿರೀಕ್ಷಕರು ಕಮಠಾಣರವರಿಂದ ಪಂಚನಾಮೆ ಹಾಗೂ ವರದಿಯನ್ನು ಪಡೆಯಲಾಗಿದ್ದು ವಿವರ ಇಂತಿದೆ. ಕೋಲಾರಕೆರೆ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 230ರಲ್ಲಿ ವಿಸ್ತೀರ್ಣ 1 ಎಕರೆ 36 ಗುಂಟೆ, ಸರ್ವೆ ನಂಬರ್ 231ರಲ್ಲಿ ವಿಸ್ತೀರ್ಣ 10 ಗುಂಟೆ, ಸರ್ವೆ ನಂಬರ್ 232ರಲ್ಲಿ ವಿಸ್ತೀರ್ಣ 13 ಗುಂಟೆ, ಸರ್ವೆ ನಂಬರ್ 233ರಲ್ಲಿ ವಿಸ್ತೀರ್ಣ 10 ಗುಂಟೆ, ಸರ್ವೆ ನಂಬರ್ 233ರಲ್ಲಿ ವಿಸ್ತೀರ್ಣ 21 ಗುಂಟೆ, ಸರ್ವೆ ನಂಬರ್ 235ರಲ್ಲಿ ವಿಸ್ತೀರ್ಣ 2 ಎಕರೆ 16 ಗುಂಟೆ, ಸರ್ವೆ ನಂಬರ್ 236 ವಿಸ್ತೀರ್ಣ 17 ಗುಂಟೆ, ಸರ್ವೆ ನಂಬರ್ 237ರಲ್ಲಿ ವಿಸ್ತೀರ್ಣ 11 ಗುಂಟೆ, ಸರ್ವೆ ನಂಬರ್ 238 ವಿಸ್ತೀರ್ಣ 4 ಗುಂಟೆ ಮತ್ತು ಸರ್ವೆ ನಂಬರ್ 239ರಲ್ಲಿ ವಿಸ್ತೀರ್ಣ 1 ಎಕರೆ 36 ಗುಂಟೆ ಜಮೀನುಗಳು ಜಂಟಿಯಾಗಿ ಶ್ರೀಮತಿ ಶರಣಮ್ಮ ಗಂಡೆ ಶ್ರೀ ದಿವಂಗತ ಲಕ್ಷ್ಮಣ ಮತ್ತು ಶ್ರೀಮತಿ ಗೌರಮ್ಮ ತಂದೆ ಲಕ್ಷ್ಮಣ್ ಇವರುಗಳ ಹೆಸರಿನಲ್ಲಿ ಇರುತ್ತದೆ. ಸದರಿ ಜಮೀನುಗಳು ಸುಮಾರು 15 ವರ್ಷಗಳಿಂದ ಮೇಲೆ ತೋರಿಸಿರುವ ಪಟ್ಟೇದಾರರ ಕಬ್ಜೆಯಲ್ಲಿ ಇದ್ದು ಸಾಗುವಳಿ ಮಾಡುತ್ತಿದ್ದಾರೆ. ಸದರಿ ಜಮೀನುಗಳಲ್ಲಿ ಕಬ್ಜಾರದ್ದು ತೊಗರಿ ಬೆಳೆ ಬೆಳೆದಿರುತ್ತಾರೆ. ಸದರಿ ಜಮೀನುಗಳ ಹಳೆಯ ಸರ್ವೆ ನಂಬರ್ಗಳಾದ 92, 93, 95, 99 ಇವುಗಳ ಖಾಸರಾ ಪಾಣಿ 1954ರಿಂದ 55ರಿಂದ 1963, 64 ಮತ್ತು 1967ರಿಂದ 1968ರವರೆಗೆ ಪಹಣಿ ಪತ್ರಿಕೆ ಕಾಲಂ 6ರಲ್ಲಿ ಇನಾಮ್ ಮತ್ತು ಕಾಲಂ ನಂಬರ್ 10ರಲ್ಲಿ ಇನಾಮದಾರ್ ಎಂದು ನಮೂದಿಸಲಾಗಿದ್ದು ಸದರಿ ಜಮೀನು ಲಕ್ಷ ತಂದೆ ನರಸಯ್ಯ ಮಾಂಗ್ ಇವರ ಹೆಸರಿನಲ್ಲಿ ಇರುತ್ತದೆ. ಈ ಸದರಿ ಜಮೀನುಗಳು ಖಾಸರಾ ಪಹಣಿ 1954-55 ಕಾಲಂ ನಂಬರ್ 6ರಲ್ಲಿ ಇನಾಮತಿ ಜಮೀನು ಎಂದು ನಮೂದಿಸಲಾಗಿರುತ್ತದೆ. ಹಳೆಯ ಸರ್ವೆ ನಂಬರ್ 93 ಮತ್ತು 95ರ ಖಾಸರಾ ಪಹಣಿ 1954-55ರಲ್ಲಿ ಕಾಲಂ ನಂಬರ್ 6ರಲ್ಲಿ ಮಾಂಗ್ ಇನಾಮತಿ ಮಾದಿಗ ಇನಾಮ್ ಎಂದು ನಮೂದಿಸಲಾಗಿರುತ್ತದೆ. ಸದರಿ ಜಮೀನುಗಳ ಕುರಿತು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಸಂಚಾರಿ ಪೀಠ ಕಲಬುರಗಿ ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ ಅಲ್ಲಿ ಪ್ರಕರಣ ದಾಖಲಾಗಿ ವಿಚಾರಣೆ ಹಂತದಲ್ಲಿರುತ್ತದೆ. ಸದರಿ ಪ್ರಕರಣಗಳ ಕುರಿತು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ದಿನಾಂಕ 24/7/15ರಂದು ಮಧ್ಯಂತರ ಆದೇಶ ನೀಡಿ ಕಬ್ಜೆ ಹಾಗೂ ದಾಖಲಾತಿಗಳಲ್ಲಿ ಯಥಾಸ್ಥಿತಿ ಕಾಪಾಡುವಂತೆ ಆದೇಶವಿರುತ್ತದೆ. ಪರಿಶೀಲಿಸಲಾಗಿ 1954-50ರ ಖಾಸರಾ ಪಹಣಿ ಪತ್ರಿಕೆಯ ಮತ್ತೆ ಕೋಲಾರಕೆ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 95ರಲ್ಲಿ ವಿಸ್ತೀರ್ಣ 8 ಎಕರೆ 33 ಗುಂಟೆ ಎಕರೆ ಹಾಗೂ 1 ಎಕರೆ 33 ಗುಂಟೆ ಇದ್ದು ಕಲಂ 9ರಲ್ಲಿ ಲಕ್ಷ ತಂದೆ ನರ್ಷ ಮಾಂಗ್ ಎಂದು ನಮೂದಿಸಿರುತ್ತಾರೆ. ಖಾಸರಾ ಪಹಣಿ ಅಂತೆ ಲಕ್ಷ ತಂದೆ ನರ್ಷ ಮಾಂಗ್ ಇನಾಮದಾರ್ ಎಂದು ನಮೂದಿಸಿರುತ್ತದೆ. 1962-63ರಲ್ಲಿ ಕಾಲಂ 6ರಲ್ಲಿ ಇನಾಮದಾರ್ ಇರುತ್ತದೆ. 63-64ರಿಂದ 67-68ರವರೆಗೆ ಕಾಲಂ ನಂಬರ್ 6ರಲ್ಲಿ ಮತ್ತು 10ರಲ್ಲಿ ಇನಾಮ್ ಇರುತ್ತದೆ. ಮೂಲವಾಗಿ ಸರ್ವೆ ನಂಬರ್ 1950ರಲ್ಲಿ ಇನಾಮ್ ಎಂದು ನಮೂದು ಇರುತ್ತದೆ. ಸದರಿ ಜಮೀನಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಯಾರೊಬ್ಬರು ಸಹ ರೀಗ್ರಾಂಟ್ಗಾಗಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. ದಿಸ್ ಇಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. ಹಾಗೂ ಸದರಿ ಸರ್ವೆ ನಂಬರ್ಗಳಲ್ಲಿ ಮಾರಾಟ ಮಾಡಿದ ವಿವರ ಕೆಳಗಿನಂತೆ ಇರುತ್ತದೆ. ಲೇಟರ್ ಆನ್ these persons whose claim to be Prabhakar and so persons, they are not at all concerned to said Narsaya, Lakshaya. Lakshaya's wife and the petitioner is the only daughter. ಮಾಡಿದ್ದು ತಿಳಿದು ಬರುತ್ತದೆ. ಈ ಕಚೇರಿಯಿಂದ ನೀಡಿದ ವಂಶಾವಳಿ ಪ್ರಮಾಣ ಪತ್ರ ದಿನಾಂಕ 30/8/2000 ಮಾರಾಟಗಾರರಾದ ಶ್ರೀ ಪ್ರಭಾಕರ್ ತಂದೆ ಲಕ್ಷ್ಮಣ್ ತಂದೆ ಸಿದ್ದಪ್ಪ ಮತ್ತು ಪ್ರಭು ತಂದೆ ನಾಗಪ್ಪ ಅವರು ಸದರಿ ವಂಶಾವಳಿ ಇರುವುದಿಲ್ಲ. ಆದರೆ ಸದರಿಯವರು ವಂಶಸ್ಥರಾಗಿರುತ್ತಾರೆಂದು ಜಮೀನು ಮಾರಾಟ ಮಾಡಿದ್ದು ತಿಳಿದುಬಂದಿರುತ್ತೆ. ಈ ಕಚೇರಿಯಲ್ಲಿ ಲಭ್ಯವಿದ್ದ ರೀಗ್ರಾಂಟ್ ಅರ್ಜಿಗಳಲ್ಲಿ ಈ ಸರ್ವೆ ನಂಬರ್ಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ರೀಗ್ರಾಂಟ್ಗಾಗಿ ಯಾರೊಬ್ಬರು ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲವೆಂದು ತಿಳಿದು ಬಂದಿರುತ್ತದೆ. So this order was later on challenged by the respondent number 4 to 7 before the Deputy Commissioner under Section 56 of the KLR Act without impleading the petitioner as one of the parties. As per the earlier direction of this court in the earlier petition referred to above. Now, our concern is, even I have produced the order sheet copy as well.
Yes.
Even the order sheet copy, at page number 93, my lord. 91, annexure M. It starts on 25/11/2019 ಆರ್ಡರ್ ಶೀಟ್ ನಲ್ಲಿ ರಂದು ನೀಡಿದ ಆಜ್ಞೆಯಂತೆ ತಹಸೀಲ್ದಾರ್ ಬೀದರ್ ಅವರಿಗೆ ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಕಡತವನ್ನು ಸಲ್ಲಿಸುವ ಕುರಿತು ಬರೆದ ಪತ್ರ ಮಾನ್ಯರ ಸಹಿಗಾಗಿ ಸಲ್ಲಿಸಲಾಗಿದೆ. ಮಾನ್ಯರು 2/12/19 ನೀಡಿದ ನಿರ್ದೇಶನಂತೆ ತಹಸೀಲ್ದಾರ್ ಬೀದರ್ ಇವರಿಗೆ ಬರೆದ ಕರಡು ಪತ್ರ ಮಾಧ್ಯಮ ಸಲ್ಲಿಸಲಾಗಿದೆ. Nowhere there is mention about any notice having been issued to the petitioner and others as per the direction that was contained in the earlier order. No, our concern is that, my lord, whether it was a Jagir Inam and it could have been directly converted to.
Please come to page 93.
93, my lord. ಪ್ರಕರಣ ಕರೆಯಲಾಯಿತು. ವಾದಿ ಪರವಾಗಿ ವಕೀಲರು ಹಾಜರು. ಮೂರನೇ ವ್ಯಕ್ತಿಯಾಗಿ ಶ್ಯಾಮರಾವ್, ದಿ ಅನದರ್ ಪೆಟಿಷನರ್ ಇನ್ ಅನದರ್ ರಿಟ್ ಪೆಟಿಷನ್, ಶ್ಯಾಮರಾವ್ ಸಲ್ಲಿಸಿರುವ ಅರ್ಜಿ ಬಗ್ಗೆ ವಾದಿ ಪ್ರತಿವಾದಿ ಕೇಳಲಾಗಿದ್ದು ಈ ಬಗ್ಗೆ ಆದೇಶಕ್ಕಾಗಿ ಮುಂದೂಡಲಾಗಿದೆ. ಅದರ ಆ ಇಂಟೀರಿಯಂ ಅಪ್ಲಿಕೇಶನ್ಗೂ ಯಾವ ಥರದ ಆರ್ಡರ್ ಮಾಡಿಲ್ಲ. ಈಸ್ ರಿಟ್ ಪೆಟಿಷನ್ ಇನ್ ಅನದರ್ ರಿಟ್ ಪೆಟಿಷನ್ ಅಂಡ್ ವೇರ್ we are not been implicated as party to that proceedings at all.
Please come to annexure N.
Annexure
N.
N, madam.
ಶರಣಮ್ಮ ಅಂತ ಏನೋ ಮಾಡಿದ್ರಲ್ಲ ಯಾರು? ಶರಣಮ್ಮ ಗೌರಮ್ಮ. Annexure N, page 97.
Yes.
How is this lady, how is her name shown in the cause title?
That is subsequently included. We have been not given any notice.
ಶರಣಮ್ಮ ಗೌರಮ್ಮನ ಹೆಸರು ಇದೆಯಲ್ಲ ಅಲ್ಲಿ?
ಇದೆ, ಹೆಸರಿದೆ. N annexure. ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ಲ. 96 ನಲ್ಲಿ ಒಂದೇ ಆರ್ಡರ್ ಇದೆ, ಆರ್ಡರ್ ಶೀಟ್ ಪೇಜ್ ನಂಬರ್ 96. ವಾದಿ ಪರ ವಕೀಲರು ಹಾಗೂ ಮೂರನೇ ವ್ಯಕ್ತಿಯಾಗಿ ಪೇಸಾಮಣದ ಸಲ್ಲಿಸುವ ಅರ್ಜಿ ಬಗ್ಗೆ.
Let us see what is the report, the order of the Deputy Commissioner.
Assistant Commissioner.
Deputy Commissioner.
Deputy Commissioner. 66 page H, annex H.
98.
98. Yes. The order sheet are 98. Yes, ma'am. 98 page number 1.
Nimma writ petition 98.
Yes, madam. I'm sorry. Yes. Agreed with the order of the Assistant Commissioner be there, file number so and so. Two separate petitions were filed. I'm just reading the second paragraph. Agreed, two separate petitions were filed before the Honorable High Court bearing numbers so and so. The Honorable High Court has dismissed both writ petitions and gave liberty to the petitioner Rajshekhar to challenge the report of the Tahsildar before the competent authority. The Tahsildar Bidar had given a report number so and so, which was adverse to the real facts. In the opening, he said, therefore, the parties are, facts are narrated.
Those facts might be necessary, my lords, to understand the entire case.
Yes, I'll read this. One Lakshman, son of Narsappa, who was the owner of land survey number so and so B, he has no issues, therefore, he adopted one Prabhakar. And there was a partition in between Prabhakar and said Lakshman, in which land survey number 230 measuring 1 acre 36 guntas and survey number 236 measuring 17 came to the share of Prabhakar. A house located village K, Taluk district Bidar came to be the share of Lakshman under the registered partition deed documents so and so. Subsequently, land survey number 230 and 236 of village Kolar K, Taluk and Bidar were sold by Prabhakar in favor of Ishwarappa, son of Bakkappa under registered sale deed. So and so on 5179. Lakshman joined the sale deed because the lands which were allotted to the share of Prabhakar were still in the name of Lakshman, and for purpose of the registration ROR entries are necessary. Therefore, Lakshman was joined as executant nominally. This is first time these facts have been came to the fore. In the earlier proceeding, no such information was provided, even in the earlier suit also. Thereafter, the said Ishwarappa got mutated both these lands in his favor and later sold the same in favor of Rajshekhar, the petition number 1, wide document number so and so on 16/1/1985, on the basis of which the mutation therefore was effected in favor of Rajshekhar. In spite of these facts, the Elas of Lakshman by name Srimati Sharanamma, Elas of Lakshman, Sharanamma, the wife of Lakshman, and Srimati Gauramma, daughter of Lakshman, has filed a petition before the Assistant Commissioner Bidar and Section 5 of PTCL Act, contending that these lands cannot be sold. Agreed with the order of the Assistant Commissioner Bidar, who held that these lands are hit under the provisions of Karnataka Certain Inamation Act and Scheduled Caste and Prohibition of Transfer of Certain Lands Act 1978. Agreed with the said order of the Assistant Commissioner Bidar dated 7/7/2007, the present appeal is filed before the Deputy Commissioner Bidar. During the pendency of the case before the Deputy Commissioner Bidar, the matter was taken to the Honorable High Court. It was remanded back and ultimately, on the direction of the High Court to dispose of the case, the Deputy Commissioner Bidar on dated 27/5/2005 passed an order setting as the order of the Assistant Commissioner dated 7/7/2007 and also directed Tahsildar Bidar to examine the basic records, nature of the Inam and Inam Patrak, Faisal Patrak, and also to verify the said transaction made with the respect of the suit land. The Deputy Commissioner Bidar had granted the stay order to the order of the Assistant Commissioner Bidar, but the respondents colluding with the revenue officials got mutated the name of Elas of the respondent when this fact was brought to the knowledge of the Deputy Commissioner Bidar, requesting him to remove the wrongly entered names of Elas of the respondent and to restore the names of the petitioners. The Deputy Commissioner Bidar had simply directed Tahsildar Bidar to enter the word stay in the ROR. Therefore, the petitioners went again to High Court against the direction of the Deputy Commissioner to the Tahsildar Bidar by filing a writ petition bearing number so and so. And the respondents have also filed their writs against the order of the Deputy Commissioner Bidar dated 27/5/2015. And when the writs were clubbed and common hearing was going on, the LR's respondents have filed a copy of the report given by Tahsildar Bidar to the Deputy Commissioner Bidar dated 31/3/2017. After filing this copy of the report, the Honorable High Court held that the impugned order passed by the Deputy Commissioner Bidar does not survive for consideration, and accordingly, the writ petition stood dismissed with liberty to the petitioner to challenge the report of the Tahsildar Bidar dated 31/3/2017. The provisions of either certain Inam Abolition Act, PTCL Act do not apply to the present case since the village of Kolar K was under the Hyderabad state, Shamrajpur Agrahar, Jagirdar lands, and village Kolar K was not Khalsa village. After police action in the year 1948, Government of India had abolished all Jagir lands. After abolition of Jagir, the then Government of Hyderabad, through its revenue department, Wide Circular number 2 dated 18/10/1949 had issued a circular to civil administrators of all districts stating that all the lands situated in Jagir area, including Inang lands, have become Patta lands as per their position. The then Hyderabad government has enacted a Law of Inams Abolition 1954 Act, Act number 8 of 1955, assent was given by the President of India on 16/7/1955, and it is published in Hyderabad Gazette Extraordinary on number 90 on 27/1955, and it is held that Act extends whole of Hyderabad state and shall be applicable to all the Inam lands. And it being so, the disputed lands also became patta lands of Lakshman, son of Narsappa, and others automatically. His name is also forthcoming. Automatically, who are cultivating lands have become pattadars. As per the revenue records, all the land survey number so and so, reference made then is in a Jagir village, and all lands are Jagir lands. These are the factual aspect is decided by the deputy commissioner and deputy commissioner without the giving opportunity to the petitioner to contest or to say anything regarding debt. The government of Hyderabad Revenue Department issued a circular number 2 dated 18/10/1949, wherein it is stated that as per Hyderabad abolition of Jagir's regulation 1355 firstly, that all the persons who hold Jagir lands and pay revenue directly to the Jagirdars shall be deemed to have become the pattedars of the lands held by them, and the rights and liabilities shall be same of those of pattedars of Khalsa lands. The details of the lands of village Kala disputes are as below. Now, the the lands relating to alienations have been said. It is worth mentioning that after the said transaction, the name of Ishwarappa got mutated in his name, and thereafter mutation was also made in favor of the Rajshekhar on the basis of sale deed taken from Ishwarappa. The sale deeds of Prabhakar and Lakshman in favor of Ishwarappa was acted upon by the way of mutation and in turn in favor of Rajshekhar. It is also worth to mention that Ishwarappa, son of Bakkappa, who is the vendor of Rajshekhar, has also purchased land survey number 235, measuring 2 acres 16 guntahs of village Kolake, Taluk Bidar, from Sri Honnappa, son of Gurappa, Dumale.
But
And
what
Subhash,
is there
son
to
of,
show, what is there to show that these are Jagir lands?
that is nothing. It is the unilateral say of the learned deputy commissioner based on the record who placed those records before Lord's authority. That is not made clear. And in fact, we had no any opportunity to contest this matter. Therefore, had we given an opportunity to contest this matter as per the direction of this honorable court, then things would have been different.
No, but you're shown as a respondent in this
Well,
case.
no notice has been served. That's the order sheet I'm
Yeah, who is the answering respondent in your case?
I appear for the contesting respondent, who are the purchasers of this property.
Whether this deputy commissioner, the petitioners were made parties before the deputy commissioner.
Yes, my lords will kindly permit me to show to your lordships the genesis of this entire case. It starts by a complaint filed by the very same petitioner challenging the alienations made by Lakshman Prabhakar in favor of the petitioner herein, the contesting respondent herein, on the ground that these lands are covered under the PTCL Act. While several rounds of litigations happened, my lords, where the respondents had to reach before this honorable court at interim stages also, it was brought out by way of a report of the Tahsildar that there is no PTCL violated here. However, the Tahsildar wrongly stated this to be covered under the Inam's land. That was again challenged before this honorable court, and an order is passed at Annexure J, my lords will see. Page number 71 onwards. This order of Tahsildar came to be.
So what was challenged in Annexure J?
In Annexure J, the very order of the deputy commissioner passed earlier, so far as he made an observation while saying that there is no violation of PTCL Act because of the report of the Tahsildar. The observation was made that it has to be ascertained whether it is an Inam land or not, and therefore he directed the Tahsildar to examine that.
No, but in this writ petition,
Now,
what is challenged is an order passed by the deputy commissioner.
Yes.
Deputy commissioner, in which, my lords, a portion of the order of the deputy commissioner stated that the Tahsildar shall ascertain this allegation whether it is an Inam land or not, while he gave a clarity about the violation of PTCL not being there. Now, that was challenged before this honorable court, where all this was argued, saying that in the earliest of the writ petition, I had also produced one annexure to show the entire list of Jagir villages under the Hyderabad Karnataka region, which was then under the Nizam rule. And all these Jagir villages as per the Hyderabad abolition of Jagir regulations, the 1349 firstly, all these Jagir villages are deemed to have been converted into pattas of the rights. The Jagirdars would lose their rights and the rights would become the pattedars. And that is the circular dated 1810-1949, which mentions about the Jagirdars having lost all the rights and all the persons occupying the lands would become, the rights would become the deemed pattedars. Now, the name of this Kolar K village is found in that list of Jagir villages in this Bidar district. This was under at Annexure J.
Where do we get that?
No, that is not produced here. It was produced at the first instance in the first of the writ petitions, where the complaint was made by the same petitioner.
Deputy Commissioner comes to the conclusion
Yes.
that this is Jagir land.
Yes.
Now, while holding so, shouldn't the petitioners be heard?
Yes, well, they were heard. They are the very complainants right from day one.
Let us see where exactly before the Deputy Commissioner.
That's why I will point out, kindly see Annexure J. The order of Deputy Commissioner is an outcome of the consequence of order at Annexure J. In Annexure J, page 71, there are two writ petitions, 20362015 and 203728. Kindly see page number 2 of this order. Respondent number 1 is Gauramma, daughter of Lakshman Rao.
Yes.
And then the petitioner in the connected writ petition at very same page number 2, WP 203175 is very same Gauramma, daughter of Lakshman Rao.
Yes, yes.
Now, my lords will permit me to read the order at para 7 onwards.
Only name has been shown in the cost title and no notice. I have produced the order sheet, entire order sheet.
Yes. Yaro obru madi.
Yes, sir.
Paragraph 7, after para 7 notes, para 8. In terms of the report of the Tahsildar, the property in question is Khidmati Inam land. The lands in question are shown as Inam as per column 6 relating to the year 1962-63 and column number 6 and 10 relating to year 63-64 to 67-68 in the revenue records. No application for regrant of the Inam land has been made by any of the parties. This statement is also reiterated in the order of Deputy Commissioner. The details of the sale made relating to the property in question is also furnished. In view of the aforesaid, challenge made to the impugned order passed by Deputy Commissioner does not survive for consideration. Accordingly, writ petitions stand dismissed with liberty to petitioners to challenge the report of the Tahsildar dated if so advised. And that's how, my lords, the very order of Tahsildar or the report of Tahsildar was because of the complaint filed by the petitioner now before your lordships, where Deputy Commissioner
challenge the report. Then you challenge the report of the Tahsildar.
Yes.
Before the Deputy Commissioner.
Yes, ma'am.
Please go to Annexure L.
Yes.
You did not array this Gauramma as a party in the petition.
Annexure L is only an objection to the petition under 1 Rule 10. This is not.
Let us see the order sheet. Let us see the order sheet. What does it show that these people were served?
They have not produced the entire records, my lords. My respectful submission is this. My lords, before your lordships will see whether the respondents are factually served or not. They are definitely a party to the proceedings from day one. This is the 5th round of litigation. Kindly see there are 2 suits filed by them.
No, before the Deputy Commissioner, whether this Gauramma was made a party or not is the question.
Yes, ma'am. In page 97, the first page of Annexure N, the order impugned, she is the very respondent. Sharanamma, who is claimed to be the wife of Lakshman. She dies and Gauramma claiming to be the LR of Sharanamma is on record.
Will records.
May I make one more submission if you lordship?
Whether this Gauramma is a party before the deputy.
As per caste title, she is party. In order sheet, we have to.
Revision petition party there. Whether she was cited as a party in the revision petition.
Well, I have to secure records.
May
I
produce page number 94 order sheet.
May I show to your lordships page number 61 Annexure G, which is an order passed as far back as in the year 2010. Even in that writ petition, Gauramma is a party. The entire proceedings are
everywhere Gauramma is a party. Everywhere Gauramma is a party. But whether the Deputy Commissioner, while passing the order, whether he has heard Gauramma, whether Gauramma was made a party to the proceedings,
my
What is the question?
True, my lord. My respectful submission is she is a party because she was the original complaint, and throughout, my lord, this is a matter after remand rather. The honorable, this honorable court, my lord, in an earlier writ petition only made an observation saying that that order of Tashildar, which is a new offshoot of the complaint filed by Gauramma for violation of PTCL, is to be contended only before the deputy commissioner. That's how, my lord, she is heard. There is no doubt about the fact that Gauramma is a party and that she is heard. My respectful submission is, well, the sales are of the year 1970s and 1980s. Till today, my lords, one or the other person wants to now challenge the sale despite Gauramma having filed a civil suit and her suit having attained the suit being dismissed. That is being upheld by this honorable court in a regular first appeal also.
What was
Earlier,
the suit filed for?
Injunction.
that suit,
What
Fair
was the
injunction.
suit filed for? What was the suit filed
press
for?
number, suit was for very relief of injunction, my lords, and I will place on record what is the exact relief. I am instructed it is a suit for declaration and injunction. Nonetheless, my lord, OS number 158 of 2004 is the suit which Gauramma herself files before the Honorable Court of Principal Senior Civil Judge at Bidar. That suit is dismissed. RFA 1668 of 2005 also came to be dismissed in the year 2006. Prior thereto, my lords, OS number 261 of 1985 is filed by the contesting respondent Rajshekar against very same Prabhakar and others, the vendors. That suit also, my lords, came to be decreed
Now,
in respect
Gauramma
of
is
very
alive.
same server.
Gauramma is there, huh?
ಇಲ್ಲ ಗೌರಮ್ಮ ಇಲ್ಲ ನಮ್ಮ petitioner. She's
Gauramma is also dead.
she's dead. Her daughter is there.
Illa Gauramma,
Gauramma ಇರ್ಬೇಕು,
ಗೌರಮ್ಮ ಇಲ್ಲ.
ಶಾರಣಮ್ಮ
Sharanamma has
Sharanamma.
died. Sharanamma has died.
Sharanamma.
Gauramma is
Gauramma ಇದರ ಸತ್ತೋಗಿದಾರ?
ಗೌರಮ್ಮ ಇದ್ದಾರೆ.
Hmm.
Annexure M ನಲ್ಲಿ order sheet copy, entire order sheet copy is produced. There is no reference. 2019, those 17 ನಲ್ಲಿ disclosed. 2019 ನಲ್ಲಿ it's open. First order sheet is on 25/11/2019.
But,
ಅದ್ರಲ್ಲಿ ಎಲ್ಲೂ there is no reference of any notice having been issued to the Gauramma or Sharanamma. And when third party application is filed, his application is also not considered for that matter.
yes, why don't you get the records?
Yes, ma'am.
May I make
I
one
will
more
send-
submission? my lord? Kindly also appreciate this fact, my lords. Before somebody comes before your lordships complaining about the principles of natural justice being violated, kindly see, my lords, it has been explained by Honorable Supreme Court that principles of natural justice will work both the ways. My lord, the petitioner has to show some
No, no.
locus, my lord.
No, now the Tahsildar has given a report. I don't know whether that report could be challenged in proceedings under section 56 of the Land Revenue Act. There's only a report. How it could be challenged, I do not know. Suppose
This
if it
honorable
is.
court permitted, my lords. This honorable court
Suppose,
directed rather.
okay, this court has permitted, no dispute. Assuming that it has permitted and you have challenged it, whether Gauramma had to be heard. She had to be heard because she has something to do with this property.
I will explain this
You
very
say,
answer.
you say that Gauramma is made a party. These people say that Gauramma was not made a party. So which is the best?
May I submit this? my lord? The very query of this honorable court, whether Gauramma is required to be heard or not, is the first question. Subsequently, my lords, if she is required to be heard, whether she is actually heard or not is another question. There has to be prejudice, my lords, added to the argument of not being heard. What's the prejudice that is caused to Gauramma is also the question.
Prejudice is this. Suppose if it's an Inam land. Suppose if it is an Inam land, then Gauramma would have got some right. Now, the deputy commissioner says it is not an Inam land, it's a Jagir land. So therefore, the pattadar will become the owner. There's no question of the land reverting or vesting in the state government. If that is the case, Gauramma had to be held.
May I make this with kind permission of the court? Lords, Gauramma, assuming that this is held to be an Inam land, Gauramma, my lords, today I am served with a copy saying that Gauramma is making an application for regrant in the year 2022, which is not permissible in law. That's why I emphasized twice, my lord, twice it is stated in the order, judicial orders.
They have not filed the application
Nobody has
in
made an
time. Now the
application for
government has
regrant.
extended the time.
No, there is nobody has made an application for regrant. That's the
Correct. Now the
finding.
government has extended the time. See, there are two things. One, though, if you are the purchaser from the Inamdar, then you become an inamdar by virtue of the definition of inamdar contained in the Inam Abolition Act. You step into the shoes. You could also file an application seeking regrant. They also could file an application seeking regrant. Then it will be a rival claimant, then the deputy commissioner will decide who should get it. No dispute. Now, the fact that this is an Inam land is set aside, is disbelieved by the deputy commissioner. Deputy commissioner said it's not Inam land, it is a Jagir land. So shouldn't Gauramma be heard in the matter is what I'm asking you. Or at least to that limited extent.
My respectful submission is, my lords, if your lordships are satisfied that this was a Jagir village, and by virtue of the Hyderabad Jagir Abolition Regulations 1349 firstly, the Jagir villages are converted into a patta in favor of the rights, then, my lords, nobody would be required to be heard at all. This is my very respectful submission. Your lordships may call for the records from the deputy commissioner or Tahsildar, and also the records from the archive, which would show, my lords, the entire list of Jagir villages in this region.
No, we can't summon it from the archive and keep this litigation pending forever. If you have some documents to show that this was Jagir land, it was recognized to be Jagir land, then we'll consider that.
Please, I will also produce it, my lords. These are records which I can also obtain it from the office of the Tahsildar and the deputy commissioner only. Your lordships may call for the records from the Tahsildar and the deputy commissioner to see how it is.
No, if it was a Jagir land, there's some administrator, right, under the Jagir Act.
Yes, my lord, that is 1948 administrator appointed by the Nizam, the administrator general, who has issued two circulars, circular 1 and circular number 2. This is the circular number 2 dated 18th of October 1949. The reference to which is found in not one or two judgments of the Andhra Pradesh High Court, but also in one or two judgments of the Honorable Supreme Court.
Please produce the whatever item number 2, item number 1, whatever you said, circular 1 and 2.
Please,
all those documents.
I will produce it. I will produce it.
Till 1963, it continued to be Inam land. There are two sets of records coming. One they say Jagir. Very Revenue Department says that it's Inam land coming under the separate Inam. It's not a Jagir. So when the two factual aspects are there.
More than 1 hour.
Yes, my lord.
And we've reached a dead end.
Yes, my lord.
Barcode, the Lord AG is directed to secure the records from the office of the Deputy Commissioner concerning case number APPL/CR-07/2019-20. The Deputy Commissioner Bidar is also directed to place on record the circular number 2 issued by the then government of Hyderabad dated 18/10/1949.
And also the list of Jagir villages in Bidar district.
List of Jagir villages in Bidar district. Yes, ಯಾವಾಗ ಮಾಡ್ತೀರಿ?
11/2.
List on 11th February. ದಯವಿಟ್ಟು ರೆಡಿ ಇದ್ರೆ ಮಾತ್ರ start the arguments, otherwise we are wasting time. 1 hour waste.
This our concern, not facts.
Right, but
We
then
have not been
you
given
are-
opportunity. Therefore, we prayed for that much.
AM Biradar.
In matter pertaining the land acquisition, the KIDB acquired for the airport of the Kalaburagi airport.
Shivkumar Tengli. Where is Shivkumar Tengli? What is the issue?
Issue with regard to the land survey number 576/1 ಎಕರೆ 35 ಗುಂಟಾ of Srinivas Sardgi Kalaburagi Taluka by acquired on 28/2/2002 under section 28 of the KIDB Act for the purpose of the formation of the airport. In terms of the preliminary notification, the award is consent award is came to be passed on 15/12/2004. Annexure C1 and C1. The possession will be taken by the airport authority and will be run the airport. There is no dispute with regard to the taking the possession. Now, since from 2004 till today, they not paid the compensation.
Where is your name in the consent award?
The name is consent award. Will be see the page number 37, serial number 39.
Kindly pass over my lord, 230 will come.
Yes. 39, huh?
Ah, sir.
Mohammed Yunus.
Yunus is my paternal uncle. My petitioner father and the awardee Muhammad Isa is the real brother.
No, we do not know whose brother is who, but
There is a decree of the partition that properties are fallen to my father share. That is also producer annexure. Annexure B. In RA number 9079 of 2007. In page 13 only, serial number 3. It is agreed between the parties that land survey number 517-1 measuring 1 acre 35 gunta, which is in the name of the deceased Muhammad Isa, that is awardee. And the said land allotted to given to share of Muhammad Isa, that is the father of the petitioner. And the appellant and the land is acquired for the airport, and appellant is entitled to get the compensation from the government.
230.
230.
Please.
Previous matter, my lord, interim order has to. The interim order is not extended. Public. Niwachim code.
My lord, item number 41.
40?
41, my lord. 41.
Ah.
So the next, some short date may continue.
Well, let them get the file.
My lord, records coming from India, my lord, it will take time, my lord. Land.
ಬರ್ತಾ ಇದೆಯಾ?
ಬರ್ತಾ ಇದೆ.
ನೀವು ಹೋಗಿ ವಿಲ್ ಫಿಕ್ಸ್ ಯಾವತ್ತು ಬೇಕು? ಯಾವತ್ತು ಬೇಕು ಹೇಳಿ?
When do we want it? When do we want it?
It may be on tomorrow or day after tomorrow.
Tomorrow, day after tomorrow. Next ಯಾವ್ದ್ರಿ?
4 tomorrow.
4th. 4ನೇ ತಾರೀಕು. 4ನೇ ತಾರೀಕು. Let him come.
Yes.
Let him bring the records.
Yes.
4th.
Great respect.
Number 49. 49 notes. The last date of hearing, Lordship has asked me to produce the 40 notes which I had challenged before ADLR. I have one memo I have filed my notes along with the documents. Memo dated 27/1/25. ಅದರಲ್ಲಿ
ಇಲ್ಲಿ ಮೇಡಮ್ ಇಲ್ಲಿ ನೀವಾ ಚಿಮ್ಕೋಡ್
Also present.
ಬಂದಿದಾರಾ?
ಪೇಜ್ ನಂಬರ್ 1 ಅಲ್ಲಿ. This part of the land notes, this part, this strip of the land.
35 guntas.
That is challenged notes since that is running contrary to the Watney which the vendor of the petitioner has entered into.
Ready now? Both of you are ready?
Ready.
Madam, you are ready?
On the technical point.
Huh?
Only on the technical points, Lordship. Annexure may be twice, Lordship, annexure. Yeah.
ಅದು
Merit,
don't
Lordship.
You said that there is some
If
Yeah.
merit is concerned, Lordship, I may not, Lordship.
You don't have a case.
No, yes, that is what, Lordship.
Because notes that
And then
Akarband,
take it up
that
at
is-
2:30.
please.
You said that appeal against the order passed by
Yes.
the deputy director has to go before the deputy commissioner, something like that.
Instead of
Deputy
regional
commissioner
Deputy commissioner in
passed an
the-
order, that is notes, as
It
per
has
the
to be go before the
notification
regional
JDL
joint director.
considered it. But
Ah.
my submission is notes, already the proceedings were concluded. It was
That is
only
not the
reserved for
question.
orders.
Yeah,
One
No, no,
date notes only reserved for orders ಆಗಿತ್ತು. Even before the notification was
After 2
released.
months, the
If
order
he
has
has-
been passed.
If he has
Lordship.
no jurisdiction, how can he pass an order?
Even
The-
after
the
2 months,
proceedings were
Lordship.
totally concluded, arguments adduced,
Oh, yeah.
we have produced documents.
He has lost the
The
jurisdiction.
reasonings assigned, my lords, that is,
Anyway, we'll consider. No.
please.
ಇದು ಚಲೋ ಮಧ್ಯಾಹ್ನ ಹೈರಾಣ ನಮ್ಗೆ. ಯಾಕಂದ್ರ ಈ ಇವು ಚಾಲು ಆಗ್ತಾವ ಇರಕ್ಕ
allegedly colluded with the revenue, survey authorities and had obtained a PT sheet which ran counter to the boundaries of the sale deeds executed by Basangowda and Ningangowda. Full stop. It is alleged that the surveyor, without issuing any notice to the respondents 4 and 5, had wrongly fixed the boundaries of the property of the vendor of the predecessor in title of the petitioner. Full stop. It is contended that the respondents 4 and 5 were therefore advised to challenge the said survey proceedings before the respondent number 2, who arbitrarily dismissed the appeal, following which a revision was filed before the respondent number 1. It is also contended that the respondent number 1 had heard the revision petition and had reserved the matter for orders, by which time the notification was issued by the state government delegating the powers of revision to the Joint Director of Land Records. Full stop. It is therefore contended that the order passed by the respondent number 1 is just and proper, having regard to the facts and circumstances pleaded above, and therefore the respondents 4 and 5 prayed that the writ petition be dismissed. Next part. The learned counsel for the respondents 4 and 5 reiterated the contentions urged in the statement of objections and contended that the father and uncles of the predecessor in title of the petitioner, namely Basanagowda, Ninganagowda, and Shivanagowda, had divided 2 acres of land into 3 portions running east to west.
Yes.
And Basanagowda and Ningangowda had conveyed their portions, while what was retained was the portion that was allotted to Shivanagowda, who transferred it to Srimati Vijayalakshmi, who in turn sold it to the petitioner. He therefore contends that the survey authorities had now fixed the boundaries of the property purchased by the petitioner north to south. North to south,
Yes, north to south, that is to totally to the western portion.
Towards the
Western portion.
Towards the western portion on the northern side.
Measuring from north to south, my lords. Measuring from north to south.
No, where is?
My statement of objections are
on the northern side on the north towards the western side.
Yes.
Full stop. He therefore
Complete north to
contends,
south.
he therefore contends that the fixation of boundaries and the Hissa survey was not in accordance with the partition deed as well as the sale deeds executed in favor of the respondents 4 and 5. Next, I consider submissions of the learned counsel for the petition and the learned counsel for the respondent number 4 and 5. The learned AGA contended that the powers of revision under section 56 was to be exercised by the respondent number 1. He however contended that the state government had delegated the powers of revision, particularly in respect of survey issues, to the Joint Director of Land Records. Full stop. He contends that since the respondent number 1 had already heard the matter and reserved the matter for orders, he did not feel it necessary to refer the case to the Joint Director of Land Records. Next para, I consider submissions of so and so. Next para. The petitioner claims to be the owner of 35 guntas of land in survey number 129/1 which was reassigned as survey number 129/3. Likewise, the respondents 4 and 5 claim that they are the owners of the remaining portion of survey number 129/1. So the respondents 4 and 5 claim that the father of the predecessor and title of the petitioner and his brothers had partitioned the property bearing survey number 129/1 into 3 bits running east to west, of which the respondents 4 and 5 purchased 2 bits, and what was remaining was 1 bit of land, which was ultimately purchased by the petitioner. Full stop. Therefore, it appears that what could have been purchased by the petitioner was a property running east to west. However, what is sought to be fixed in the PT sheet is a bit of property which lies on the western side on the northern edge of the property. Full stop. Ideally, while fixing the boundaries of the property so purchased by the petitioner, the respondent number 2 must have, the concerned surveyor must have intimated the adjacent landowners and thereafter must have taken out Hissa survey. However, it appears that the same was not done. Be that as it may, since the powers of revision was delegated by the state government in favor of the respondent, in favor of the Joint Director of Land Records by a notification dated 31/5/2021, that is much prior to the respondent number 1 passing the impugned order, the respondent number 1 must have referred the parties back to the Joint Director of Land Records. Instead, the respondent number 1 has assumed jurisdiction and has passed the impugned order. Therefore, on this short ground alone, the impugned order deserves to be set aside, and the parties are liable to be relegated before the Joint Director of Land Records. Full stop. Hence, the petition is allowed in part. Impugned order passed by the respondent number 1 is set aside. The parties are directed to appear before the Joint Director of Land Records.
Belgaum.
Yes. Tilkondra?
Yes.
Belgaum. Along with a copy of this order. Full stop. The office of the respondent number 1 is directed to forthwith transfer revision petition to the office of the Joint Director of Land Records, Belgaum, and the party shall appear before the Joint Director of Land Records, Belgaum on date on 25th February.
50, please.
In a record, so
25th.
February 2024.
Without further.
The Joint Director of Land Records shall consider and dispose of the revision petition in accordance with law after hearing all the parties concerned.
Published.
Yes, Mantish.
What's sixth respondent?
Sixth respondent.
The is owner of the Mlot's land measuring 4 acre 13 guntas totally. In survey number 812 P and 812 bar A Mlots.
812 B and
there was bifurcation subsequently, but it totally 812 is measuring 4 acre 13 guntas Mlots. Now we are not 812 bar B 2 acre 6 guntas is the present my lords disputed land. He my lords applied for the permission to grant my lords use it for the land for non-agricultural purpose on 33/2002 my lords.
13?
33/3/2002. Thereafter my lords on 6/9/2002, the fifth respondent has approved the sanction plan my lords, and based on the grant order, he was the layout map was came to be approved my lords on 6/9/2002. On 21/10/2005 my lords, the petitioners and several other vendors have purchased the various plots my lords in the layout formed in the 812/B my lords. And thereafter on 5/2/2007, the measuring 446.09 meters my lords was transferred in favor of the government as a civic community and garden as reserved under the plan my lords. Then my lords, in the year 2008, the petitioner has purchased petitioner number 1 purchased 14 and 15 my lords. I have narrated my lords in brief in my writ petition at para number 5 and 7 of the writ petition my lords. Under the various CL deeds, the petitioners were purchased the several properties my lords.
Yes.
Then after purchasing these properties my lords, the subsequently he filed an my lords applications, the sixth respondent himself, to cancel the NA order granted in favor of him my lords on 33/2002. That was by virtue of the impugned order my lords, which is impugned in the present writ petition annexure P, page number 369. The deputy commissioner has cancelled the order of NA my lords.
Why?
He says my lords, since there was some survey was conducted and he found that the land is not utilized. He himself, the sixth respondent states.
Please read.
From para 1 to read. ರಾಯಚೂರು ಜಿಲ್ಲೆ ಸಿಂಧನೂರು ತಾಲೂಕಿನ ಸಿಂಧನೂರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 812B ರ ವಿಸ್ತೀರ್ಣ 2 ಎಕರೆ 6 ಕೃಷಿ ಜಮೀನನ್ನು ವಾಸದ ಉದ್ದೇಶಕ್ಕಾಗಿ ಉಲ್ಲೇಖಿತ 1ರ ಈ ಕಾರ್ಯಾಲಯದ ಆದೇಶಾನುಸಾರ ಅರ್ಜಿದಾರರಾದ ಶ್ರೀ ಶ್ರೀನಿವಾಸ್ ತಂದೆ ಅಂಬಣ್ಣ ಸಿಕ್ಸ್ತ್ ರೆಸ್ಪಾಂಡ್ ತಾಲೂಕ್ ಸಿಂಧನೂರು ಇವರಿಗೆ ವಾಸದ ಉದ್ದೇಶಕ್ಕಾಗಿ ಭೂ ಪರಿವರ್ತನೆ ಆದೇಶ ಮಂಜೂರಿಯಾಗಿದ್ದಿರುತ್ತದೆ. ಆದರೆ ಅರ್ಜಿದಾರರು ಸದರಿ ಜಮೀನನ್ನು ನಾವುಗಳು ಸಾಗುವಳಿ ಮಾಡುತ್ತಾ ಬಂದಿರುತ್ತೇವೆ. ನಮ್ಮ ಕುಟುಂಬದಲ್ಲಿ ಭಿನ್ನಾಭಿಪ್ರಾಯವಿದ್ದ ಕಾರಣ ಜಮೀನನ್ನು ನಾವು ಯಾವತ್ತೂ ಭೂ ಪರಿವರ್ತನೆಗೊಳಿಸಿದ್ದನ್ನು ಉಪಯೋಗಿಸಿಕೊಂಡಿರುವುದಿಲ್ಲ. ಸದರಿ ಜಮೀನನ್ನು ಅಂದಿನಿಂದ ಇವತ್ತಿನವರೆಗೆ ನಾವು ಬಿತ್ತಿ ಬೆಳೆ ತೆಗೆಯುತ್ತಿದ್ದೇವೆ ಹಾಗೂ ಸದರಿ ಜಮೀನಿಗೆ ನಾವು ಕಂದಾಯ ತುಂಬುತ್ತಾ ಬಂದಿದ್ದೇವೆ ಎಂದು ವಾಸದ ಉದ್ದೇಶಕ್ಕಾಗಿ ಬಿನ್ ಶೇತ್ಕಿ ಮಂಜೂರಿಯಾದ ಜಮೀನನ್ನು ಪುನಃ ಕೃಷಿ ಜಮೀನಿಗಾಗಿ ಉಪಯೋಗಿಸಲು ದಿನಾಂಕ 25/2/2019 ಈ ಕಾರ್ಯಾಲಯಕ್ಕೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿ ಬಿನ್ ಶೇತ್ಕಿ ಆದೇಶವನ್ನು ರದ್ದುಪಡಿಸಲು ವಿನಂತಿಸಿರುತ್ತಾರೆ. ಮುಂದುವರೆದ ಉಲ್ಲೇಖ 4ರ ಕಾರ್ಯಾಲಯದ ಪತ್ರದ ಮೂಲಕ ತಹಸೀಲ್ದಾರ್ ಸಿಂಧನೂರು ಇವರಿಗೆ ವರದಿಯನ್ನು ಸಲ್ಲಿಸುವಂತೆ ಕೋರಿದ ಪ್ರಯುಕ್ತ ಸದರಿಯವರು ಸಿಂಧನೂರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 812/B ರ ವಿಸ್ತೀರ್ಣ 2 ಎಕರೆ 6 ಜಮೀನನ್ನು ಕಂದಾಯ ನಿರೀಕ್ಷಕರು ಸಿಂಧನೂರು ಇವರ ಜೊತೆ ಜಂಟಿ ಸ್ಥಳ ತನಿಖೆ ಮಾಡಿ ಸದರಿ ಜಮೀನಿನಲ್ಲಿ ಯಾವುದೇ ರೀತಿಯ ಭೂ ಪರಿವರ್ತನೆ ಲಕ್ಷಣಗಳು ಕಂಡು ಬಂದಿರುವುದಿಲ್ಲ ಹಾಗೂ ಅರ್ಜಿದಾರರು ಕೃಷಿ ಆಧಾರಿತ ಬೆಳೆ ಸಾಲ ಪಡೆದಿರುವುದು ತಿಳಿದು ಬಂದಿರುತ್ತದೆ ಮತ್ತು ಸ್ಥಳ ತನಿಖೆಯಲ್ಲಿನ ಅಂಶಗಳ ಅನ್ವಯ ಕೃಷಿ ಉದ್ದೇಶದ ಜಮೀನು ಕೃಷಿಯೇತರ ಉದ್ದೇಶಕ್ಕಾಗಿ ಬಿನ್ಶೇತ್ಕಿ ಆದ ನಂತರ ಕೃಷಿ ಚಟುವಟಿಕೆಗಳನ್ನು ಮುಂದುವರಿಸದಿರುವುದು ಮತ್ತು ವಿನ್ಯಾಸ ಅನುಮೋದನೆ ಆದ ನಂತರ ವಿನ್ಯಾಸ ಅಭಿವೃದ್ಧಿ ಕಾಮಗಾರಿಗಳನ್ನು ಮಾಡದೇ ಇರುವುದು ಹಾಗೂ ಮಾನ್ಯ ಸಹಾಯಕ ಆಯುಕ್ತರು ಲಿಂಗಸೂರಿಯವರ ಆದೇಶ ಸಂಖ್ಯೆ 33/2002 ಕ್ರಮ ಸಂಖ್ಯೆ 2ರ ಷರತ್ತನ್ನು ಉಲ್ಲಂಘಿಸಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ ಎಂದು ಈಗಾಗಲೇ ವಾಸದ ಉದ್ದೇಶಕ್ಕಾಗಿ ಭೂ ಪರಿವರ್ತನೆಯಾಗಿರುವ ಆದೇಶವನ್ನು ರದ್ದುಪಡಿಸಲು ಸೂಕ್ತವಿರುತ್ತದೆ ಎಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ಉಲ್ಲೇಖ 5ರ ಪತ್ರದ ಮೂಲಕ ಸದಸ್ಯ ಕಾರ್ಯದರ್ಶಿ ನಗರ ಯೋಜನಾ ಪ್ರಾಧಿಕಾರ ಸಿಂಧನೂರು ಇವರು ಕೂಡ ಸದರಿ ಜಮೀನಿಗೆ ಭೂ ಮಾಲೀಕರು ಈ ಪ್ರಾಧಿಕಾರದಿಂದ ವಿನ್ಯಾಸ ನಕ್ಷೆ ಅನುಮೋದನೆ ನೀಡಲಾಗಿದ್ದು ಪ್ರಸ್ತುತ ಈವರೆಗೂ ಸ್ಥಳದಲ್ಲಿ ಯಾವುದೇ ವಿನ್ಯಾಸ ಅಭಿವೃದ್ಧಿ ಕಾಮಗಾರಿಗಳು ಪೂರ್ವ ಸೇರುವುದಿಲ್ಲ. ಸದರಿ ಬಿನ್ ಶೇತ್ಕಿ ಆದೇಶವನ್ನು ರದ್ದುಪಡಿಸುವುದು ಸೂಕ್ತವಾಗಿರುತ್ತೆ ಎಂದು ವರದಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಹೀಗಾಗಿ ತಹಸೀಲ್ದಾರರು ಸಿಂಧನೂರು ಮತ್ತು ಸದಸ್ಯ ಕಾರ್ಯದರ್ಶಿ ನಗರ ಯೋಜನಾ ಪ್ರಾಧಿಕಾರ ಸಿಂಧನೂರು ಇವರ ವರದಿಯನ್ವಯ ಭೂ ಮಾಲೀಕರು ಅಭಿವೃದ್ಧಿಪಡಿಸದೇ ಇರುವುದರಿಂದ ಹಾಗೂ ಮೇಲ್ಕಾಣಿಸಿದ ಎಲ್ಲ ಅಂಶಗಳನ್ನು ಗಮನದಲ್ಲಿಟ್ಟುಕೊಂಡು ಈ ಕೆಳಗಿನ ಆದೇಶವನ್ನು ಹೊರಡಿಸಲಾಗಿದೆ. ಪೀಠಿಕೆಯಲ್ಲಿ ವಿವರಿಸಿದ ಎಲ್ಲ ಅಂಶಗಳನ್ನು ಗಮನದಲ್ಲಿಟ್ಟುಕೊಂಡು ಸಿಂಧನೂರು ತಾಲೂಕಿನ ಸಿಂಧನೂರು ಗ್ರಾಮದ ಜಮೀನು 812B ರ ವಿಸ್ತೀರ್ಣ 2 ಎಕರೆ 6 ಕೃಷಿ ಜಮೀನು ವಾಸದ ಉದ್ದೇಶಕ್ಕಾಗಿ ಬಿನ್ ಶೇತ್ಕಿ ಮಂಜೂರಿಯಾಗಿದ್ದು ಸದರಿ ಉಲ್ಲೇಖ 1ರ ಮುಖಾಂತರ ಹೊರಡಿಸಿದ ಭೂ ಪರಿವರ್ತನೆಯ ಆದೇಶವನ್ನು ಈ ಮೂಲಕ ರದ್ದುಪಡಿಸಲಾಗಿದೆ. This land after conversion, I have produced the layout map. Thereafter, my lords, this as per the order layout, my lords, the property which is reserved for civic communities and for park area was came to be transferred in favor of the municipality, my lords, which is I have produced at my lords annexure, page number 39, my lords. 33, 34, my lords. Annexure C1. Thereafter, we purchased the several petitioners, but these are the petitioners were purchased the registered through the registered sale deeds from 21/10/2005 onwards, my lords.
Yes.
After purchasing, my lords, he himself has filed an applications for cancellation of the NA order, and these are the orders which the mutation was also carried by the municipality by virtue of the registered sale deeds, which I have produced, my lords.
Yes, who appears for the response?
My lord, I am appearing for here, my lord. The purchaser, they did not have purchased from me, my lord. There is a dispute. Themselves, he was in the himself he has stated in the, my lord, in writ petition stated, I have given the GPA to the one Wagga Shankarappa his name is, my lord, is Shankarappa Wagga. But it is under disputed, my lord. The person who is Shankarappa Wagga, he is doing all these things, my lord. And I myself, I am not at it. It is very, very clear. My application before the deputy commissioner is that, my lord, it is my land. I am the owner and possessor of the land. I am not at all carried out any activities. These all documents are created by that Shankarappa Wagga, man. This is one aspect. There is a suits are pending before the concerned court in last time bandag the argument again. There is an oral direction to the Mr. Mantesh Patil to say about about the status of the that civil suits, my lord. Apart from this, my lord, as per section 29, either granting or rejecting of the NA, it is a appealable order before the, my lord, KAT appellant. This is not my case.
Yes, government, how did you do this?
My lord, based on application filed by the
Just
respondent.
because he says it's cancel it, you cancel it, is it?
No, spot inspection has
What
done by
the-
Tahsildar.
Hey, the land is now within the limits of some urban development authority. Did you write to the urban development authority whether sites are sold, whether khatas are made, whether there is relinquishment? ಏನು ಬರಿದಂಗೆ ಇವ್ರು ಬಂದು ಹೇಳಿದ್ರು and you allowed it? What is the verification that you have done?
Those documents are not at all filed in the, my lord, EAC. There is an order of the EAC.
Correct.
Refer.
No, what is that you have done?
My
He
lord,
gave a letter, fair enough. He gave a
Deputy
letter.
Commissioner has given, has sent Tahsildar letter, my lord. Go and.
So looks like everybody has colluded with this respondent number 6. ಇಲ್ಲ ಸೇಲ್ ಡೀಡ್ ಎಷ್ಟಾಗಿದೆ ಚೆಕ್ ಮಾಡಿಸಿದ್ರಾ? Did you verify? Did you verify what should happen to the land which is relinquished? Did you verify with the urban development authority whether khatas are made out? How did you cancel the conversion?
No, it has not done, my lord.
Huh?
It has not
Yes,
done.
what you
There is a report of assistant commissioner, my lord, that is referred in the, my lord, referred in the impugned order, my lord.
assistant
That is
commissioner.
not produced.
Correct, assistant. Then you produce it. You produce it if you want. ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ. ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಅದೆಲ್ಲ ಚೆಕ್ ಮಾಡಿದಾರ? ಖಾತೆ ಆಗಿದೆಯಾ, ಕಂದಾಯ ಆಗಿದೆಯಾ?
The executing of GPA itself is in
Work out your remedy.
he is the person, my lord, doing all those things, my lord.
Work it out in the whatever suits that you have filed.
Not one submission. He did not file any suit. Some of the, my lords, purchasers of the sites have filed the suits. He remained ex parte. One of the suit is already also
Whether
decreed.
you have respondent number 6 has filed any suit?
Illa.
The respondent number 6 has filed any suit?
Never, my lords, challenged the
not
sale
challenged.
deeds,
You are not challenged?
nor questioned about the execution of GPA to the Shankar Wagga.
Hold.
Several suits were filed and one of the suit is decreed. He remained ex parte.
Barcode.
But section 49, my lord, appeal has to be preferred.
Appeal has to be preferred against what?
Before the KAT, my lord.
Against what?
Section 49, my lord,
Against what?
or cancellation or granting of the NA, my
These
lord.
people are not even been heard.
Is not?
The petitions are not even heard before cancellation.
So matter request for remand, my lord.
Huh?
Matter request for remand, my lord. If that is the question mark they are
Matrix?
sought, matter requires before the remand for before the my lord,
Yes, I'll
Deputy Commissioner.
consider that.
And that aspect has been considered by this court, my lords. I have produced the two judgments.
The petitioners have challenged an order petitioners has challenged an order
Annexure P
dated
19/6/2022.
19/6/2021, passed by the respondent number 2, recalling the conversion of land bearing survey number 802/B of Sindhanur village, Sindhanur Taluk, for non-agricultural residential purposes. Next para. The petitioners contend that the land bearing survey number 802/B, measuring 2 acres 6 guntas and situated Sindhanur town, Raichur district, was owned and possessed by the respondent number 6. Full stop. He got the aforesaid land converted for non-agricultural residential use on 4/12/2002. Full stop. The 6th respondent thereafter formed a layout, sought sanction of a layout of residential sites through his power of attorney, and accordingly a sum of rupees 13,486 was paid as betterment charges to the town planning authority. And a layout plan was approved. Full stop. Approved on 5/2/2007. Full stop. By the, prior to such approval, the respondent number 6 transferred 446.09 meters towards civic amenity and 446.09 meters of land towards garden as per the sanction plan in favor of the state government. Full stop. The respondent number 6 then formed, through his power of attorney, then formed 36 plots and sold it to the petitioners, who in turn sold it inter se amongst who sold it to some of the petitioners, who in turn sold it to others who are also arrayed as petitioners in this writ petition. Full stop. The petitioners contend that after such sales, the khata of the sites were transferred to the respective purchasers. They contend that even though the land in question was converted for non-agricultural residential purposes, however, the revenue entries continued in the name of the respondent number 6. And taking advantage of the same, he started troubling the petitioners. Full stop. A suit in OS number 712/2015 was filed against the respondent number 6 for perpetual injunction. Full stop. Next para. The respondent number 6 thereafter availed agricultural loan of rupees 3 lakhs from Syndicate Bank by mortgaging the land which was already converted for non-agricultural residential purposes by misrepresenting that it was still used for agricultural purposes. He also executed a sale agreement in favor of one Mr. Tirupati and Yankappa on 11/2/2009. the petitioners who came to know of the fraud indulged in by the respondent number 6, confronted him, and he assured the petitioners that he would ensure that the mortgage deed in favor of Syndicate Bank and the sale agreement in favor of Mr. Tirupati and Yankappa would be cancelled shortly. However, the same was not done, which compelled the petitioners 1 and 2 and other purchasers to file PC number 157 bar PCR number 157 bar 2019 and 158 bar 2019 for various offences. The respondent number 6 then conveyed a sale deed, conveyed the property which was owned by the petitioner number 7, which forced him to file OS number 420 of 2019. Likewise, the respondent number 6 had created some unconscionable documents in respect of properties owned by the petitioner number 6 and 3, which compelled them to file OS number 181 of 2019. Full stop. Similarly, petition number 3 has filed OS number 183 of 2019. When things stood thus, the respondent number 6 then moved an application before the respondent number 2 to cancel the order of conversion dated 30/3/2002. The respondent number 2 forwarded the request to the respondent number 4 for verification and report. So the petitioner 3, 6 and 7 filed objections before the respondent number 2 and the respondent number 4, bringing to their notice the developments after the land was converted for non-agricultural purpose. Nonetheless, the respondent number 2, in terms of the impugned order, cancelled the order converting the land for non-agricultural use. Full stop. Being agreed with the said order, the petitioners are before this court. Next para. The learned counsel for the petitioners contended that once the land was converted and an approved plan was sanctioned by the planning authority, and after a layout was formed and sites were sold and appropriate khatas were made out by the municipal authority, the respondent number 2 had no, the respondent number 2 could not have cancelled the order converting the land for non-agricultural purposes. He contends that the respondent number 2 has relied upon a one-sided report submitted by the respondent number 4 that there is no development in the property in question. He contended that the respondent number 6 has executed a relinquishment deed relinquishing certain area towards civic community and park, and therefore the respondent number 2 cannot now hold that there is no development of the land converted, and therefore he could not have withdrawn the order converting the land for non-agricultural use. Besides this, he also contends that the respondent number 2 did not secure any information from the concerned town planning authority or the municipal council, municipal council, as well as the state government before proceeding to cancel the order of conversion. He contends that having regard to the conduct of the respondent number 6, the conduct of the respondent number 6 in trying to litigate the properties after selling them, shows that the respondent number 6 has conspired with the respondent number 4 and 2 in bringing about the impugned order. Full stop. Per contra, ನೀವು objection ಹಾಕಿದ್ರಿ? Objection. Contra, the learned counsel for the respondent number 6 contends that the land in question was converted by a power of attorney and not the respondent number 6. Contends that the respondent number 6 has not executed any power of attorney, and therefore the respondent number 6 was advised to seek cancellation of the order of conversion of the land for non-agricultural purposes. Full stop. He contends that if the petitioners are argued by the order of the respondent number 2, they are bound to file a revision, appropriate revision before the state government under section
49 of the
49. Appropriate
Karnataka
appeal.
Land Revenue Act.
Appropriate appeal before the appropriate authority under section 49 bracket A of the Karnataka Land Revenue Act. Full stop. He therefore contends that the writ petition is not maintainable. Next para. The learned AGA submitted that the impugned order was passed in view of a representation submitted by the respondent number 6, claiming that he had not used the land for the purposes for which it was converted. He submitted that the respondent number 2 has acted on the report of the respondent number 4, as it was reported that no development had taken place in the land after the land was converted for non-agricultural purpose. Full stop. He therefore contends that when the land was not used for the purpose for which it was converted, the respondent number 2 was well within his power to cancel the order of conversion. Next para. Insofar as the first contention of the learned counsel for the respondent number 6, that this writ petition is not maintainable in view of the remedy of an appeal before the competent authority under section 49A of the Karnataka Land Revenue Act, it is to be noticed that a mere existence of an alternate remedy would not be bar for this court to exercise jurisdiction under Article 226 of the Constitution of India. Full stop. As held by the apex court in the case of Chabbil Das versus Income Tax Officer, the abstinence from exercise of power under Article 226 is a self-imposed rule, but is not a straight jacket that has to be applied in all cases. Full stop. When the order impugned lacks the power, the order impugned is one passed without jurisdiction or in absolute violation of law, or if it is passed without following the principles of natural justice, this court would not hesitate to exercise power under Article 226, notwithstanding the existence of an alternate remedy. Full stop. In the instant case, the land in question was converted for non-agricultural use on 30/3/2002. The land was put to use by applying for sanction of a layout plan, and thereafter sites were formed therein and conveyed to various purchasers. Full stop. The respondent number 6 had also relinquished portions of the land in favor of portions of the land reserved for civic amenity sites and open spaces in favor of the state government. The municipal authorities had assessed the properties to tax and had issued appropriate assessment and had opened relevant assessment registers in respect of the properties. Full stop. Therefore, the respondent number 2 would not have unilaterally cancelled the conversion of the land for non-agricultural purposes and thereby put the petitioners at peril. Full stop. It appears that the respondent number 2 has not applied his mind before proceeding to cancel the conversion on the mere say of the petitioner, on the mere say of the respondent number 6, that he had not used the land for the purpose for which it was converted. Full stop. The respondent number 2 was bound to secure information from the concerned town planning authority, this concerned municipal council, as well as the concerned department of the state government before proceeding to cancel the conversion. Full stop. The respondent number 2 also must have been slow while proceeding to pass the impugned order, more particularly when a few of the petitioners had lodged their objections against cancellation of the conversion for non-agricultural purposes. Full stop. Therefore, it is apparent that the respondent number 2 has acted without due application of mind and without following the principles of natural justice, and also in absolute violation of in absolute violation of ಏನ್ ಮಾಡಬೇಕು? Pass the impugned order. Provided. Huh? And has not followed the due process of law in cancelling the conversion of the land in question for non-agricultural purposes. Full stop. In that way of the matter, the impugned order passed by the respondent number 2 deserves to be quashed. So therefore, hence the following order. The writ petition is allowed. The impugned order passed by the respondent number 2, cancelling the order of conversion of the land bearing survey number 812/B of Sindhanur town is quashed. The order of conversion of the aforesaid land dated 30/3/2002 is restored. Yes.
My lord, kindly be taken on next week, man.
ಯಾವುದು 51
Next week, sir.
counsel for the petition seeks time list now date ಕೊಡಿ. Arun Kumar,
Please.
Abdul Muqtadir.
Petitioners are calling in question orders of revenue authorities, that is deputy commissioner and assistant commissioner, whereunder initially assistant commissioner has set aside the mutation effected in favor of petitioners based on my lord succession, that is on account of death of their father. Their father name, my lord, was appearing in the revenue records way back in the year
What
19.
is the land in question? Survey number?
Survey number, my lord, survey number 17 and 12, my lord.
What about 21?
21 is, my lord, another ancestral property which is however not included and not disputed also. May I directly invite lordship's attention.
Let me
These,
understand your.
yes, ma'am. That is the reason. Annexure A is a copy of a family tree. The petitioners and the private respondents and sisters are related by blood because there are annexure A. ma'am. There are 3 persons, 3 sons to the propositors. and petitioners belongs to one branch and private respondent belongs to another branch.
Yes. Now, what does the respondent say? Do they dispute the partition and all the stuff?
They, my lord, having kept quiet all along 50 years, having accepted, now they are disputing. Before that,
How can they,
yes,
how can these revenue authorities
yes, that's what, my lord. All that, my lord, petitioners have did is after their death, the death of their father, they, my lord, based on succession, they submitted an application to mutate their name, for which they have raised an objection. They never dispute, my lord, my grandfather's name appearing in the ROR. My lord, respondent Tahsildar has also conducted inspection. Drawn Panchnama also, my lord. May I request page 13, annexure B. There, both, my lord, the petitioners, including private respondents, are enjoying land to an extent of 12 acre 32 guntas and 10 acre 14 guntas.
Now, please tell us.
Yes.
You are concerned with which survey number?
It is, my lord, only 12 and 17.
ಅದ್ರಲ್ಲಿ bifurcate ಆಗಿದೆಯಲ್ಲ?
ಇಲ್ಲ, bifurcate ಆಗಿ, there are, my lord, Issas para 5 of my writ petition.
Which are the hissas where you are interested?
Yes, my lord. The 17 bar star bar 1, my lord. 12 bar 1 to 4. Survey number 12 and 17 are the subject matter before the deputy commissioner as well as assistant commissioner.
What is there to show that it was transferred to your father's name? ನಿಮ್ಮ ತಂದೆ ಹೆಸರಿಗಿರೋ ಖಾತೆ ಎಲ್ಲಿದೆ?
Yes. They are not disputing it. Anyhow, my lord, I'll find out from the record itself.
Where have you produced it? ಎಲ್ಲಿದೆ ದಾಖಲೆ?
Yes. My lord, page 13 itself.
ಓದಿ.
ಮೇಲ್ಕಾಣಿಸಿದ ವಿಷಯ ಹಾಗೂ ಉಲ್ಲೇಖ ಒಂದರ ಅನ್ವಯ ಸೊ ಸರ್ವೆ ನಂಬರ್ ಸರ್ವೆ ನಂಬರ್ ವಿಸ್ತೀರ್ಣ ಜಮೀನುಗಳ ಕುರಿತು ಈ ಮುಂಚೆ ತಾಯಣ್ಣ ತಂದೆ ಹನುಮಂತ ಇವರ ಹೆಸರಿನಲ್ಲಿ ಪಟ್ಟ ಆಗ ನೋಂದಣಿ ಇದ್ದು, ಸದರಿ ಭೂಮಿಯನ್ನು ಪಟ್ಟೇದಾರನ ಮಕ್ಕಳಾದ ಬ್ಯಾಡ್ರ್ ಸಾಬಣ್ಣ, ತಾಯಣ್ಣ ಈಸ್ ಮೈ ಲಾರ್ಡ್ ಮೈ ಗ್ರ್ಯಾಂಡ್ ಫಾದರ್, ಪಟ್ಟೇದಾರನ ಮಕ್ಕಳಾದ ಬ್ಯಾಡ್ರ್ ಸಾಬಣ್ಣ ತಂದೆ ಬ್ಯಾಡ್ರ್ ತಾಯಣ್ಣ ಹಾಗೂ ನಾಗೇಶ್ ತಂದೆ ತಾಯಣ್ಣ ಇವರುಗಳು ತಮ್ಮ ಹೆಸರಿನಲ್ಲಿ ಪೋತಿ ವಿರಾಸತ್ ಪ್ರಕಾರ ವರ್ಗಾವಣೆ ಮಾಡಿಸಿಕೊಂಡಿರ್ತಾರೆ. ಹಾಗೂ ಸದರಿ ಭೂಮಿಗಳು ಉಲ್ಲೇಖಿತ 3ರ ಅನ್ವಯ ಕಂದಾಯ ನಿರೀಕ್ಷಕರು ಕುರುಡೀರವರು ಸಾಗುವಳಿಯ ಬಗ್ಗೆ ಸ್ಥಾನಿಕ ವಿಚಾರಣೆ ಮಾಡಿ ಈ ಕೆಳಗಿನಂತೆ ವರದಿಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ದೇರ್ ಟ್ಯಾಬ್ಯುಲೇಷನ್ ಇಸ್ ಗಿವನ್.
ಆಯ್ತು, ನೀವೆಲ್ಲಿದ್ದೀರಾ ಇಲ್ಲಿ?
Please, my lord, my name, my lord, is appearing in Sabanna, my lord. Sabanna, Thayana, my lord. The second one.
ಆಯ್ತು.
And my lord, Nagesh.
ಇಷ್ಟೊಂದು ಜನ ಇದಾರಲ್ಲ, ಯಾರು?
Out there, my lord, because
ದೊಡ್ಡ ಸಾಬಣ್ಣ ಸನ್ ಆಫ್ ಹನುಮಂತಪ್ಪ.
Yes.
ಅದ್ಯಾರು?
ದೊಡ್ಡ ಸಾಬಣ್ಣ son of Hanumanthappa is, my lord, person belonging to some other branch, my lord, that is ಏ ವಂಶಾವಳಿ ನೋಡಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ.
Therefore, ಇದನ್ನ ನಿಮ್ದು ಅಂತ ಹೇಳೋದಕ್ಕೆ ಹೆಂಗೆ? How to compute?
There are, my lord, spot inspections were held, Panchnama is drawn.
Revenue inspector.
I'll produce, my lord.
Revenue officers, can they decide whether you are there, they are there, he is there, and they decide?
All that I am not saying they can decide.
If your father's name was found in the
Yes,
revenue records,
yes,
then we'll direct your name to be entered.
yes, ma'am. For a moment, yes, yes, for a moment, my lord. Annexure C, page 15. It is a Tahsildar's order. ಮಾನ್ವಿ ತಾಲೂಕು ಮೇರಿಡ್ ಕುರುಡಿ ಹೋಬಳಿಯ ಸ್ವಯಂಸೋ ವಿಸ್ತೀರ್ಣ 12/1 12 ಎಕರೆ 32 ಗುಂಟೆ ಹಾಗೂ ಸರ್ವೆ ನಂಬರ್ 17 ಜಮೀನಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ವಹಿವಾಟು ಸಂಖ್ಯೆ 10/2020-21 ಪೋತಿ ವಿರಾಸತ್ ಪ್ರಕಾರ ಖಾತೆ ಮಾಡುವ ಬಗ್ಗೆ ಬ್ಯಾಡ್ರ ಸಾಬಣ್ಣ ತಂದೆ ತಾಯಣ್ಣ ಮತ್ತು ನಾಗೇಶ್ ತಂದೆ ತಾಯಣ್ಣ ಇವರು ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಈ ಸಂಬಂಧ ಅರ್ಜಿದಾರರ ಅರ್ಜಿಯನ್ನು ಪರಿಶೀಲಿಸಿ ತಾಲೂಕು ಭೂಮಿ ಕೇಂದ್ರದಲ್ಲಿ ಕರ್ನಾಟಕ ಸ್ವಯಂಸೋ ರನ್ವಯ ತೆಗೆಯಲಾಗಿರುತ್ತೆ ಹಾಗೂ ಗ್ರಾಮದಲ್ಲಿ ಪ್ರಚುರಪಡಿಸಲಾಗಿದೆ. ಆದರೆ ಸದ್ರಿ ಪೋತಿ ದಾಖಲೆ ಮಾಡುವ ತಕರಾರು ಅರ್ಜಿ ದಾಖಲಾಗಿರುತ್ತದೆ ಎಂದು ಕಂದಾಯ ನಿರೀಕ್ಷಕರು ಕೂಡಿರುವರು ಕಡತವನ್ನು ಕಾರ್ಯಾಲಯಕ್ಕೆ ಸಲ್ಲಿಸಿದರು. ಸದ್ರಿ ಪ್ರಕರಣದಲ್ಲಿ ವಿಚಾರಣೆಗೆ ಹಾಜರಾಗಲು ತಿಳಿಸಿ ವಾದಿ ಮತ್ತು ಪ್ರತಿವಾದಿಗಳಿಗೆ ನೋಟಿಸ್ ಮಾಡಲಾಗಿದೆ. ಅದರಂತೆ ಪ್ರಕರಣವನ್ನು ದಿನಾಂಕ ಸ್ವಯಂಸೋ ವಿಚಾರಣೆ ಅರ್ಜಿದಾರರು ಹಾಜರಾಗಿರುತ್ತಾರೆ ಹಾಗೂ ಅವರ ಪರ ವಕೀಲರು ಸ್ವಯಂಸೋ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 12/1 ವಿಸ್ತೀರ್ಣ 12 ಎಕರೆ 32 ಗುಂಟೆ ಮತ್ತು ಸರ್ವೆ ನಂಬರ್ 17 ವಿಸ್ತೀರ್ಣ 10 ಎಕರೆ 14 ಗುಂಟೆ ಜಮೀನುಗಳು ಅರ್ಜಿದಾರರ ತಂದೆಯಾದ ದಟ್ ಈಸ್ ಮೆಲಡ್ ಮೈ ಫಾದರ್ ತಾಯಣ್ಣ ತಂದೆ ಹನುಮಂತ ಇವರ ಹೆಸರಿನಲ್ಲಿ ಪಟ್ಟ ಇರುತ್ತವೆ. ಪಟ್ಟಾದಾರರು ಮರಣ ಹೊಂದಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ನೇರ ವಾರಸುದಾರರ ಮಕ್ಕಳಾದ ಅರ್ಜಿದಾರರ ಹೆಸರಿಗೆ ಪೋತಿ ಖಾತೆ ಮಾಡಲು ಕೋರಿರುತ್ತಾರೆ. ಈ ಬಗ್ಗೆ ತಕರಾರುದಾರರಾದ ಗೋವಿಂದಪ್ಪ ತಂದೆ ರಾಮಣ್ಣ ಇವರು ಹಾಜರಾಗಿರುತ್ತಾರೆ ಹಾಗೂ ತಾವು ಈಗಾಗಲೇ ಸಲ್ಲಿಸಿದ್ದ ತಕರಾರು ಅರ್ಜಿಯನ್ನು ಹಿಂಪಡೆದಿರುತ್ತೇನೆ. ಅರ್ಜಿದಾರರ ಹೆಸರಿಗೆ ವರ್ಗಾವಣೆ ಮಾಡುವ ಬಗ್ಗೆ ತನ್ನದು ಯಾವುದೇ ತಕರಾರು ಇರುವುದಿಲ್ಲ ಎಂದು ಪ್ರಮಾಣ ಪತ್ರ ಸಲ್ಲಿಸಿರುತ್ತದೆ. ಇನ್ನುಳಿದ ತಕರಾರು ಅರ್ಜಿದಾರರಾದ ಸಣ್ಣ ತಾಯಣ್ಣ ತಂದೆ ಆಂಜನೇಯ ಉಲಿಗೆ ದಟ್ ಈಸ್ ಮೈ ಲಾರ್ಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಹಿಯರ್ ಉಲಿಗೆಯ ತಂದೆ ರಂಗಯ್ಯ ರಂಗಪ್ಪ ತಂದೆ ಉಲ್ಗೆಯ ಹನುಮಂತ ತಂದೆ ಈರಣ್ಣ ಸ್ವಯಂಸೋ ನೋಟಿಸಿನ ಅವಧಿಯಲ್ಲಿ ತಕರಾರು ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ ಹಾಗೂ ಪ್ರಕರಣದ ವಿಚಾರಣೆಯ ಸಮಯದಲ್ಲಿ ಕೂಡ ಹಾಜರಾಗಿರುವುದಿಲ್ಲ ಹಾಗೂ ಯಾವುದೇ ದಾಖಲೆ ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಸದ್ರಿ ಭೂಮಿಯನ್ನು ಮೃತ ಪಟ್ಟದಾರರ ನೇರ ವಾರಸುದಾರರಾದ ಬ್ಯಾಡ್ರ ಸಾಬಣ್ಣ ತಂದೆ ಬ್ಯಾಡ್ರ ತಾಯಣ್ಣ ಮತ್ತು ನಾಗೇಶ್ ತಂದೆ ತಾಯಣ್ಣ ಇವರ ಹೆಸರಿಗೆ ಜಂಟಿಯಾಗಿ ವರ್ಗಾವಣೆ ಮಾಡುವುದು ಸೂಕ್ತವೆಂದು ಪರಿಗಣಿಸಿ ಈ ಕೆಳಗಿನಂತೆ ಆದೇಶ ಹೊರಡಿಸಲಾಗಿದೆ. ಮಾನ್ವಿ ತಾಲೂಕು ಕುಡಿ ಹುಬ್ಳಿ ಸ್ವಯಂಸೋ this is an order that is based on
please come to the AC's order page
Yes.
22 page 22
yes please
second paragraph
23 man
page 22 second para
please ಪ್ರಕರಣದ ವಿಚಾರಣೆ ದಿನಾಂಕ ಸ್ವಯಂಸೋ ರವರಿಗೆ ವಿಚಾರಣೆ ನಡೆಸಿ ಅದೇ ದಿನಾಂಕದಂದು ಆದೇಶಕ್ಕೆ ಕಾರಿಸಲಾಯಿತು. ವಾದಿಗಳು ಮತ್ತು ಪ್ರತಿವಾದಿಗಳು ಕಾಸ ಅಣ್ಣ ತಮ್ಮಂದರಾಗಿದ್ದು ಸದರಿ ಸರ್ವೆ ನಂಬರ್ 12 ವಿಸ್ತೀರ್ಣ ಸ್ವಯಂಸೋ ಸರ್ವೆ ನಂಬರ್ ಸ್ವಯಂಸೋ ಗುಂಟೆ ಜಮೀನು ವಾದಿಯು ಮತ್ತು ಪ್ರತಿವಾದಿ 1, 2, 3 ರವರ ತಾತನವರಾದ ತಾಯಣ್ಣ ರಂಗಯ್ಯ ಹನುಮಂತ ಭೀಮಯ್ಯ ಪಿತ್ರಾರ್ಜಿತ ಆಸ್ತಿಯಾಗಿದ್ದು ಮೌಖಿಕವಾಗಿ ವಾದಿಗಳು ಮತ್ತು ಪ್ರತಿವಾದಿಗಳು ಸರಿಸಮಾನವಾಗಿ ಭಾಗವಾಗಿದ್ದರು. ಆದರೆ ವಾದಿಗಳಿಗೆ ತಹಸೀಲ್ದಾರರು ಯಾವುದೇ ನೋಟಿಸ್ ನೀಡದೆ ಏಕಪಕ್ಷೀಯವಾಗಿ ಪ್ರತಿವಾದಿಗಳ ಹೆಸರಿನಲ್ಲಿ ಮುಟೇಶನ್ ಮಾಡಿರುವುದು ಕಾನೂನು ಬಾಹಿರವಾಗಿದೆ. ವಾದಿಗೆ ನೀಡಿದ ತಡೆಯಾಜ್ಞೆ ರದ್ದುಪಡಿಸಿದೆ. ವಾದಿಗಳು ಮತ್ತು ಪ್ರತಿವಾದಿಗಳು RRT ಆದೇಶದ ದೃಢೀಕೃತ ನಕಲು, ತಹಸೀಲ್ದಾರ್ ಪಂಚನಾಮೆ, ಪಹಣಿ ಪತ್ರಿಕೆಗಳು, ವರ್ಗಾವಣೆ ಮುಟೇಶನ್ಗಳು, ವಂಶಾವಳಿ 1954ರ ಪಹಣಿ, ಆಧಾರ್ ಕಾರ್ಡ್, ತಕರಾರು ಅರ್ಜಿ, ಪೌತಿ ವಿರಾಸತ್ ಅರ್ಜಿ, ಮಾನ್ವಿ ತಹಸೀಲ್ದಾರ್ ಸ್ವಯಂಸೋ ಪಂಚನಾಮೆ ವರದಿ, ಕ್ರಯಪತ್ರಗಳು ವಾದಿಗಳು ಮತ್ತು ಪ್ರತಿವಾದಿ 1, 2, 3 ಸಲ್ಲಿಸಿದ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿದ ನಂತರ ವಾದಿಗಳು ಮತ್ತು ಪ್ರತಿವಾದಿ 1, 2, 3 ರಕ್ತ ಸಂಬಂಧಿಕರಾಗಿದ್ದಾರೆ. ಆದರೆ ಸರ್ವೆ ನಂಬರ್ಗಳು ಪಿತ್ರಾರ್ಜಿತ ಆಸ್ತಿಗಳಾಗಿವೆ. ವಾದಿ ಮತ್ತು ಪ್ರತಿವಾದಿಗಳು ಸಮಭಾಗವಾಗಿದ್ದಾರೆ. ಆದರೆ ಕಂದಾಯ ವರದಿಯ ಪ್ರಕಾರ 12 ಸರ್ವೆ ನಂಬರ್ 12 ವಿಸ್ತೀರ್ಣ 12 ಎಕರೆ 32 ಗುಂಟೆ, ಸರ್ವೆ ನಂಬರ್ 17 ವಿಸ್ತೀರ್ಣ 10 ಎಕರೆ 14 ಗುಂಟೆ ಜಮೀನುಗಳು ಸರಿಸಮಾನ ಭಾಗವಾಗಿದ್ದು ಕಂದಾಯ ವರದಿಯಲ್ಲಿ ನಮೂದಿಸಿರುವುದಿಲ್ಲ. ಸರ್ವೆ ನಂಬರ್ 12 ವಿಸ್ತೀರ್ಣ
ಕಂದಾಯ ವರದಿಯಲ್ಲಿ ನಮೂದಿಸಿರುವುದಿಲ್ಲ.
Yes, ma'am.
So how can you ask the revenue authorities
Please.
to decide that there was a partition and all those stuff? ಏನ್
I'm-
ಮಾಡಬೇಕು?
It is, my lord.
It is ಅಲ್ಲ. How can the revenue authorities
I
decide?
never approached my lord stating that there was partition in between my ancestors and therefore my lord.
Please point out.
Yes,
ನಿಮ್ ತಂದೆ ಹೆಸರಿಗೆ
yes,
ಇದೆರಡು ಸರ್ವೆ ನಂಬರ್
ಹೌದು.
ಪಾರ್ಟಿಷನ್ ಮುಖಾಂತರ ಬಂದಿದೆ ಅಂತ ಮ್ಯೂಟೇಶನ್ ಏನಾದ್ರು ಇದೆಯಾ?
64ರಿಂದ ಅವ್ರದ್ದು ಹೆಸರೇ ಬರ್ತಾ ಇದೆ.
ಹೆಸರು ಬರ್ಬೋದ್ರಿ, ಪಾರ್ಟಿಷನ್ ಏನಾಗಿದೆ ಅಂತ ಇದೆಯಾ? Is there any
Yes, ma'am.
mutation
There
proceeding?
is my lord entry to
Produce
that
that.
effect.
There is entry.
Produce
which
some
shows-
document to show
Yes,
that at an undisputed point of time, your father got his name entered after a partition. ಇದ್ದೇ ತೋರ್ಸು.
subject to that, my lord, subject to.
Let us not
Yes.
waste time subject to that. Andre.
Allah,
That is the important, that is the only thing which is important.
please.
Learn counsel for the petitioner is directed to place on record material to establish that the name of the father of the petitioner was entered in the revenue records pursuant to acceptance of mutation. Yes, ಯಾವತ್ ಮಾಡ್ತೀರಿ?
Monday.
List
Next
down
week,
date.
next.
Narendra Reddy.
Land to the extent of 3 guntu was utilized by the government, and they have formed a shed, a bus stand shed in the state highway.
Yes, mister. Who has to answer?
My lord, state government is to answer.
State government?
The respondent number 4 and 6 are the state government.
No, whoever has to answer, you please answer.
Last time, I think direction was given to state government.
Already I have filed the objection.
You ready? Huh?
Time may be.
Yen time, yen objection.
Mandamus.
What objections have you filed? Mandamus for what?
To some endorsement, one endorsement is given, my lord, to quash that endorsement, and mandamus directed to pass award and pay compensation,
Page number
fixed
4.
market value.
Page number 4, para number 9, my lord.
You know,
I have filed the objection.
of the statement.
Already 30 feet wide road is establishing, my lord.
ಏನ್ ಹೇಳ್ತೀರಿ ಓದಿ.
Development.
Please read.
In reply to the para number 8 of the writ petition, it is submitted that Union Ministry of Road Transport and Highway, New Delhi, upgraded the earlier State Highway 51 Baswakalan Raichur and declared it as a National Highway 150, Kalaburagi, Wadi.
ಇದೆಲ್ಲ ಸುಮ್ನೆ unnecessary ಆಗಿ ಹೋಗ್ತಾ ಇರುತ್ತೆ. Please tell us, when will you conduct an inspection survey?
Survey, my lord. Page number
Even
3,
an
para
extra
number 7.
CNC is there, madam. My lord, it has shown that annexure C, my lord, 28, column number 8, man.
ಏನಿದು?
Joint measurement, man.
ಹಾ.
It has been taken, my lord, 3 guntas or.
ಏನಂತ ಇದೆ ಜಾಯಿಂಟ್ ಮೆಷರ್ಮೆಂಟ್?
3 guntas have been taken over.
ಎಲ್ಲಿದೆ?
Serial number 8, man.
What is this Janti Mojani Pramana Patra?
A joint measurement, my lord of all.
Joint measurement, is there a notification?
Yes.
Is the notification?
Notification, my lord.
Annexure A, B, notifications are filed.
ಎಲ್ಲಿ? Annexa?
Annexure B, my lord. 17.
Item number 17.
Yes, Mr. It appears to be acquired for national highways. ಭೂಮಿ ಪಡೆದುಕೊಳ್ಳುತ್ತಿರುವ ಇಲಾಖೆ ರಾಷ್ಟ್ರೀಯ ಹೆದ್ದಾರಿ. ಮರಡಿ.
Sir, I am for the appearing only for the National Highway Authority of
This
India.
property is also acquired for national highway.
National Highway Division is different. State Highway will be along with central government will be managed by the NH 150, my lord.
Is this national highway or state highway?
Earlier it is state highway. They have stated in Raichur to Baswakalan. Baswakalan to Raichur state highway is there. After the notification is issued by the central government, it is
ಯಾವಾಗ,
upgraded.
when it became a national highway? When it was upgraded to a national highway?
As per annexure.
In the year 2018, my lord.
2018,
16th
Yavaga?
August 2018.
16th.
August 2018.
Now you issued a notifications thereafter.
Yes.
ಮತ್ತೆ ನಿಮ್ದು ಬರುತ್ತಲ್ವ
ನಾವು
ರೆಸ್ಪಾನ್ಸ್?
ಬರಲ್ರಿ. ಇದು ಸ್ಟೇಟ್ ಹೈವೇಸ್ ಡಿವಿಷನ್ ಸೆಪರೇಟ್ ಬಾಡಿ ಇದೆ. Or respondent number 4 and 6 are the necessary party, my lord. The award passed by the Assistant Commissioner Yadgir. The State Highway Division iddaga Yadgir Assistant Commissioner will be passed the award.
Even under the National Highways Act, who's the land acquisition officer?
National
Under the National Highways Act, who's the land acquisition officer?
The
Who
land,
performs the role of the,
as per National Highway Authority of India is the separate body, the SLO is separate, my lord.
please tell us,
Yes,
when a property is acquired for a national highway,
yes, ma'am.
who is the authority concerned who performs the role of a land acquisition officer?
If the National Highway Act, the State Highway Division is also acquired under the National Highway Act only. Section 3A, 3D will be applicable to the issue notification, my lord.
Can a state government issue a notification for acquisition under the National Highways Act?
Yes, my lord. This is the
Torsi.
National Highway Division is there.
Source. Please point out how the state government can issue a notification.
Their petition page number, kindly see the page number 32, my lord. Annexure E. Page number 32. The respondent number 6 is issued a letter to the petitioner. 30, page number 30. Annexure G, my lord. G. ವಿಷಯ ರಾಷ್ಟ್ರೀಯ ಹೆದ್ದಾರಿ 150 ಚಿತ್ತಾಪುರದಿಂದ ಯಾದಗಿರಿ ರಸ್ತೆಯ ವಾಡಿ ಗ್ರಾಮದ ಜಮೀನಿನ ಸರ್ವೆ ನಂಬರ್ 49/8 ಅಗಲೀಕರಣ ಮತ್ತು ನಿರ್ಮಾಣಕ್ಕಾಗಿ ಭೂಸ್ವಾಧೀನಪಡಿಸಿಕೊಂಡು ಇದಕ್ಕೆ ಭೂ ಪರಿಹಾರದ ಮೊತ್ತ ಕೊಡುವ ಬಗ್ಗೆ ಉಲ್ಲೇಖ ತಮ್ಮ ಪತ್ರ ದಿನಾಂಕ 24/9/2020 ಮೇಲ್ಕಾಣಿಸಿದ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖಿತ ತಮ್ಮ ಪತ್ರದ ಅನ್ವಯ ಕೋರಿರುವಂತೆ ರಾಷ್ಟ್ರೀಯ ಹೆದ್ದಾರಿ 150 ಚಿತ್ತಾಪುರದಿಂದ ಯಾದಗಿರಿ ರಸ್ತೆಯ ವಾಡಿ ಗ್ರಾಮದ ಜಮೀನಿನ ಸರ್ವೆ ನಂಬರ್ 49/8 ಹೊಂದಿಕೊಂಡಂತೆ ಹಾಲಿ ರಸ್ತೆಯ ಜಾಗದಲ್ಲೇ ರಸ್ತೆಯ ಅಗಲೀಕರಣವನ್ನು ಕೈಗೊಳ್ಳಲಾಗುತ್ತಿದೆ. ಇದನ್ನು ತಮ್ಮ ಮಾಹಿತಿಗೆ ನೀಡಿದೆ. Petitioner issued a letter to the respondent number 6.
First of all, let us understand whether it is by the National Highways or by the state authorities under the National Highways Act.
So state authorities come under this.
ತೋರಿಸ್ರಿ ಹೆಂಗೆ ಅಂತ ಸುಮ್ಮನೆ ನೀವು don't argue like a layman.
My lord, this is the national NH 150 will come under state highway division only. This is the separate body state highways, my lord.
ಎಲ್ಲಿ ತೋರಿಸಿ, please
The
point out.
respondent number 6 is there.
Please point out under the act. How do you say that this comes under the state control?
Lord, section 11 of the National Highway Act
ಓದಿ
1988.
ಆಯ್ತು ಓದಿಪ್ಪ. Please go through that. ಕುಡಿಯೋ ನೀವು ಆಕ್ಟು ತರಲ್ಲ. Control of that portion of the national highways lying within a state. ದಯವಿಟ್ಟು ಓದ್ಕೊಂಬನ್ನಿ ಮರಡಿ, this is not the first time it's happening. You are coming to the court without preparation. I am sorry to say this. Court prepare ಆಗೇ ಬರೋದಿಲ್ಲ ನೀವು.
As per our authorities issued letter memo with the document I have filed.
Forget about you are a lawyer, mister.
Please.
So therefore you should know what is the law. Don't come and tell my authority said this. Please point out how it is justified.
Yes.
See, a stretch of the national highway lying within a particular state, it is the state authorities who will have to maintain it. I can accept it. But when it so far as relates to acquisition, how can you say that the state authority is liable to pay the compensation?
Maintenance, I can understand. Maintenance, I can understand. But acquisition, how do you say that the state authority has to do it? ದಯವಿಟ್ಟು ನೀವು ಓದ್ಬೇಕು ಸಂತೋಷ್ ಮರಡಿ. No, when you're appearing for national highways, you can't come like this. ಯಾವತ್ತು, when will you come ready?
1 ತಾರೀಕು.
Huh?
1 February 1.
List on first.
Matter pertaining the mutation entry. Mutation entry, my lord will be take the in page 27. In earlier, the father name is mutated on 21/19/89.
Page number?
27. Typed copy 26 and 27 is a typed copy.
Yes.
I may be permitted to read that. ಅರ್ಜಿದಾರ ದಿನಾಂಕ 30/11/88 ಆಕ್ಷೇಪಣೆ ನೋಟಿಸ್ ದಿನಾಂಕ 30/11/88 ಅರ್ಜಿದಾರ ಮೌಲಾ ಪಟೇಲ್ ತಂದೆ ಗುಡು ಪಟೇಲ್ ನಿವಾಸಿ ವರ್ಕನಹಳ್ಳಿ ಈತನು ತನ್ನ ಹೆಸರು ವರ್ಕನಹಳ್ಳಿ ಗ್ರಾಮ ಸೀಮಾಂತರ ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ 1 ಎಕರೆ 3 ಗುಂಟೆಯನ್ನು ಭೂಮಿಯನ್ನು ಮೆಹಬೂಬ್ ಪಟೇಲ್ ತಂದೆ ನಬಿ ಪಟೇಲ್ ಈತನಿಗೆ ಪಾಲುಗಾರಿಕೆಯಲ್ಲಿ ಹಂಚಿಕೊಡಲಾಗಿದೆ ಎಂದು ಮತ್ತು ಪಾಲುಗಾರಿಕೆ ಪ್ರಕಾರ ಸರ್ವೆ ನಂಬರ್ 3ರಲ್ಲಿ ತೋರಿಸಿದ ಸರ್ವೆ ನಂಬರ್ 1 ಎಕರೆ 3 ಗುಂಟೆ ಭೂಮಿಯನ್ನು ವರ್ಗಾಯಿಸಬೇಕೆಂದು ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ 30 ದಿವಸ ಆಕ್ಷೇಪಣೆ ನೋಟಿಸ್ ಪ್ರಸ್ತುತಿ ಪಡಿಸಲಾಗಿದೆ. ಸದರಿ ಆಕ್ಷೇಪಣೆಯಲ್ಲಿ ನೋಟಿಸ್ ಮುದ್ದತಿನ ಯಾವುದೇ ತರಹದ ಉಜುರುವಾರಿ ತಕರಾರು ವಗೇರೆ ಬಂದಿರುವುದಿಲ್ಲ. ಕಾರಣ ಅನುಬಂಧ 64ರ ಪ್ರಕಾರ ಪಾಲುಗಾರಿಕೆ ಮೆಹಬೂಬ್ ಪಟೇಲ್ ತಂದೆ ನಬಿ ಪಟೇಲ್ ಹೆಸರಿಗೆ ವರ್ಗಾಯಿಸಲು ಯೋಗ್ಯವಿದೆ. As per partition, that property is fallen to share of my father in the year by effecting mutation entry on 21/8/1918. That will be challenging the annexure A1 by the respondent number before the assistant commissioner. The assistant commissioner, without examining the mutation entry validity, he decided the right of the party as per the unregistered partition. Therefore, the mutation entry in the affected in the year 1989 is a set aside. As against, I filed a revision before the deputy commissioner. Deputy commissioner also confirmed the order passed by the assistant commissioner holding that there is unregistered partition. My respectful submission be that after lapse of 32 years, neither respondent father is challenging the mutation entry in the name of the petitioner father. Moreover, he filed an appeal before the assistant commissioner without any condonation application, without any assigning reason. The assistant commissioner passed the impugned order annexure A1 and A2.
Yes.
That will be required to. And one more important question, I will be take lordship will be annexure RR up entry in page 28, record of right. My father died in the year 2002. After demise of father by virtue of succession, my petition name is affected mutation entry by mutation column number 10 only. Mutation number 2668 of 26/8/2002. That mutation entry will not challenge. Earlier mutation, my father entry will be challenged.
Yes, Mr.
My lord, is based on the unregistered partition deed, the mutation got affected. So, my endeavor before the lordship, my lord.
Go and file a suit. You file a suit. You allowed the entries to continue for so long. You go and file a suit saying that there's no partition.
And it is unregistered, and before 1889, my lord, before the partition came into effect, it was standing in my father's name. So thereafter, my lord, this was partition deed was created document.
Mister, you go and get it, get a civil suit filed. You go and get a civil suit filed. Master, la?
Also, this judgment, my lord.
Good.
A relevant para is at para 4, my lord. Read, my lord.
Hmm.
From the facts
So what
stated,
are the facts?
Lord, this is based on the mutation unregistered document. Mutation cannot be affected and
Yeah, relinquishment deed ಅಂತ ಹೇಳೋದು ಇದು.
it is unregistered, my lord.
Hmm. Civil suit and file ಮಾಡಿದ್ರೆ ನೀವು?
Please,
Have you filed any civil suit?
no, there is no NSC.
It is a graveyard, my lord, and it is used for public purpose. And is alienating the land, my lord.
ಬರ್ಕೊಳ್ಳಿ. Anyway, you go to the civil suit and get a direction. ಬರ್ಕೊಳ್ಳಿ. The petitioner has challenged the revenue entries. Sorry, challenged the order passed by the respondent number 3 in a proceeding under section 136(2). Order passed by the respondent number 2 bearing number so and so dated 28/1/2022 in proceedings under section 136(2), and the order passed by the respondent number 2 bearing number so and so dated so and so in a revision petition filed under 136(3) of the Karnataka Land Revenue Act. Next para. The petitioner is the paternal uncle of the respondent number 4. Full stop. The petitioner claims that there was a partition between him and his 5 brothers on 30/11/1988, in terms of which land bearing survey number 106/A measuring 1 acre 3 guntas was allotted to the share of the petitioner's father. The father of the petitioner took possession of the said 1 acre 3 guntas and initiated proceedings for mutating his name in the revenue records based on the partition. Full stop.
Unregistered.
Full stop. The mutation proceedings were initiated and the notice of the mutation was also published. And as no objections were raised, was received by the revenue inspector, the mutation was accepted and the name of the father of the petitioner was entered in the revenue records. In the year 1980, 89,
Please.
the year 89. His name was entered in the revenue records from then on. Full stop. He later died on 28/5/2002 and the name of the petitioner was entered in the revenue records in T26 dated 26/8/2002. And the revenue records was transferred to the name of the petitioner. Full stop. The petitioner contends that the respondent number 4 challenged the mutation proceedings initiated in the name of his father by filing an appeal under section 136(2) of the Karnataka Land Revenue Act. In the year 2021.
Yes, 21, 22.
In the year 2021. Full stop. The respondent number 3 passed an order dated 28/1/2022, holding that the name of the father of the petitioner was entered in the revenue records based on an unregistered partition, and therefore set aside the mutation as well as the revenue entries in the name of the father of the petitioner. This was challenged by the petitioner in a revision petition under section 136(3), which too was dismissed on the same ground. Being agreed by the said order, the petitioner is before this court. Next paragraph. The learned counsel for the petitioner contends that the respondent number 4 contends that the father of the respondent number 4, who was privy to the partition, did not challenge the revenue records and the mutation from the year 1988-89 till the year 2020-21. He therefore contends that the respondent number 4 would not have any right to now contend that the partition deed was not registered, and therefore the revenue entries based on such unregistered partition have to be reversed. He further contends that the respondent number 3, without even further contends the respondent number 4 did not even file an application for condonation of delay in filing the appeal, and no reasons were mentioned as to why the delay had to be condoned. He submits that the respondent number 3, without even condoning the delay, had entertained the appeal and had set aside the entries that were brought about in the year 1988-89. Full stop. He contends that if the respondent number 4 was interested to reverse the revenue entries on the ground that the partition was not registered, he was bound to go to the civil court and obtain a declaration that he was interested in the property. Full stop. He contends that the respondent number 2 and 3 committed an error in directing the petitioner to approach the civil court. Per contra, the learned counsel for the respondent number 4 submits that the name of the father of the petitioner was entered in the revenue records based on an unregistered partition. Contends that the respondent's number 3 was justified in holding that no such entries can be made based on such unregistered documents. In support of this contention, he relied upon the judgment of a coordinate bench of this court in Guddappa, Fakirappa, Madar, and others versus Deputy Commissioner and others. Full stop. Thus, he contends that the petitioner contends that the impugned order passed by the respondent number 3 and confirmed by the respondent number 2 is just and proper. He also contends that the land in question stood in the name of the father of the respondent number 4
Before 1980.
before the mutation proceedings, and therefore, in the absence of any document to show that the father of the respondent number 4 had conveyed it to the father of the petitioner, the revenue records could not have been brought about. Next, the learned AGA also supported the contention of the learned counsel for the respondent number 4. Next, I have considered the submission of the learned counsel for the petitioner and the learned counsel for the respondent number 4 and the AGA. Next para. The proceedings were initiated by the father of the petitioner to enter his name in respect of land bearing survey number 106/A, measuring 1 acre 3 guntas. Full stop. The total extent of land measuring 1 acre, total extent of land in survey number 106/A was 2 acres 7 guntas. The father of the petitioner claimed that this 1 acre 3 guntas fell to his share at a partition between him and his brothers. Full stop. The notice of the mutation was published. The father of the respondent number 4 did not object to the transfer of the khata based on the partition. The father of the respondent number 4 also did not raise any question and did not challenge the mutation proceedings that was initiated to enter the name of the father of the petitioner in the revenue records from 31/12/1988 till the year 2020-21. When did your father die?
28/5/2002.
The father of the respondent number 4 is stated to have expired on 31/5/2002. Full stop. Therefore, the respondent number 4 could not have challenged the revenue entries on the assertion that there was no partition deed between his father and his brothers and his uncles. Full stop. If the respondent number 4 was interested to protect his protect his title in the property, the appropriate remedy was to approach the civil court and assert his claim over the property. The respondent number 3 could not have entertained an appeal, the two which was belated, and the two without an application for condonation of delay. And he could not have annulled the mutation test of time. Therefore, the impugned order passed by the respondent number 3 and the order passed by the respondent number 2 deserve to be set aside, reserving liberty to the respondent number 4 to approach the civil court and establish his title over the property. It is needless to mention that in the event the respondent number 4 files any suit, the revenue proceedings, the revenue records that stand in the name of the petitioner shall always be subject to the outcome of that suit. Hence the following order. The writ petition is allowed. The impugned orders passed by the respondent number 3, dated so-and-so, bearing number so-and-so, is set aside. Consequently, the order dated so-and-so, bearing number so-and-so, dated so-and-so, passed by respondent number 2 is also set aside. The respondent number 3 is directed to forthwith restore the name of the petitioner in the revenue records. As per T26 slash T26 or 126 or
126.
as per the
26/2002-3.
mutation, as per the inheritance dated 26/8/2002 in Kata number 328. Yes. Within a period of 3 months. ನಿಮ್ಮ ಹೆಸರಲ್ಲಿ ಇದೆಯಾ?
Please.
Stay ಇದೆಯಾ?
ಇಲ್ಲ, no, there is.
Within a period of 3 months.
Grateful.
There is no representation for the petitioner and respondent. List on so-and-so. Arun Kumar. Wash survey and.
Is challenging preparation of form number 10, which is behind the back of petitioner even without issuance of notice on the petitioner. My lord, facts in brief. Originally land bearing survey number 117, totally measuring 2 acre 36 guntas, was belonging to one Siddappa Shirinimelu. Thereafter, his successors got divided among themselves
And my lord, land to an extent of 1 acre is sold to my vendor, that is Bhimanagowda. Bhimayanagowda. May I request my lord, Annexure A is a sale deed. So also my lord, land to an extent of 1 acre 36 guntas is purchased by by the private respondent, that is respondent number, private respondent number 1, my lord. It is not in dispute, my lord. Both first respondent and petitioner is the purchasers from the original owners. In the year 2006 itself, my vendor, my lord, first sale deed is of my vendors. It is at Annexure A. There the boundaries of the land shown as page 16. Page 16, Annexure A is my vendor sale deed, my lord. There towards north, one Guru Shantaya land.
What have you challenged here? What have
My lord, farm number 10.
What have you challenged here in this writ petition?
Annexure E, my lord. Preparation of farm number 10 followed by dismissal of my appeal at Annexure G, my lord.
Lords, I would, there would be an appeal lying against order.
No, you have to go before the concerned authority.
In fact, it is, my lord, in fact, it is without any notice. Very farm number 10 itself cannot be revised or, my lord, reviewed by the very same authority, that is ADLR. Once it is prepared, the aggrieved person shall file an appeal before DDLR. However, the first respondent herein, behind my back, he seems to have made some applications and got prepared this farm number 10, blocking very road, approach road to my land itself.
You don't shout.
No. Sorry. May I take lordship to Annexure A, my lord? Page 60 are the boundaries. This sale deed is of the year 2003, my lord.
Where is the farm number 10 that was given to you earlier?
My lord, Annexure B. In fact, for better understanding, my lord, I place reliance on the documents filed by respondent number 1. It is a sketch. Annexure B is, my lord, previous farm number 10.
Oh, the persons who are claiming they're not the original owners. The persons who are claiming the petitioner and the respondents, they're
Yes.
not the original owners.
No.
That is, they're not legal heirs of Siddhappa Shirini.
No, no, ma'am.
So you have purchased 1 acre and they have purchased 1
1
acre
acre
26.
36 guntas. Yes.
Yes.
Annexure A is, my lord, my vendor sale deed, which is of the year 2003 itself. Ma'am.
Yes.
And my lord, Annexure B is a previous farm number 10.
Yes.
Annexure B1, my lord, is a copy of conversion order.
Yes.
After purchase, my vendor, my lord,
Yes.
has got converted it for non-residential purpose, showing very same boundaries, my lord.
Yes.
And Annexure B2 is, my lord, approved layout plan of my vendor. There also boundaries are maintained as it is. Annexure C is, my lord, my sale deed. My vendors has got Annexure C. Ma'am.
Same boundaries?
Please.
Are the boundaries the same?
Yes, yes, ma'am. Same. And Annexure D is, my lord, sale. Annexure C1 is a khata, my lord, e-khata, issued in favor of petitioner.
Please come to boundaries. How do you say it is same?
Yes. Yes. My lord, my vendors' boundaries are described at page 16, that is Annexure A. And now, if it is compared with page 34, my lord, for towards north, Guru Shantaya Swami Ivaravala, towards south, idu Mallanna Tande Siddhappa Maddi Ivaravala,
ಏನಂತಿದ್ದೆ ಶೀಲ್ಡ್ ಫಸ್ಟ್ ಶೀಲ್ಡ್ ಅಲ್ಲಿ
ಗೌರಮ್ಮ ತಂದೆ ಗಂಡ ಚೆನ್ನಪ್ಪ ಶಿರಣಿ. It is all, my lord, these family members of very ancestors. ಅದು ಏನೋ ಚೇಂಜ್ ಆಗಿರ್ಬೇಕು. But now the dispute is with regard to, my lord, only towards east, my lord. And my lord, ಸಂಗಪ್ಪ ಇದು ಅಲ್ಲಿ ಏನೋ ಚೇಂಜ್ ಆಗಿರ್ಬೇಕು ಸ್ವಾಮಿ.
ಏನೋ ಚೇಂಜ್ ಆಗಿರುತ್ತೆ
ಅಲ್ಲ ಈ ಪಶ್ಚಿಮ ಅಲ್ಲಿ ಸಂಗಪ್ಪ ತಂದೆ ಗೂರಪ್ಪ ಶಿರಣಿ ಅಂತ ಇದೆ, ಇಲ್ಲಿ ಪಂಪಾಪತಿ ಸಂಗಪ್ಪ ಶಿರಣಿ ಅಂತಿದೆ. ಅಂದ್ರೆ ದೇ ಆರ್ ಆಲ್, ಮೈ ಲಾರ್ಡ್, ಸೇಮ್ ನೈಬರಿಂಗ್ ಲ್ಯಾಂಡ್ ಓನರ್ಸ್ ಆರ್ ಆಲ್ ಬಿಲಾಂಗಿಂಗ್ ಟು ಕಾಮನ್ ಫ್ಯಾಮಿಲಿ. ಟುವರ್ಡ್ಸ್, ಮೈ ಲಾರ್ಡ್, ಈಸ್ಟ್ ಶಾಪುರ್ ಅತ್ತಿಗೂಡು ರೋಡ್, ಇಲ್ಲಿ ಸರ್ಕಾರಿ ರೋಡ್ ಅಂತ ಇದೆ ಪೂರ್ವಕ್ಕೆ. ದೇರ್ ಈಸ್ ಓನ್ಲಿ ಒನ್ ಅಪ್ರೋಚ್ ರೋಡ್. And now coming to, my lord, annexure D is a sale deed executed in favor of respondent number 1. There also, my lord, annexure 14, page 49 is boundaries. Bhimaya Gowda Kattimani Urvala, that is my vendor's land is shown towards north. And Dakshina Muhammad, south Muhammad Yusuf Agra Ivaravala, Purva Bidar Bengaluru Rajya Esthare, Paschima Pampapati Tande Sangappa Shirni Varavala. Now, my lord, page 53, my lord, annexure E. This is latest, my lord, farm number 10. After, please.
Please go to the impugned order.
My lord, before that, my lord, may I invite lordship's attention to page 53. How, my lord, this farm number 10 prepared is blocking my road, that is, my lord. Page 53, my lord. The contention of the petitioner is, my lord, there are two subdivisions. One is, my lord, belonging to respondent number 1, and 2, ISA 2 is belonging to petitioner. There they say that this land is in L shape, my lord. As per previous, my lord, farm number 10, this was divided, my lord, equally. And now by preparing farm number 10, my lord, there
ಎಲ್ಲಿದೆ previous one?
My lord, may I request lordship to peruse statement of objection along with the statement of objection R1 has produced. Page 8, my lord, annexure R3. ಮೊದಲಿನಂತಿದೆ first ಅಲ್ಲಿ. This two, my lord, strips are divided equally, and this column shown is, my lord, is a road. ಮೊದಲಿನಂತೆ this one.
How do you say it's a road?
Yes, my lord, it's a road.
How do you say that?
That is, my lord, towards east, that is a road only, my lord, even as per their own case also. And now, my lord, coming to latest one, Iga Durasti Prakara, he makes it, my lord, as L shape.
L shape ಎಲ್ರಿ ಇದೆ road
ಹೌದು.
ಅದು.
ಇಲ್ಲ ಇಲ್ಲಿ ಕಟ್ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ, ಇಲ್ಲಿ ಕಟ್ ಮಾಡಿಬಿಡ್ತಾರೆ. All along, my lord, the vendor of the first respondent never disputed it. Though my vendor has purchased, my lord, way back in the year 2003
There
itself.
is a conversion sketch.
Yes, ma'am.
Conversion sketch.
Yes, yes, my lord, I have not produced it.
You not produced it under what do you want to do?
ಇಲ್ಲ, ಇದೆ sir, ಇದೆ sir. ಅದು by mistake. May I pass on?
Where is their conversion sketch?
ಅವ್ರದ್ದು ಕನ್ವರ್ಟೇ ಆಗಿಲ್ಲ ಅವ್ರದ್ದು.
1 ಎಕರೆ 26 ಗುಂಟೆ ಕನ್ವರ್ಟ್
ಅಲ್ಲ, they obtained conversion order, but it is not approved by town planning.
Where is
So,
the conversion sketch?
You have produced 11E, my lords. 11E ಹಾಕಿದೆ.
11 ಒಂದು conversion sketch, conversion ಮಾಡಿಸ್ಕೊಂಡಿದ್ದೀರಲ್ಲ.
Yes, my lords.
Then there should be sketch ಅಲ್ವಾ?
Yes.
ಹಾ.
Lords, and my friend says that it was there's a change in the map. In 2020, said that it was changed recently and ಹೇಳಿ. That was, I would like to correct that, it was not recently that it was converted and changed agide map and ಹೇಳಿ. It was long back, his vendor itself had given an application. Prior to his purchase itself, his vendor had filed an application. I may take your lordship to that application.
No, but
in
if you
presence
look
of
at
his-
the boundaries.
Boundaries were prepared that another application of his vendor itself, his vendor himself admitted the situation of this lands, my lords, as your lordship sees.
No, boundaries east by road ಅಂತಿದೆಯಲ್ಲ.
That boundary, what they have shown is, my lords, actually it is wrong.
ನಿಮ್ ಸೈಡ್ ಈಸ್ಟ್ ಬೈ ಏನಂತಿದೆ?
East, it is our boundaries road only.
ನಿಮ್ ಸೈಡ್ ರೋಡ್ ಅಂತಿದೆ.
Road ಇದೆ.
ಅವ್ರ ಸೈಡ್ ರೋಡ್ ಅಂತಿದೆ.
Their sale deed also, my lords, is shown as road, but in fact, their land doesn't extend up to the road. It is within the reach of that road, my lords. My lords, for they,
ಅಂತ expand ಆಗಲ್ವಲ್ಲ, like a
ಅಲ್ಲ,
double point.
for they, in the division, my lords, it was a family property, wherein, my lords, both these persons, they belong to Shirani family only. They took 1 acres of the land, my lords, that was situated. They took 1 acre of the land, my lords, that was situated here and there. We took 1 acre 30 guntas, my lord, that was situated in this way. So this is how the situation of the land was.
Therefore, you have to measure the property
Yes, ma'am.
from the road. You make ಹಿಂದೆ ಬಂದ್ರೆ ನೀವು ತಕೊಳ್ಳಿ.
Here, my lords, here in regard to these boundaries are concerned of the person who are existing here lands, it is not in dispute. For he files an application, my lords, it is this petitioner, my lords, he purchased this land in 2011. Then he approaches this honorable court, my lords, in 2024. For long back, my lords, in the year 2006, I may take your lordship to annexure R1, 2006, when his vendor was the owner of this land. His vendor had moved an application for survey of this land. Annexure R1, dated 21/11/2006, my lords. Therein, he files an application to Tahsildar. May I read?
Yes, please.
ಮಾನ್ಯ ತಹಸೀಲ್ದಾರರು ಭೂಮಾನ್ಯ ಶಾಖೆ ಶಾಪೂರ್ ಮಾನ್ಯರೇ ವಿಷಯ ವಿಭೂತಿಹಳ್ಳಿ ಸೀಮಾಂತರದಲ್ಲಿರುವ ಸರ್ವೆ ನಂಬರ್ 117 ಕ್ಷೇತ್ರ 1 ಎಕರೆ ಜಮೀನು ಕೋಡಿ ಮಾಡಿ ಫಾರ್ಮ್ ನಂಬರ್ 10 ತಯಾರಿಸುವ ಕುರಿತು ಮೇಲ್ಕಾಣಿಸಿದ ವಿಷಯ ಪ್ರಕಾರ ನಾನು ಭೀಮನಗೌಡ ತಂದೆ ತಿಮ್ಮಯ್ಯನಗೌಡ ಕಟ್ಟಿಮನಿ ಶಾ ಚಾಪು ತಾಲೂಕು ಶಾಪೂರ್ ಜಿಲ್ಲಾ ಗುಲ್ಬರ್ಗ ಇದ್ದು ಈ ಅರ್ಜಿಯ ಮೂಲಕ ತಮ್ಮಲ್ಲಿ ವಿನಂತಿಸಿಕೊಳ್ಳುವುದೇನೆಂದರೆ ವಿಭೂತಿಹಳ್ಳಿ ಸೀಮಾಂತರದಲ್ಲಿರುವ ಸರ್ವೆ ನಂಬರ್ 117 ಕ್ಷೇತ್ರ 1 ಎಕರೆ ಜಮೀನು ಇದರ ಪಟ್ಟೆದಾರನು ಇರುತ್ತೇನೆ. ಸದರಿ ಆಸ್ತಿಯನ್ನು ತಮ್ಮ ಕಾರ್ಯಾಲಯದ ಮೂಲಕ ಫೋಡಿಯನ್ನು ಮಾಡಿ ಫಾರ್ಮ್ ನಂಬರ್ 10 ತಯಾರಿಸಬೇಕಾಗಿ ಈ ಅರ್ಜಿಯ ಮೂಲಕ ತಮ್ಮಲ್ಲಿ ವಿನಂತಿ. ಕಾರಣ ತಾವುಗಳು ಸದರಿ ಜಮೀನು ಭೂ ಮಾಪನ ಮಾಡಲು ಬೇಕಾದ ಸರ್ಕಾರಿ ವೆಚ್ಚವನ್ನು ತಮ್ಮ ಕಾರ್ಯಾಲಯದಲ್ಲಿ ಸಂದಾಯ ಮಾಡಿ ರಸೀದಿಯನ್ನು ಪಡೆದುಕೊಂಡಿರುತ್ತೇನೆ. ದಿನಾಂಕ 20/11/2006. This is his application. Then based on his application, my lords, R2, that is form number 10 was prepared, annexure R2, my lords, wherein the extent of both the lands were shown. Then coming to annexure R3, my lords, wherein this Hissa 1 and Hissa 2 both were separated. Hissa 1, that is 1 acre, my lords, and Hissa 2, Hissa 1 acre 30 guntas, Hissa 2, my lords, 1 acre it was shown. There again, here also extent of the lands were shown, my lords. There is Bhimanagowda, Gauramma. Gauramma is our vendor, my lords. Bhimanagowda is his vendor. Extent of both the lands were shown. In 2006, it's 767 only itself. wherein his extent of the land was shown on the northern side, my lord.
Total extent ಎಷ್ಟು ಇರೋದು?
1 acre 36 guntas, my lord.
No, no,
No, sorry.
2 acre.
2 acres 36 guntas,
Please come to the podi. Annexure R3 ಗೆ ಬನ್ನಿ.
R3, my lords.
ಲೆಕ್ಕ ಎಷ್ಟಿದೆ? 1 acre 36 guntas
Yes, my lord.
plus 1 acre, 2 acre 36 guntas.
Yes, yes, sorry, 2 acres. 36
Correct alva?
Correct.
If that is the case.
Yes, ma'am.
If according to you, 1 acre is what is sold to
Yes.
him, then his property will have to be measured from the road.
Not from the, my lords. Earlier also his property, no, lords. That's what, whether the property, whether his version of the vendor was from the road or it was from the western side, that would be the question, my lords. To prove that aspect, my lords, I may take your lordship again to annexure R4, wherein it is his statement, my lords, wherein he admitted the survey conducted and situation of the land is there. ಹೇಳಿಕೆ ಪತ್ರ, type copies and next page number 10, my lords. ಶಾಪುರ್ ತಾಲೂಕಿನ ವಿಭೂತಿಹಳ್ಳಿ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 117ರ ಹಿಡುವಳಿದಾರನಾದ ನಾನು ಈ ಮೂಲಕ ತಮ್ಮಲ್ಲಿ ಹೇಳಿ ಬರೆಸಿರುವ ಹೇಳಿಕೆ ಪತ್ರ ಏನೆಂದರೆ, ನಾನು ಸಲ್ಲಿಸಿದ ಸರ್ವೆ ನಂಬರ್ 117ರ ಫೋಡಿ ಅಳತೆ ಅರ್ಜಿ ಅನ್ವಯ ಭೂಮಾಪಕರು ಸ್ಥಳಕ್ಕೆ ಹಾಜರಾದರು. ಸದರಿ ಅಳತೆಯನ್ನು ದಾಖಲೆಗಳ ಸಹಾಯದಿಂದ ಪೂರೈಸಿದರು. ನಾನು ಸರ್ವೆ ನಂಬರ್ 117ರಲ್ಲಿ 1 ಎಕರೆ ಜಮೀನು ಖರೀದಿಸಿದ್ದು ವಿಸ್ತೀರ್ಣವು ತಾಳೆ ಇರುವುದಾಗಿ ತಿಳಿಸಿದರು. ಅದರಂತೆ ಅಳತೆಯ ಪ್ರಕಾರ ಮುಂದಿನ ಕ್ರಮ ಜರುಗಿಸಲು ನನ್ನ ಹಾಗೂ ಲಾಗುದಾರರ ಸಂಪೂರ್ಣ ಒಪ್ಪಿಗೆ ಇರುತ್ತದೆ ಎಂದು ಈ ಹೇಳಿಕೆ ಮೂಲಕ ವ್ಯಕ್ತಪಡಿಸುತ್ತೇನೆ. ಈ ಹೇಳಿಕೆ ಪತ್ರವು ನಿಜವಿರುತ್ತದೆ. Based on his present survey was done.
ಯಾವಾಗ?
2006-7 months. ಅವಾಗೇನೆ ಫಸ್ಟ್ ಫಾರ್ಮ್ ನಂಬರ್ 10 ಪ್ರಿಪೇರ್ ಆಗುತ್ತೆ. When this annexure R3 was being prepared, based on this annexure R2 he files an application. Based on his R1 he files an application. Based on his application, form number 10 was prepared. He himself approached. Then, my lords, form 11E, this annexure R5 is 11E, which is my land.
That is your land.
Yes, my lords. Now, a very important document, my lords, again, to prove the aspect that his land is situated far out from the road. I may take your lordship to annexure R6 is the photographs of the two properties, my lords. Even as on earlier, my lords, and even as on today, my lords, this is his land. This is his land, my lords, wherein all the trees have grown 1 acre. Adjoining to this land, my lords, his land is up till here. My land is in this L shape, even as on today. Now, according to what he told his case, he says his land is extending up to and he is cultivating up till here. Your lordship sees the photographs, my lords. He is not in possession of property.
No, but what I am asking you is, when you're preparing form number 10.
Yes, ma'am.
How do you do it? Is it as per the sale deed or as per actual possession?
Sale deed and the possession of the party.
Possession, it's
Pardon?
only the sale deed.
Pardon, my lords?
It's only the document.
Document, my lords, document and survey would be conducted.
It is only based on the document.
Document extent of the land, yes, ma'am.
If there's any discrepancy in the document and the spot, he has to send the parties back to the civil court.
Yes.
Civil court ಹೋಗಿ ಅಂತ ಹೇಳ್ಬೇಕು ಅವನು.
If there is a dispute, my lord.
If there's a dispute, he has to direct the parties to go to the civil court. Here is a case where 1 acre of property is sold with specific boundaries.
Yes, ma'am.
Eastern boundary is the road.
Yes, ma'am.
Now you say eastern boundary is not the road.
Yes, ma'am.
Correct. Either the survey authority will have to tell you to go to the civil court and establish eastern boundary is not the road, because form number 10 is already issued to him. It is already issued to him. So how do you seek for review of that form number 10?
Oh, sorry.
Only by filing an appeal. When did you file the appeal?
I did not file, my lords. He files an appeal.
Against your form number 10?
Yes.
Against that form number 10, which was prepared by his vendor.
No.
Based on his vendor's applications, form number 10 was prepared. Now he's challenging that.
No.
No, no.
His form number 10 is already prepared.
This is what the form number 10 is, my lord.
ಯಾವುದು? First form number 10 ಇಲ್ರಿ ಇದು ನಿಮ್ದು.
R3,
2006, my lord. that is.
R3.
Huh?
R3. Annexure
No.
R3, my lords.
ನಿಮ್ದು
number
ಇಲ್ರಿ
eight.
form number 10.
Annexure B, my lord, that is.
It was one compact land where it was on his application, but he only goes to the survey authorities, he only asks for division of the land. On his application,
Page 18.
his vendor's application only, it was done. Now he in 2024, he is coming before this court saying that what was done earlier is wrong, which vendor himself did not dispute.
Page?
Oh.
Page number 8, my lords, annexure R3.
ಅಲ್ಲ, page 18, my lord, annexure B.
Now,
ಕೆಚ್ಚಲ್ಲಿದೆ.
ಹೆಚ್ಚಿಲ್ಲ ಸ್ವಾಮಿ ಅದು.
ನೀವು ಅರ್ಧಂಬರ್ಧ ಡಾಕ್ಯುಮೆಂಟ್ ಯಾಕೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀರಾ?
Page 53 is issued, my lord, is page 53, kindly come to my lord. Page 53. This is issued in the year on 7/9, ಅಳತೆ ದಿನಾಂಕ 7/9/2020. ಹದ್ದು ಬಸ್ತು 2021. Page 53.
Mr. When is this page annexure B ಯಾವತ್ತಪ್ಪ?
B, my lord, it is.
B for Bangalore.
Yes,
When was that?
B, my lord, 2006, man.
B for Bangalore, when was that?
Yes, ma'am. 2006-7.
Annex page 53, when was that?
2020, ma'am.
Where is the sketch attached to annexure B? Where is the sketch attached to annexure B?
Sketch ಇಲ್ಲ.
What is this, Arun Kumar? ಫಸ್ಟ್ ಕೋರ್ಟ್ ಬಂದಲ್ಲಿ ಫೈಲ್ ಓಡೋದು ನೀವು?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದೇ.
Annexure B is on sketch prepared in 2006-7. Where is the sketch? You produced only the extract, but where is the sketch? No.
Sorry, my lord, sorry.
ಏನ್ ಈ ತರ ಅಲ್ಲ, ಸಾರಿ ಫಾರ್ whose sake? Learned counsel for the petitioner seeks time to secure form number, the sketch attached to form number 10 prepared in the year 2006-7. List after the same is done. ನೀವು ಅರ್ಧ ಗಂಟೆ ಆದ್ಮೇಲೆ ಸಾರಿ ಅಂದ್ರೆ ಏನು ಉಪಯೋಗ? We wasted judicial time for half an hour. Sajjan Shetty.
Lordship, I am appearing for the respond number 5 to 7. 2 weeks time may be granted, your lordship.
Current counsel for the respondent 5 to 7 seeks time to file objections. List on. Ravi Chavan.
Obliged.
Changan Gowda Biradar. 58. Ravi Chavan.
Yes.
You ready?
Yes.
Are you ready?
Yes, ma'am.
ಎಲ್ಲ ಓದ್ಕೊಂಡ್ ಬಂದಿದ್ದೀರಾ?
Yes, ma'am.
ಹೇಳಿ.
In this petition, petitioner is a society, my lord. He got the land of 6 acres land for education purpose by lease, my lord. Before completion of the lease period, petitioner has filed the representation before the respondent number 1, my lord, for the extension of lease period. Respondent number 4 is filed an objection. Respondent number no way concerned to the society and respondent number 1.
Is already institution building constructed on the property?
No,
Yes, my lord.
Huh?
Only on the office building. Kindly see
Officer and come
page
training
25
center
of
is
the
there.
order, my lord.
Page?
25, Deputy Commissioner order. There is no any development work, man.
25.
Yes, man.
ಓದಿ.
ಪ್ರಸ್ತುತ ಪ್ರಕರಣದ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ವಿಜಯಪುರ
25.
ಎಸ್ ಮ್ಯಾಮ್.
ಇಲ್ಲಿದೆ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್.
ಫಸ್ಟ್ ಪ್ರಸ್ತಾವನೆಯಿಂದ ಚಾಲು.
ಇದು ತಹಸೀಲ್ದಾರ್.
ಇಲ್ಲ ಮತ್ತರ ಜಿಲ್ಲಾ ವಿಜಯಪುರ ಇದೆ.
This petitioner has made several developments in this place, my lord. Digged borewell, my lord.
ಪ್ರಸ್ತುತ
and
ಪ್ರಕರಣ.
ಎಸ್ ಮ್ಯಾಮ್.
ಓದಿ.
ಪ್ರಸ್ತುತ ಪ್ರಕರಣಕ್ಕೆ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ವಿಜಯಪುರ ತಾಲೂಕು ಐನಾಪುರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 74 ಕ್ಷೇತ್ರ 6 ಎಕರೆ ಗುಂಟೆ ಗೈರಾನ್ ಜಮೀನನ್ನು ವಿಜಯಪುರ ಜಿಲ್ಲಾ ಬಂಜಾರ ಶಿಕ್ಷಣ ಸಂಸ್ಥೆಗೆ ಶೈಕ್ಷಣಿಕ ಉದ್ದೇಶಕ್ಕಾಗಿ 30 ವರ್ಷಗಳವರೆಗೆ ಈ ಕಾರ್ಯಾಲಯದ ಆದೇಶ ಸಂಖ್ಯೆ 21-1-92 ಕೆಳಗೆ ಮಂಜೂರಿಸಿ ಲೀಸ್ ಗುತ್ತಿಗೆ ನೀಡಲಾಗಿತ್ತು. ಲೀಸ್ ಅವಧಿ ಮುಕ್ತಾಯವಾಗಿದ್ದರಿಂದ ಪುನಃ 50 ವರ್ಷಗಳ ಅವಧಿಗೆ ಗುತ್ತಿಗೆ ಮುಂದುವರಿಸುವಂತೆ ಅಧ್ಯಕ್ಷರು ಇವರು ಕಾರ್ಯಾಲಯಕ್ಕೆ ದಿನಾಂಕ ಅಂದು ಅರ್ಜಿ ಸಲ್ಲಿಸಿದರು. ಸದರಿ ಅರ್ಜಿಯನ್ನು ತಹಸೀಲ್ದಾರ್ ವಿಜಯಪುರ ಇವರಿಗೆ ಸ್ಪಷ್ಟ ಅಭಿಪ್ರಾಯ ಹಾಗೂ ದಾಖಲಾತಿಯೊಂದಿಗೆ ಉಪ ವಿಭಾಗಾಧಿಕಾರಿಗಳ ಮುಖಾಂತರ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸಲು ಕಳಿಸಲಾಗಿತ್ತು. ಈ ಮಧ್ಯೆ ಮೇಲ್ಮನವಿದಾರ ಶ್ರೀ ರಮೇಶ್ ತಂದೆ ಕಾಮು ರಾಠೋಡ್ LT ಗ್ರಾಮ ಪಂಚಾಯತಿ ಸದಸ್ಯರು ದಿನಾಂಕ 28/6/22ರಂದು ಅರ್ಜಿ ಸಲ್ಲಿಸಿ DBI ಸೊಸೈಟಿಗೆ ಲೀಸ್ ಅವಧಿಯನ್ನು ನವೀಕರಿಸದೆ ರದ್ದುಪಡಿಸಬೇಕೆಂದು ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ವಿಜಯಪುರ ಇವರಿಗೆ ವಿನಂತಿಸಿದ್ದು, ಸದರಿ ಅರ್ಜಿಯನ್ನು ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ತಹಸೀಲ್ದಾರ್ ವಿಜಯಪುರ ಇವರಿಗೆ ಪರಿಶೀಲಿಸಿ ಅಗತ್ಯ ಕ್ರಮ ಕೈಗೊಂಡು ಅರ್ಜಿದಾರರಿಗೆ ಹಿಂಬರಹ ನೀಡುವಂತೆ ದಿನಾಂಕ 6/7/22ರಂದು ಪತ್ರದ ಕೆಳಗೆ ಸೂಚಿಸಿದ್ದು ಇರುತ್ತದೆ. ತಹಸೀಲ್ದಾರ್ ವಿಜಯಪುರ ಅವರು ವಿಚಾರಣೆ ನಡೆಸಿ ತಮ್ಮ ಪತ್ರ ಸಂಖ್ಯೆ ಸೋ ದಿನಾಂಕ 24/8/22ರಂದು ಕೆಳಗೆ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ವಿಜಯಪುರ ಇವರಿಗೆ ವರದಿ ಸಲ್ಲಿಸಿ ಐನಾಪುರ ತಾಂಡ ಗ್ರಾಮಸ್ಥರು ದಿನಾಂಕ 30/6/22ರಂದು ತಮ್ಮ ಕಾರ್ಯಾಲಯಕ್ಕೆ ಮನವಿ ಸಲ್ಲಿಸಿ ಐನಾಪುರ ಗ್ರಾಮದ ಜಮೀನು ಸಂಖ್ಯೆ ಪೈಕಿ ಪಶ್ಚಿಮ ಭಾಗದ 6 ಎಕರೆ ಜಾಗೆಯನ್ನು ಶೈಕ್ಷಣಿಕ ಉದ್ದೇಶಕ್ಕಂತ ಮಂಜೂರಿಸಿದ್ದು, ಆದರೆ DBI ಸೊಸೈಟಿ ಲಂಬಾಣಿ ಮಹಿಳೆಯರ ಕಸೂತಿ ಲಂಬಾಣಿ ಕೇಂದ್ರ ಅಂತ ಬೋರ್ಡ್ ಹಾಕಿಕೊಂಡು ಒಂದು ರೂಮ್ ಹಾಕಿಕೊಂಡು ಯಾವುದೇ ಚಟುವಟಿಕೆಗಳನ್ನು ನಡೆಸಿರುವುದಿಲ್ಲ. ಸದರಿ ಜಾಗೆಯನ್ನು ಲೀಸ್ ಮೇಲೆ ಪಡೆದಿದ್ದು, ಲೀಸ್ ಅವಧಿ ಮುಗಿದಿದ್ದರಿಂದ ಅದನ್ನು ನವೀಕರಿಸಲು ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು ಕಂಡು ಬಂದಿದೆ. ಆದರೆ ಸದರಿ ಜಾಗೆಯನ್ನು ಬಿಟ್ಟರೆ ತಮ್ಮ ಗ್ರಾಮಕ್ಕೆ ಯಾವುದೇ
ಏನ್ ಪರ್ಪಸ್ಗೆ ನಿಮ್ಗೆ ಕೊಟ್ಟಿದ್ದು?
ಎಜುಕೇಶನ್ ಪರ್ಪಸ್
ಏನ್ ಮಾಡಿದಿರಾ?
ಅಲ್ಲಿ ಟ್ರೈನಿಂಗ್ ಸೆಂಟರ್ ಫಾರ್ ವುಮೆನ್.
ಡಾಕ್ಯುಮೆಂಟ್ ಏನ ಹಾಕಿದಿರಾ?
I will produce the photographs, my lord. Documents. And borewell ಹಾಕಿದ್ದಾರೆ, ಆಮೇಲೆ CC road.
ಬೋರ್ವೆಲ್ ಎಲ್ಲ ಇಟ್ಕೊಳ್ಳಿ, ಬೇಡ ಅಂತ ಹೇಳಲ್ಲ. ಬೋರ್ವೆಲ್ ತಗೊಂಡೋಗಿ.
Societies.
But have you used the property for the purpose for which it was given to you?
Yes, my lord.
ಏನ್ ಮಾಡಿದ್ರಿ?
Training center for women, my lord.
ಹ್ಮ್.
ಅಂಡ್ ಎಲ್ಲ ಡೆವಲಪ್ ಮಾಡಿದ್ದಾರೆ. ಅದಕ್ಕಾಗಿ ಲೀಸ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಸಲುವಾಗಿ ರೆಪ್ರೆಸೆಂಟೇಶನ್ ಹಾಕಿದ್ರು. ವಿತೌಟ್ ಕನ್ಸಿಡರ್ ರಿಪ್ರೆಸೆಂಟೇಶನ್.
We'll call it tomorrow. Produce the photographs.
Yes, my lord.
List tomorrow.
Yes, ma'am.
If you don't produce the photographs, then we'll direct the land to be taken over.
Yes, ma'am. Obliged.
Kulkarni Srinath, Annaraya M. Patil. The end quarter is direction to consider. There's no representation for the petitioner. This time on date. Madan Kumar Mitra. Both of you are ready?
I'm ready.
You are ready?
Yes, sir.
Yes.
My lord, already Honorable High Court of Karnataka ಕಾಸ್ಟ್ ಮಾಡಿದ್ರು.
ಫಸ್ಟ್ ಇಂದ ಶುರು ಮಾಡಿ. ನನ್ನ ಹೆಸರು ಇದು, ನಾ ಇದಕ್ಕೋಸ್ಕರ ಬಂದಿದ್ದೀನಿ, ಅಲ್ಲಿಂದ ಶುರು ಮಾಡಿ. Honorable High Court has already cost ಅಂದ್ರೆ. Start from the beginning. What are the facts?
My lord, I am appearing for petitioner. The petitioner prays that my lord, already High Court of Karnataka quashed 1990. My lord, order cost ಮಾಡಿದ my lord. Common order dated 1991 ಇಯರ್ದು ಸರ್ಪಸ್ ಲ್ಯಾಂಡ್ ಇದು. ಆದ್ರೂ ಪೆಂಡಿಂಗ್ ಇದೆ my lord. 6 months, more than 23 years ಆಯ್ತು. Before Land Tribunal Raichur. Without jurisdiction, respondent 2 directed to respondent 3 to enter the Pani of respondent 4 and 5 without no proper foundation. My lord, hence it is just necessary to quash the annexure D and F.
You turn around and ask if any of the lawyers understood what you argued. ಸುಮ್ಮನೆ ತಿರುಗಿಬಿಟ್ಟು ಕೇಳಿ ಯಾರನ್ನಾದ್ರೂ ಅರ್ಥ ಆಯ್ತಾ ಯಾರಿಗಾದ್ರೂ ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದೇನು ಅಂತ. Mister, how do you argue a case? Petitioner is the owner of so-and-so survey number. This was granted to him by the land tribunal. The order of the land tribunal was upheld by the High Court. ಕತೆ ಹಂಗ್ತಾನೆ ಹೇಳು, that is how you argue.
Yes, ma'am.
And what is it you are doing? High Court has quashed, already quashed 1991 revenue entries, therefore just and necessary to pass an order. ಏನ್
Sorry.
ಕನ್ನಡದಲ್ಲಿ ಹೇಳಪ್ಪ, ನಿಂಗೆ ಇಂಗ್ಲೀಷಲ್ಲಿ ಬರ್ದಿದ್ರೆ ಕನ್ನಡದಲ್ಲಿ ಹೇಳು, ಏನು ಅಂತ ಹೇಳು. If you are not conversant with comfortable in English, please argue in Kannada. ಹೇಳಿ.
My lord, Karnataka High Court common order dated.
Please get ready, mister. ಓದ್ಕೊಂಬ ನೀನು ಸರ್.
My lord, please, my lord. I will argue.
ತಿರ್ಗಾ ಕಾಮನ್ ಆರ್ಡರ್ ಇಂದನೇ ಶುರು ಮಾಡ್ತೀವಿ. ಕತೆ ಹೆಂಗ್ ಹೇಳೋದು? How do you narrate, how do you say or you tell a story? ಕತೆ ಹೆಂಗ್ ಹೇಳೋದು? ಕತೆ ಹೆಂಗಪ್ಪ ಹೇಳೋದು? ಇವಾಗ ನೀನು ಒಬ್ರು ಕತೆ ಹೇಳ್ಬೇಕು, ಹೆಂಗ್ ಹೇಳ್ತೀನಿ? ಹೆಂಗ್ ಶುರು ಮಾಡ್ತೀಯ ಹೇಳು, ಒಂದು ಕತೆ ಹೇಳ್ಬೇಕು. Forget the case. I am asking you, suppose you have to tell a story to me. ಒಂದು ಕತೆ ನನ್ಗೆ ಹೇಳ್ಬೇಕು.
Applause, my lord. I will prepare, my lord. Please applause.
ಆಯ್ತಪ್ಪ, ಈ ಕೇಸ್ ಬಿಟ್ಬಿಡು ಮಾರಾಯ. Forget this case. Suppose if I request you to tell me a story. ಒಂದು ಕತೆ, ಒಂದು ಹೇಳಪ್ಪ, ಯಾವ್ದೋ ಒಂದು ಕತೆ ಹೇಳು ಅಂತ ಹೇಳಿದ್ರೆ ಹೆಂಗ್ ಶುರು ಮಾಡ್ತೀಯ?
Starting ಅಂತ ಹೇಳ್ಬೇಕು, my lord.
ಸಾಟರ್ಡೆ ಹೇಳುವಂತ ಮನೆ. ಈಗ suppose if I tell you, ಆಂಜನೇಯ ಶ್ರೀಲಂಕಾಕ್ಕೆ ಹೋದ್ನಂತೆ, ಸೀತಂಗ್ ಕರ್ಕೊಂಬಂದಂತೆ, ಸೀತಾರಾಮ ಚೆನ್ನಾಗಿದ್ರಂತೆ. ಆಂಜನೇಯ ಶ್ರೀಲಂಕಾಕ್ಕೆ ಹೋದ್ನಂತೆ, ಸೀತಾದೇವಿ ಕರ್ಕೊಂಬಂದಂತೆ, ಆಮೇಲೆ ರಾಮ ಸೀತೆ ಚೆನ್ನಾಗಿದ್ರಂತೆ. What did you understood? Did you understand anything? ಈ ಕತೆ ಏನಂಗ ಅರ್ಥ ಆಯ್ತಾ? ಎಲ್ಲಿಂದ ಶುರು ಮಾಡಬೇಕು? ಒಂದು ಊರಲ್ಲಿ ಒಬ್ಬ ರಾಜ ಇದ್ದಂತೆ. ಆ ರಾಜಂಗೆ 3 ಜನ ಹೆಂಡ್ತಿದಿರಿದ್ರಂತೆ. ಮೊದಲನೇ ಹೆಂಡ್ತಿ ಮಗನಿಗೆ ಇವನು, 2ನೇ ಹೆಂಡ್ತಿ ಇವನು, 3ನೇ ಹೆಂಡ್ತಿ, ಹಿಂಗೆ ಕತೆ ಶುರು ಮಾಡೋದು. ನೀನು ಕೇಸು ಹಂಗೆ ಓಪನ್ ಮಾಡಬೇಕು. ಪ್ಲೀಸ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ದಟ್. ದೇರ್ ಶುಡ್ ಬಿ ಎ ಬಿಗಿನಿಂಗ್, ಓಪನಿಂಗ್ ಆಫ್ ದಿ ಕೇಸ್. ಅದು ಹೆಂಗೆ ಕೇಸ್ ಓಪನ್ ಮಾಡಬೇಕು? ಹಿಂಗೆ. My lord, the petitioner is the owner of certain so land. This was granted to him by the land tribunal. The order of the land tribunal was upheld by the High Court. The tribunal has directed the revenue interest to be made in the name of the petitioner. Till today, it is not made. ಏನಪ್ಪ, ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು ಲಾಯರ್ ಆಗಿ?
3 years. 3 years.
3 years. ಮತ್ತೆ ಯೋಚನೆ ಮಾಡು. I leave it to you. ರೆಡಿಯಾಗಿ ಬರಬೇಕು. ಡೋಂಟ್ ಕಮ್ ಟು ದ ಕೋರ್ಟ್ ಜಸ್ಟ್ ಲೈಕ್ ದಟ್. ಫೈಲ್ ತೆಗೆದು ಏನು ಕೇಸು ಹೆಂಗೆ ಹೇಳಬೇಕು, ಹಿಂಗೆ ಹೇಳಕ್ ಬರ್ದಿದ್ರೆ ಮಿರರ್ ಮುಂದೆ ನಿಂತ್ಕೊಂಡು ಒಂದ್ಸತಿ ಅಭ್ಯಾಸ ಮಾಡು. ಎಸ್. ವೆನ್ ಡು ಯು ವಾಂಟ್ ಇಟ್? ಟುಮಾರೋ ಆಗುತ್ತಾ? ಒಂದಿನದಲ್ಲಿ ಮಾಡ್ಬೋದಾ? ಲಿಸ್ಟ್ ಆನ್ ಫಸ್ಟ್ ಸಂಜೀವ್ ಕುಮಾರ್ ಪಾಟೀಲ್.
Lord, the petitioners are, my lord, the owner of the land bearing survey number 107, measuring 3 acre 32 guntas. Lord, they belong to SC community. They have applied for the, my lord, grant of land. The as per the annexure A, my lord, a C form was issued on 10/6/1980. Thereafter, the name of the annexure B series are the record of rights, name of the father of these petitioners, Gundappa, Tukaram and Pundlik, are entered and they are in cultivation of the land.
But ಏನು ನೀವು appeal ಹಾಕೋಬೇಕಲ್ಲ ಇದ್ರ ಮೇಲೆ?
All of a sudden, not without any notice and nothing, what the deputy commissioner is did, they say that it is reserved for the my lord graveyard. Not even my lord, reserved for my lord graveyard. Kindly see the my lord impugned order is at annexure C. ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿದ ಕರ್ನಾಟಕ ಭೂ ಕಾಯ್ದೆ 71 ಅನ್ವಯ ಅಧಿಕಾರ ಚಲಾಯಿಸುತ್ತಾ ಸೋ ನಾನು ಬೀದರ್ ಜಿಲ್ಲೆಯ ತಾಲೂಕು ಸಂತಪುರ ಹೋಬಳಿ ಗೋಟ ಗ್ರಾಮ ಸರ್ಕಾರಿ ಜಮೀನು ಸರ್ವೆ ನಂಬರ್ 107 3 ಎಕರೆ 32 ಗುಂಟೆಯನ್ನು 2 ಗುಂಟೆ ಸಾರ್ವಜನಿಕ ಸ್ಮಶಾನ ಕೆಳಗಂಟೆಗೆ ಷರತ್ತು ಹಾಕಿದೆ.
ಎಲ್ಲಿ ಸಿ ಫಾರ್ಮ್ ಇಲ್ಲಿ ಇಶ್ಯೂ ಮಾಡಿದ್ರೆ ನಿಮಗೆ?
Lord, annexure A is the my lord mutation entry based. A, my lord. I have to copy your lordship, right side, your lordship may kindly see in English also.
Annexure E na?
A, my lord.
A.
Page number. This case pertain to C form issued from the seal of, my lord, it is in the year 10/6/1980. As per that, my lord, mutation.
Government.
Yes, madam. Without giving opportunity, order also passed.
No, whether you just get it verified.
Yes, my lord.
Land AG seeks time to secure instructions. List on ಯಾವತ್ತು ಬೇಕು?
11/2.
Yes. Interim order granted is extended to the next week. Niva chim code.
My lord, I have taken instruction, they will pass order 4/2, it may be taken.
ಯಾವ್ದಲ್ಲಿ?
Next 62, my lord.
Learned counsel for the learned AG seeks time to secure instructions. List on
4/2, my lord.
4/2. Yes. DK Yusuf.
This is the case, I am challenging the.
Money.
My lord.
Huh? Rupa Sagar Patil. Yaru. Who appears for the other side?
Copy served, my lord.
TDS.
Copy served.
Girish
All
is the
respondents.
contest.
Girish Hulmani.
Yes, sir.
Yes, I think it is covered by judgment Allah.
Yes, covered by judgment.
Where is
Even-
the judgment?
Judgment of fact, G and H, your lordship, in the writ petition.
G and?
H.
ಅವರು
Yes, Girish Hulmani. The petitioner has challenged the deduction of 10% TDS, 10% tax, challenge the deduction of 10% tax at source out of the compensation amount payable to him in respect of the acquisition of land bearing survey number. Survey number ಏನು?
Survey number. In respect of MSA number, my lordship, given in the case number decided by the Honorable High Court.
In
Award
respect of
copy filed, Your Honor.
Huh?
Award copy filed by the
Which survey number, mister?
survey number. Because award copy has filed, my lordship.
Survey number ಹೇಳ್ರಿ ಏನೋ ಹೇಳ್ತೀರ
ಹೇಳ್ತೀನಿ sir. ಹೇಳ್ತೀನಿ sir.
land
Sir,
bearing
six,
survey number
six,
so-
three,
so-
639,
Huh?
639,
Ah,
634, 639 bar 2,
639, 634 bar 2 and
639 bar 2, 639 bar 1 and 2, my lordship.
639 bar 1 and 2.
Letter copy is given.
Six 39 bar 1 and 2 and
Yes, 634A, 639 bar 2,
how many survey? 4 survey numbers.
3 survey numbers.
One on the fund.
639 OR, 639 bar 1 and 2 to the extent of 16 acres.
For the purpose of Amarja irrigation project.
Yes, my lordship.
The petitioner contends that the compensation awarded is not a taxable, is not an income taxable in the hands of the petitioner. And such, there is no provision for deduction of tax. In respect of acquisition of, in respect of compensation paid for acquisition of agricultural land. Full stop. The Learned Counsel for the petitioner reiterated the above contentions. The Learned Counsel for the respondent submits that the issue is no longer resting in view of the judgment of the division bench of this court in writ appeal 192 of 2007. Next para.
A recent judgment synapses there one.
Lands in question, the lands in question belonging, the lands belonging to the petitioner were acquired yavaga? Yavagri acquired?
1991 then, sir.
The year 1991.
Yes, sir.
The year 1991. And the compensation was enhanced by this court in MSA 1054 of 2013, 1055 of 2013, and 1056 of 2013.
Yes.
By the order stated 17/9/2021. Full stop. The respondents have deducted, have passed the impugned order enhancing the compensation as per the orders referred supra. That have deducted 10% at source. Full stop. Section 2 bracket 14 bracket small Roman 3 of the Income Tax Act reads as follows. Copy marked. Section 194 LA of the Income Tax Act declares that any compensation paid on acquisition other than agricultural land, 10% of the compensation has to be deducted towards income tax. Full stop. Explanation 1, small Roman 1 to section 194 LA defines that agricultural land includes agricultural land as referred to in clause 14 of section 2. In view of the above, when agricultural land is acquired there is no acquired comma, there is no provision for deducting tax from the compensation amount. Therefore, any deduction from the compensation amount payable towards tax would be illegal and contrary to section 194 LA of the Income Tax Act 1961. Full stop. Therefore, comma, the impugned order deducting 10% TDS from out of the compensation amount payable to the petitioner is set aside. And the petitioner is entitled for refund of the amount deducted by the respondent number
1 and 4, sir.
one and
4 matters.
deduct ಮಾಡೋದು ಯಾರ್ರಿ?
Income SLO, sir.
By the respondent number 1 and 2.
If 4 credit ಮಾಡಿದ್ರೆ sir.
If the amount is already deducted and credited into the account of the respondent number 4, the petitioner is entitled to file appropriate application seeking refund.
ಇಲ್ಲ
Of-
sir, to deposit in the EP, my lordship, pending in the EP number deposit ಮಾಡ್ಬೇಕು ಸುಮ್ಮನೆ ಇದು.
ಯಾರ್ ಡೆಪಾಸಿಟ್? ನೀವು ರೀಫಂಡ್ ಕೇಳ್ಬಿಡಿ.
ಅದೇ refund in the same deposited in the
ರೀಫಂಡ್ ಮಾಡ್ಕೊಳ್ಳಿ. ತಿರ್ಗಾ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಬಂದು ಎಲ್ಲಿ ರೀಫಂಡ್ ಮಾಡ್ತಾರೆ?
ಬರೋದಿಲ್ಲ ಸಮಯ.
If it is already deposited in the TDS this one account, ask for refund.
Refund, we have to take much time, my lordship. That
ಏನಿಲ್ಲ.
deduction is itself is incorrect. Same may be payable to the petitioner, my lordship.
Refund of the tax deducted before the respondent number 4. If any such application is filed, the respondent number 4
One-
shall consider it
Yeah,
and
like-
pass
My lordship, 27,38,043 rupees.
In case if any application is filed, the respondent number 4 shall refund the tax deducted at source to the petitioner within a
27
period of
lakhs.
1 month.
Letter ಪ್ರಕಾರ 27 lakhs, sir.
1 month. Within a period of 1 month. ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ 1 ತಿಂಗಳಲ್ಲಿ ಕೊಡ್ಬೇಕು ಅಂತಿದೆ.
Right, my lordship. Right.
Connected matters, my lord, I will find.
List this petition along with WP number so and so, so and so. ಕೊಡಿ. ರೆಡಿ ಆಗಿದ್ರೆ ಮಾತ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ರಿ ಪ್ಲೀಸ್. ಇಟ್ಸ್ ಎ ರಿಕ್ವೆಸ್ಟ್.
Please,
ಇಟ್ಸ್ ಎ ರಿಕ್ವೆಸ್ಟ್ ಪ್ಲೀಸ್ ರೆಡಿ ಇದ್ರೆ ಮಾತ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ. ಇಲ್ಲ ಟೈಮ್ ತಗೊಂಬಿಡಿ.
ಇಲ್ಲ.
Let us not waste time.
My lord, 66, it may be taken on 11/2, my lord. Sarkari ಅಂತ ಬಂದಿದೆ ಪಾಣಿ.
Current AJ seeks time. List on so and so. Amit Jayant Kumar Bhatti.
This is a matter of deemed conversion, your lordship.
Deemed conversion government.
Yes,
ಯಾವಾಗ ಹೇಳ್ತೀರಾ?
4/2.
Current AJ seeks time. List on. Ganesh Subhash Chandra Kalaburagi.
Name is wrongly printed, but I could not get the file.
Office is directed to show the name of the learned counsel for respondent number 5 as R.S. Siddhapurkar
In 2 weeks
instead
time.
of R.S. Diddapurkar. List on date. Good. K. Ravindra,
There is an interim order operating.
interim order granted is extended to the next date of hearing. K. Ravindra,
My lord, it is survey has done, my lord. I am producing along with memo. Ravindra advocate is not here, my lord. It is prior to survey and demarket, my lord. It
ಮಾಡಿದ್ದೀರಾ?
has done, my lord.
ಇಲ್ಲಿ ರವೀಂದ್ರ
ಅವ್ರು ರಾಯಚೂರಲ್ಲೇ ಇರ್ತಾರ ಅವ್ರು.
ಮತ್ತೆ ಅಲ್ಲೇ ತಗೊಂಡು ಕೊಡ್ಬೇಕಾ ಹೆಂಗೆ? ಬರ್ತಾರ?
ನೋಡೋಣ, my lord.
There is no representation for the petitioner. List on date. Good. Ajay Kumar,
Your lordship, it is yesterday matter.
Yesterday, it has 4/2 date given, my lord. Why?
Huh?
Interim order granted and next date of hearing 4/2, it has date given, my lord.
The petitioner.
In view of the claim of the learned counsel for the present complaints of ಇದೇ 52, 53, 54, 55 ಏನದು?
Your Lordship, petitioner was running a transport business. The government has responded to one issued a notification inviting e-tender for supplying of food grains to the ration shops, Your Lordship.
ಎಸ್ ಎನ್ ನೀವೇ ತಾನೆ? ಏನಿದು ಅರೇಂಜಿಂಗ್ ಏನಂತ ಮಾಡಿದ್ದೀರಾ? ಅರೇಂಜಿಂಗ್ ಸ್ಪೆಲ್ಲಿಂಗ್ ಏನು? ಏನೆಲ್ಲ ನೋಡ್ಬೇಕು ನಾವು. ಅರೇನಿಂಗ್ ಅಂದ್ರೆ ಅಕ್ಯೂಸ್ನ ಅರೇಂಜ್ ಮಾಡೋದು. ಇದು ನೀವು ಅರೇಂಜಿಂಗ್ ಸ್ಪೆಲ್ಲಿಂಗ್ ಮಿಸ್ಟೇಕ್ ನಾನು ಹೇಳ್ತಿರೋದು.
Your Lordship, petitioner was running a transport business. Therefore, the respondent one issued a tender notification for inviting the application for supplying of food grains to the ration shops, Your Lordship, in the Raichur district. He has accordingly, he had applied for the tender notification, and he applied the requisite documents, Your Lordship. As per Annexure G, his technical bidding was rejected by the respondent authorities, Your Lordship. On the ground that he has not having any, only 2 years experience certificate was produced, and also no any case is pending before the Essential Commodities Act, Your Lordship. I produced an Annexure C series with regard to the experience certificate, as well as I produced Annexure F, Your Lordship, with regard to the Deputy Commissioner has given a certificate that there are no cases are pending against the present petition.
What are these conditions that you refer to?
Yes, Your Lordship.
52, 53,
Yes, Your Lordship.
what are those conditions?
Your Lordship, that is page number 24, Your Lordship.
Period of contract shall remain in force as per the agreement with Deputy Commissioner.
Page number 24, Your Lordship.
The
That is, that's
Commissioner,
4.2.
page number 24,
Page number 24. Last paragraph, Your Lordship. With respect to the 4.2. And with respect to the 5, Your Lordship, next page number 25. Last paragraph, that is 5.3, Your Lordship.
Disqualifications.
Disqualification.
The vehicle furnished for transportation of food grains or other commodities under any contract agreement with state government or other agencies should not be quoted for bid under this notification. Lorries hired and owned by bidder or family members should not have any criminal cases. Should not have been booked on the EC Act. Bidders, if blacklisted, debarred from the public shall be should submit the affidavit.
Yes.
Employees of state FCS are not entitled. So 5, ನಿಮ್ಗೆ ಯಾವ್ದು ಅಪ್ಲೈ ಆಗುತ್ತೆ ಇದರಲ್ಲಿ?
Your Lordship, with regard, I produce no condition that has disqualified me from the applying tender, Your Lordship. But in spite of that, the Deputy Commissioner has rejected my application, Your Lordship. I produced an
Disqualification ಅಂತ ಇದೆ.
Yes, Your Lordship.
No, is it rejected on that ground?
3 ವರ್ಷದ ಸಾಗಾಣಿಕೆ ಪ್ರಮಾಣ ಪತ್ರ ಕೊಟ್ಟಿಲ್ಲ.
Your Lordship, at Annexure page number 72, Your Lordship.
ಏನಂತ ಹೇಳಿದೆ? As per tender.
Yes. Receipt.
Tender rejected for following reason.
Yes, Your Lordship.
As per tender clause 5, 2, 3, 4, 5. Affidavits are not enclosed.
So I enclose my documents, Your Lordship. I produce Annexure F, Your Lordship.
ಎಲ್ಲಿದೆ?
At page number 66, Your Lordship.
ಏನಂತ ಇದು?
With regard to the Essential Commodities Act, Your Lordship, I have no cases are pending from.
ಆಯ್ತು, ಓದ್ ಏನ್ ಹೇಳ್ತಿದ್ವಿ? ಇದರ ಅಗಸ್ತ್ಯ ಯಾವುದೇ ಪ್ರಕರಣ ದಾಖಲಾಗಿರುವುದರಿಂದ ಹಾಗೂ ಅವರನ್ನು ಕಪ್ಪು ಪಟ್ಟಿ ಸೇರಿಸಿಲ್ಲ ಎಂಬ ಕೋರುತ್ತಾರೆ. ಸದರಿ ಇವರು ಜಿಲ್ಲಾ ಪೊಲೀಸ್ ವರಿಷ್ಠಾಧಿಕಾರಿ ರಾಜೀವ್ ವಿರುದ್ಧ ಪಡೆದ ಹಾಗೂ ಜಿಲ್ಲಾ ಪೊಲೀಸ್ ವರಿಷ್ಠಾಧಿಕಾರಿ ಪೊಲೀಸ್ ಸದರಿ ವಿರುದ್ಧ ಸಮರ್ಥನೆ ಇಲ್ಲವರಿಗೆ ಯಾವುದೇ ಆಯ್ತು, ಒಂದಾಯ್ತು.
And with regard to the experience certificate, Your Lordship. With regard to the experience certificate, Annexure E, Your Lordship, page number 65. Your Lordship, from 2022 to 2025, I have got an experience certificate as.
ಅದು 3 ವರ್ಷ ಇಲ್ಲಿದೆ.
And up, your lordship, I have produced annexure C, your lordship, C series at page number 54. Since from 2018 to 2019, annexure
ಅವ್ರು
C.
ಏನಂತ ಕೇಳ್ರದ್ರಿ? ಏನಂತ ಕೇಳಿದಾರೆ? ಫಾರ್ ಪ್ರೀವಿಯಸ್ 3 years ಅಂತ
Previous 3 years. I continue, I produce, your lordship.
3 ವರ್ಷದ ಎಲ್ಲಿದೆ ಪ್ರೀವಿಯಸ್ 3 years?
Your lordship, from 2022 to 25, that is the annexure E, your lordship.
22 to 23,
23, 23 to
24, 25. So
23,
23, 24 ಇಲ್ಲ.
Your lordship, that is contract period, your lordship, that is in between column number 3, your lordship. 2022 to 23, 23 to 24, and 24 to 25. And for earlier experience certificate, I produced annexure C series, your lordship, at page number 54.
Yes, what is that you have found? ಏನಂತ ಹೇಳಿ?
My lord, rejection, there are 3 conditions, they have page number
2, 3,
74.
4, 5. 2, 3, 4, 5. Vehicle furnished for transportation of food grains or other commodities under any contract agreement with state government. ಇದು 2 ಗೆ ಅಫಿಡವಿಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
Pardon?
ನಿಮ್ಮ ಗಾಡಿಗಳು
Yes, your.
ಬೇರೆ ನೋಟಿಫಿಕೇಶನ್ ಕವರ್ ಆಗಿಲ್ಲ ಅಂತ ಏನು ಅಫಿಡವಿಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
Yes, your lordship.
ಎಲ್ಲಿದೆ?
With regard to that annexure, I have not produced, your lordship.
ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕಲ್ವ ನೀವು?
But I produce because
5.2 is also the ground on which it is rejected.
page number 72, that
Huh.
is the condition was that the 5.3, your lordship, first condition. As per, that is Vasaraj Pani, your lordship.
ಬಸವರಾಜ
Pani, that is a petitioner herein. At top, your lordship, that the name is Vasaraj Pani. On the ground rejected at third column, your lordship, from bottom. The tender rejected.
ಪಾಣಿ
Huh.
Tender
rejected for the following grounds, your lordship.
ಏನದು?
As per the tender clause 5.3, your lordship, with regard to the Essential Commodities Act.
ಅಲ್ಲ ಇದೆಯದು ಬೇರೆ ಇದೆಯಲ್ಲ ಬಸವ?
ಇಲ್ಲ, that is Farooq Ahmed, that is another person, your lordship.
ಅಲ್ಲ ಫರೂಕ್ ಅಹಮದ್ ಒಂದು
ಅವ್ರ separate, but
Total 4
only-
persons rejection, you know.
as per tender clause 5.3,
Yes, your lord.
bidder shall submit the affidavit and certificate from deputy commissioner
Yes, your lord.
of the district in this regard from districts across the state for previous 3 years whenever he has worked, but bidder not submitted ECA certificate from deputy commissioner of district where he has worked.
Yes, your lord. That
Clause
is
number 4.2, transporter should have minimum of 3 years experience in transportation by 10 ton and above capacity trucks in government departments also. What is this? If he has got the experience, why don't you allow him?
ನಾ already yesterday entry ಮಾಡ್ರೆ as granted.
ಏನಂತ ಆಯ್ತು ಇವಾಗ?
ಈಗ ಏನಿಲ್ಲ ಮೈಲಾಡ್, ಇವತ್ತು ಅದು ಪೋಸ್ಟ್ ಬರ್ದಾಯ್ತು, ಪೋಸ್ಟ್ ಆಗಿದೆ ಅಷ್ಟೇ. 4 to 8 ಕೊಟ್ಟಿತ್ತು ಮೇಲೆ.
ಅಲ್ಲಿ ಲಿಸ್ಟ್ ಆನ್ 28(1) ಅಂತ ಕೊಟ್ಟಿದೆ.
ಇಲ್ಲ, ನಮಗ 4 to ಅಂತ ಅಂದಿದ್ದು.
4 to
four
ಅಂತ
to,
ಇತ್ತು. List on 4.
much of this.
ಪಾಸ್ವರ್ಡ್ ಯಾವ್ದಿದೆ?
My lords, one submission, my lords.
ಹಾ.
My lords, an emergency parallel, I moved an application, my colleague has moved an application, my lord. Tomorrow the marriage is going to be held of the petitioner, my lords. The petitioner brother is in the prison since 4 years, my lords. And I have filed a memo, my lords. It has requested this honorable court to take it.
Parole.
Yes, my lords, parole. my
Parole.
lord. Yes, my lords.
ತಗೊಳ್ಳಿ, ನಾಳೆ ಮದ್ವೆ ಇದೆಯಾ?
ಹೌದು, my lord, ನಾಳೆ ಮದುವೆ ಐತೆ.
ತಗೊಳ್ಳಿ. Yes. ಯಾವ್ದ್ರಿ ಪಾಸ್ವರ್ಡ್? ಯಾವ್ದು ಬೇಕೋ ಕೊಡಿ. ಕೊಡಿ ಯಾವ್ದು.
Court officer, sir. Court officer, sir.
ಅದಕ್ಕೆ ಮಾಡಿದ್ರೆ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕಂಡೀಷನ್ ಎಲ್ಲ ಹೇಳ್ಬೇಕು.
ಮತ್ತೆ ಈಗ ಅನಿವಾರ್ಯ ಇದೆ ಅತಗ
ದೂರ ಮಾಡ್ತದೆ ಸರ್.
ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್.
ಒಂದ್ಸಲ ರಿಪೀಟ್ ಮಾಡ್ತೀನಿ.
ಸರ್ ಸಾಹೇಬ್ರು ತಗೊಳ್ಳಿ ಅಂದ್ರಲ್ಲ, ನಾಳೆ ಬೆಳಿಗ್ಗೆ ತಗೊಂತೀರಾ ಸರ್ ಅದು?
ನಾಳೆಗೆ ಕಳಿಸ್ಬಿಟ್ರಿ ಸರ್ ಅದ್ರ.
ಹ್ಮ್ ಸರಿ ಸರ್, ಓಕೆ.
46 ಇದೆ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕ್ಬಿಡ್ರಿ. 11 ನಂತರ 17 ಸಾರಿ 18 18
ನಮ್ದು
46 20 ಇದು 1 week time.
ನನ್ನ ಟೇಬಲ್ ಅವು ಸೀರಿಯಲ್
ಏನ್ರಿಪ್ಪ ಡೇಟ್ ಸೈನ್ ಆಗಿಲ್ಲಲ್ರಿ ಸಾಹೇಬ್ರ. ಕೊಡ್ರಿ ಇವನ ಕೊಟ್ರಿ.
ಹಾ ಹೇಳಿ. ಹ್ಮ್
FR ಇದೆ ರೀ ಅದ FR ನಂಬರ.
ಮುಂಜಾನೆ 10ಕ್ಕೆ ಹೋಗ್ಬೇಕು.
ಆಯ್ತು ಕೊಟ್ಬಿಡ್ರಿ ಅರ್ಜೆಂಟ್. ಫೋನ್ ಮಾಡಿ ಹೇಳ್ಬಿಡ್ರಿ ಅವ್ರೆ. ಅಲ್ಲ ಫೋನ್ ಮಾಡಿ ಹೇಳ್ಬಿಡ್ರಿ ಅವ್ರು. ಹೇಳ್ಬಿಡ್ರಿ ಸುಮ್ಮನೆ.
ಏನಿಲ್ಲ ತಲೆ ಕೆಡಿಸ್ಕೋಬೇಡ, ಎಲ್ಲ ಅಂತಾರ ಅದು ಕರ್ಕೊಂಡು ಹೋಗ್ತೇವೆ ಹೋಗು.
12 ದಿವಸ
ಹೌದು, ನಂದಿ ಮಲ್ಲಪ್ಪನ ಮನೆಗೆ ಅದ್ರಿಂದ ಏನಾಗಲ್ಲ.
TDS
ಮಾರ್ಕೆಟ್ ಬ್ಯಾಲೆನ್ಸ್ ಇದ್ದಾಗ ಹೋಗಿ ಮಾಡಂತ ಹೇಳು. ರೈಲ್ವೆ ಸ್ಟೇಷನ್ ಬಲ್ಲಿ ರೈಲ್ವೆ ಸ್ಟೇಷನ್ ಬಲ್ಲಿ ಇದ್ದಿದ್ದು ಬ್ಯಾಂಕ್ ತಕ್ಷಣ ಮಾಡಂತ ಹೇಳ್ಬೇಕು. ಹಾ ರೈಲ್ವೆ ಸ್ಟೇಷನ್ ಬಲ್ಲಿ